Results, my lords. He could not appear for the third sem, and he got the year back, my lords. And it was scheduled for
Who is the respondent?
Karnataka State Law University, my lords.
Her standing counselor.
KL Patil, sir.
So, Madhuri.
Please.
230.
ನನ್ನ ಪ್ರಿಮಿಸಸ್ ಅನ್ನ ಲಾಕ್ ಮಾಡಿದ್ದಾರೆ, ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ ಸರ್. ಸಿಟಿ ಮುನ್ಸಿಪಲ್ ಕಾರ್ಪೊರೇಷನ್ ನೆರೆಗಲ್ ಅದಕ್ಕೆ 230. ಸಿಎಂಸಿ ನೆರೆಗಲ್ಸ್
ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್?
ಸ್ಟೇಟ್ ಇದೆ ಸರ್.
ಸಿಎಂಸಿ ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್? ಯಾರಪ್ಪ? ಸಿಎಂಸಿ
ನೆರೆಗಲ್ ಗದಗ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಸರ್.
ಅವ್ರು ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ.
ಪ್ಲೀಸ್.
230.
Adjournment list 1, page 8, 39 to 41, page 9, 42 to 48.
45, my lord. I'm for respondent. Personal inconvenience next week.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ ಪಟಿಷನರ್ಗೆ? ಹಿಂಗೆಲ್ಲ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬೇಕು. ಅಲ್ಲಿದ್ದಾರೆ ಅಲ್ಲ,
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀವಿ.
ಇಲ್ಲೇ ಇರ್ತಾರೆ.
ಇನ್ಫಾರ್ಮ್
ಮಾಡ್ಬೇಕು. ಕನ್ಸೆಂಟ್ ತಗೊಂಡ್ಬೇಕು. Consent. 45 at the request of counsel for respondent number 2, released on 31st January.
Yes. But serial number 47. I appear for petition number 2. But records are required. On the last case, records are directly called for.
Not received despite communication. Communication ಮಾಡಿ ಬಂದಿಲ್ವೋ ಇಲ್ಲ ಮಾಡ್ಬೇಕಾ? ಮಾಡ್ಬೇಕು. Released on 6th February.
Page 10, 49.
My lords, in serial number 51, my lords, in 51.2, I appear for respond number 9, my lords. For Harsha Desai, I'm requesting for a short accommodation, my lords. I've informed the petitioner counsel. The arguing counsel has some inconvenience today. Maybe taken up on 3rd or 10th of February.
So we'll take up the other matters and only adjourn that matter.
They'll have to be heard.
Mr. Shetty?
Yes, expresses some inability.
51 at the request of counsel for respond number 9 in WP number 103383 of 2015, released on 4th January.
Please.
41.1 name is wrongly shown for respond number 3. It is regional commissioner.
AGFR 1 to 4 antide. 51.1 registry is directed to delete the name of Shri Jagdish Patil as that appearing for respond number 3.
My lord, serial number 58, my lord. Jagdish Patil sir is there.
58 has not been called, Mr. Shetty.
Please, my lord, please.
Serial number 49.
49.
Appearing for respondent number 4. For short adjournment to file the objection.
Inform madidira?
Determine only.
49. Learned counsel for respond number 3 seeks for and is granted 10 days time finally to file a statement of objection. If objections are not filed by 3rd February, it will be taken as not filed and matter proceeded with. Released on 6th February.
Page 11, 52 to 55.
Serial number 54. We have the respond number 3. Next
number?
Respond number 3. Senior personal inconvenience.
Inform madidira?
Madidenu.
Anil Kale.
54 at the request of counsel for respond number 3, released on 6th February.
Please.
Page 12, 56 to 59.
My lord, the serial number 58, my lord.
Yes.
I have some personal inconvenience, my lord. I will intimate Jagdish Patil sir, my lord. Tuesday, my lord.
At the request of counsel for respondent, released on 28th January.
Please, my lord. Oblige, my lord.
Page 13, 60 to 64.
63, your lordships. No, it's a proxy submission on behalf of the council appearing for respond number 1A and 1B. But since he is not keeping well, my lords, I have been asked to seek for a short accommodation. It may be taken up on Monday, my lords. He'll be prepared.
So all of you are appearing for the petitioner or?
I'm for petitioner, my lord.
Anand Ashtekar antide illuna?
My lords, I am actually on behalf of the. Adu actually, when I was attached to Shilvan sir's office, I had filed wakala there.
ನಿಮ್ಮ ಹೆಸರು ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕಾ ಇಲ್ಲಿ?
ಇಲ್ಲ, my lords, it can continue, my lords, not an issue.
You are making the request on behalf of?
Prashant F. Gaudar, my lords.
Petitioner, my lord. There's a interim,
But I had-
yes.
I had intimated they have
Yeah,
consented.
the request
There's
of
an interim
counsel
order
for
it
respondent
kind
number
of-
1A and 1B, relist on
Monday, my lords.
27th, interim order earlier
But
granted
kindly,
is extended.
28, my lord. Senior is not available on 27th.
28,
Yes.
28, interim order earlier granted is extended till next date.
Grateful, my lords.
14, 65 to 68. Page 15, 69 to 75. Page 16, 76 to 80.
Mother 76 for this one and Mother 4 to 7. Next week, any date, Mother. I have informed the other side also, Mother.
76 at the request of counsel for respondent number 4 to 7, relist on 31st. It is made clear that no further adjournment would be granted.
Page 17, 81 to 87.
That's 84, my lords. I'm filing memo for withdrawal.
Petitioner is before this court seeking for the following relief. A memo dated 23/1/2025 has been filed, signed by the petitioner and the counsel for the petitioner, which reads as under. Accepting the said memo and the submission of counsel for the petitioner, petition is dismissed as withdrawn.
Page 18, 88 to 93.
Serial number 88, my lord. I am for the petitioner. Yesterday, my lord, the respondents have filed statement of objections. I need to file my rejoinder opinion, my lord. 10 days accommodation. I already informed the
Secretary Gram Panchayat Shendur.
V. Shivraj Hiremat.
88. Shri V. Shivraj Hiremat is directed to accept notice for respondent number 4. He is also directed to file the affidavit of respondent number 4 as to why, despite service of notice, there has been no appearance made by respondent number 4 in the present matter. At the request of counsel for the petitioner, relist on
10 days.
Relist on 6th February.
Please.
Page 19, 94 to 98. Page 20, 99 to 104. Page 21, 105 to 110.
The further hearing at 2:30 ಆಗ್ಬೇಕು. ಎಲ್ಲ further hearing ಎಲ್ಲ 2:30 ಬರಬೇಕು.
List 1, orders 1, BV Somapur.
The responding counsel has filed a memo reporting death of respondent number 1 and 2. I have to get the information regarding LRs of respondent number 1 and 2.
The respondent number 2 is the only alarm lord of respondent number 1. I have stated in my memo, my lord. I have.
ಇವಾಗ ಯಾರು ಎಕ್ಸ್ಪೈರ್ ಆಗಿದೆ? 1 ಬರೀ
one expired, my lord.
1.
ಇಲ್ಲಿ 1 and 2 ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಇಲ್ಲ, 1 expired, my lord. 2 is the daughter, my lord. He is the only LR.
The counsel for respondent 1 and 2 has filed a memo dated 21/2025 stating that the respondent number 1 has expired and his only surviving legal representative is respondent number 2, his daughter. The memo is accepted. Respondent number 2 is treated as the legal representative of respondent number 1. Counsel for the petitioner to make necessary endorsement in the cause list.
Please. I'll make necessary endorsement in the case.
ಆಯ್ತು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಯಾವಾಗ?
Monday, minutes.
Relist on 27th.
Please.
2, MB Hiremat.
The memo is filed.
Is before this court seeking for the following reliefs. A memo dated
21/1.
One more. Memo dated 21/1/2025 has been filed, signed by the petitioner and the counsel for the petitioner, which reads as under. Accepting the memo and the submission of counsel for the petitioner, petition is dismissed as withdrawn.
R3, I accept notice, sir. State.
Learned AG accepts notice for respondent number 3. Almelbar.
3, Santosh Rao.
Notice issued to respondent number 8 has been written with the endorsement refused. And service in respect of respondent number 8 is held sufficient. Registry is directed in the name of respondent number 8 with the endorsement refused.
Held sufficient, my lordship.
ಯಾವಾಗ?
Respond number 8. Please.
When will you get ready to argue?
Kindly next week, my lordship.
ನೀವೇ ಮಾಡಬೇಕು. At the request of counsel for the petitioner, relist on 31st.
4, Umesh Enapur.
Comply the honorable court order, man. On 15th, I have paid the amount.
Order dated 18/12/20.
ಕೌಂಟರ್ನಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
In 1812 ಏನ್ ಕಂಪ್ಲೈನ್ಸ್?
2000 rupees ಅವ್ರಿಗೆ ಪೇಡ್ ಮಾಡಿದ್ದೆ.
Learned counsel for the petitioner submit that the cost has been paid.
Please pay.
If submission is accepted, registry is directed to verify. Yes.
Lord, it will be issue notice to the respond number 2, my lord. The ICICI Lombard Insurance Company is there.
Yaar standing counsel yaar?
MK Saudagar.
Shri?
MK Saudagar.
MK Saudagar.
Please.
Is directed to accept notice for respond number 2, counsel
Please.
for the petitioner to furnish 2 sets of the petition
Obliged.
along with annexure on the said counsel, released on 12th February.
Obliged.
5 case party.
Appeal for the petitioner. Government was directed to secure instructions regarding why after remand since 1978, it is still pending.
Next week, Your Lordship. It may take a next week, Your Lordship. I'm not getting the file. I'm not getting the file, Your Lordship.
Not getting the allu file sikkilla avarge adikke. And AGS seeks fund is granted 1 week's time to comply with the order dated 10/1/2025, released on 31st.
6 Srivatsa Hegde.
Week's time may be given.
What all mood week's time andre?
My lord, I was about to comply, my lord.
Counsel for the petition seeks fund is granted 1 week's time finally to comply with the office objection. If the office objection is not complied by 31st January, petition would be liable to be dismissed for non-prosecution, released on 6th February.
Please.
7 Bahubali Kanvargi.
None appears, 1 week's time, same order.
8 SM Kalwad.
During course of day, my lords, I will comply the office objection, my lords. Kindly pass over, my lords.
Pass over.
Please.
9 DLR Khan.
Lord, against the rejection of an application under order 1 rule 10, subsequent purchaser during the pendency of a suit was impleaded. An application came to be filed and the learned civil judge holds that principles of lease pendency will apply. Hence, he is not a necessary party to the proceedings. I am a defendant in the case wherein a suit was filed by the plaintiff. He filed an application to withdraw the suit. There, that application came to be opposed by me, and the transposition application came to be filed by the defendant in a suit for partition. That was observed that the defendants are also having a right to prosecute the suit.
No need to transpose.
As such, I filed an application to implead those persons who have purchased the property from the defendant number 4.
New Year again, Mr. Beturmat.
So I'm appealing for the proposed response.
You are going to be bound by this.
Contention is that my suit properties are not ancestral property. And those properties.
You want to contest or you will be bound by this. Then later you can't take this contention in FDP. That is what we will be observing. Or kardidar nimge. Kardilla andre bere. Now you are put on notice of the.
I will join.
Petitioner is before this court seeking for the new proposed respondent.
Oh, the proposed respondent. For other respondents, notice is not required. My lord, I will file this. See.
At the request of the counsel for the petitioner, notice to respond number 1 to 4 is dispensed with, since the application which had been filed was one for impleading respond number 5, and it is only respond number 5 who is the contesting respondent and is represented by counsel in the present matter. The petitioner is before this court seeking for the following reliefs. A suit in OS number 13 of 2016 had been filed for partition and separate possession, in which the petitioner was defendant number 4. In the said suit, the petitioner filed an application in IA number 21 of 24 under order 1 rule 10(2) of the Code of Civil Procedure read with section 151 of the Code of Civil Procedure to implead respond number 5 herein on the ground that respondent number 5 is a subsequent purchaser during the pendency of the suit for partition. The said application came to be rejected by the trial court on the ground that the principle of lis pendens would apply, and respondent number 5.
There are two applications, my lord. There are two applications. One
ಒಂದೇ
order
ಕೇಳಿರೋದು.
21 ಒಂದಿದೆ, ಇನ್ನೊಂದು 24 ಇದೆ.
ಇದರಲ್ಲಿ ಬರೀ 21 ಇದೆ.
Page number 64, my lords, and page number 71. There are two orders.
Page number 64 and
Page number 64, order on IA number 21, my lords. Page number 71, order on IA number 24. That is herein also IA under order 1 rule 10 came to be rejected, my lord.
Allah, that is with respect to other persons, my lord. An application came to be filed to implead them. Not
you,
this.
You're not challenged 24.
Illa, idralli.
You're challenged only 21 here.
Please, my lord. 21.
Came to be rejected on the ground that the principle of lis pendens would apply. And if the suit were to be decreed in favor of the plaintiff, or if the counterclaim were to be allowed, same would also be binding on the proposed defendant. Shri D.L. Ladkan, learned counsel for the petitioner. It is challenging said order that the petitioner is before this court. Shri D.L. Ladkan, learned counsel for the petitioner, would submit that even though the principles of lis pendens may apply, in the final decree proceedings, if the purchaser is not made, a party to the suit in the final decree proceedings, there could be difficulties which could arise in the enforcement of the preliminary decree. Respondent number 5, I mean, put to notice as regards the pendency of the suit for partition would be bound by any decree that is passed in the aforesaid suit. As I am of the considered opinion that if the purchaser is not bought on record, the purchaser would be deprived of any opportunity to place his defense on record. Dior's section 52 of the TP Act. Since any such defense could not be raised in the final decree proceedings if the purchaser is not made a party to the suit. In that view of the matter, I pass the following order. Writ petition is allowed. A certiorari is issued. Certiorari and ಕೇಳ್ತಿರಾರೆ ಯಾವ್ದು ನಾವು mistake ಮಾಡಿ.
ಇಲ್ಲ.
Writ petition is allowed.
Order is
the order dated 1/8/24 passed on IA number 21 of 24 filed in OS number 13 of 2016 by the senior civil judge Ungun is set aside. Consequently, IA number 21 of 24 filed in order 1 rule 10(2) is allowed. The person named therein is brought on record as defendant number
7
agatte Swami subsequent.
on submission, my lords. Here what happened in this case, my lords? By virtue of IA number 24, my lords, you want to implement respondent number 5 to 8. 5 and 6 are my vendors, my lords. If they are not made as a party, my lords.
5 and 6 are the purchasers from the family members.
No. 5 and 6 are the sons of defendant number
family
1.
members.
Family members. They are the the acquired property of defendant number 5 and 6, my lords.
A challenge madilva ನೀವು?
That was not challenged.
That is with respect to other aspect, my lord. As far as
their vendors are not made party.
Allah, they are there, my lord. They are there already. They are on record.
Where is the sale deed?
Allah.
Sale deed.
Sale deed is not been produced by the either the plaintiff or the
sale deed.
ಇಲ್ಲ ಅವ್ರ ಹತ್ರನೂ ಇಲ್ಲ.
ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಯಾರು.
ಇಲ್ಲ.
They are saying, my lordship, my page number 74, my lords. Last 5 line from the bottom, my lords. Hence, the question of deciding the proposed defendant 5 to 8 are necessary parties to the suit does not arise at all. The learned counsel defendant 4 has filed a similar application. Again, thus protect the proceedings. Wherein, my lords, 5 and 6 are my vendors, my lords.
Page 74.
It's very much contention, my lords.
Para 6 ಅಲ್ಲಿ ಇದೆ ಅಲ್ಲ, Mr. Ladkan, page 72. Standing in the name of defendant number 5 and 6 was son of defendant number 1.
That counterclaim in 5 and 6 are joint family properties and purchased by investing huge. There is a appearance of the name of 5 and 6.
5 and 6 are not brought on record.
ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅವರು. ದೇ ಆರ್ ಪಾರ್ಟೀಸ್ ಇನ್ ದ ಕೌಂಟರ್ ಕ್ಲೇಮ್.
They are not parties.
Parties to the suit, my lord.
ನಿಮ್ಮ application in IA 24 is dismissed. So if their vendors are not brought on record, how can they be brought on record?
ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ there is some mistake, my lord.
Verify ಮಾಡ್ಕೊಳ್ಳಿ. ಅದು ಬೇಡ. At the request of counsel for the petitioner, relist on 31st.
ಅಲ್ಲ, let there be some interim order. Now the case.
If they are not on record, we'll be dismissing your petition.
Automatically, I am not entitled for any relief as far as the main relief is concerned. May I seek
Main
for-
relief ಅಲ್ಲ, petition dismiss ಆಗುತ್ತೆ.
ಅಲ್ಲ, ಅಲ್ಲಿ ತನಕ now the case is posted for arguments ಅಂತ post ಆಗಿದೆ.
ಚೆಕ್ ಮಾಡಿ ಇವಾಗ ಮಧ್ಯಾಹ್ನ ಹೇಳ್ತೀರಾ, ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ.
ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ಹೇಳ್ತೀನಿ ಪ್ಲೀಸ್.
ಬೇಡ ಪಾಸ್ ಓವರ್. ಇವಾಗ ಅಲ್ಲ ಇರ್ಲಿ ಅದು.
10 Vadiraj.
R2 to R4.
In this case, I undertake to file wakalat to R2 to R3.
So undertakes to file wakalatnama for respond number 2 to 4. Registry is directed to print his name as that appearing for respond number 2 to 4.
I request for a week's time.
Today they have served copy in respect to R1. At the request of counsels for the respondents, relist on 31st.
Please.
Please.
11 Raviraj C. Patil.
Lordship, I have given submissions for the office objections. One is first page of the order sheet, Lordship, at annexure A, and manuscript in the order sheet. I'm not relying on the manuscript and first page of the annexure A, Lordship.
Learned counsel for the petitioner submits that he would not be relying on the first page of the order sheet at annexure A. In that view of the matter, office objection at serial number 43-2 is overruled. His further submission is that he would not also be relying on the manuscript portion of annexure A. As such, office objection at serial number 43-3 is also overruled. Yes.
Lordship, I am aggrieved by the rejection of my IA for production of documents when my evidence is still pending. I filed an IA seeking production of 3 documents, wherein I have taken a contention. This is a suit for specific performance filed by initiated by the respondent against the petitioner herein. So I have taken a claim, I have taken a stand that we have known each other for a long time, and he had my signed documents, which is now being utilized as an agreement of sale. I have sought to produce that document to show that he was in my acquaintance and I had known him. And that I came to be rejected even when my evidence is still pending.
You haven't started the evidence or?
Evidence has commenced, Your Lordship.
Is the
Impugned order is at page number 17. It is a part of the annexure A order sheet in the trial court, Your Lordship. Order on IA number 18, page number 17.
There is no pleading as regards this.
Your Lordship, may I take Your Lordship's kind attention at page 39, Your Lordship. Paragraph number 8 at page number 39 in specific.
What have you said about the pleading? What is the use of evidence?
My submission is when I have taken a stand that these documents were misutilized by the respondent herein. If those documents are brought on record, Your Lordship, then I would be able
to have pleadings on that. You can't do it without it.
Then I request indulgence of this honorable court on the sole ground that
Can't give you that indulgence. If there's no pleading, what is the point in doing it? It'll be a empty formality. I mean, it has to be, these documents cannot be looked into. There's no use.
Please.
You know what you have to do, you do that.
I'll-
Petitioner is before this court seeking for the following reliefs. Notice to the respondent is dispensed with in view of the proposed order to be passed. A suit in OS number 57 of 2019 had been filed by respondent number 2 herein, seeking for specific performance. Of an agreement of sale dated date in prayer illa. Dated 19/2/2016. In the said suit, after the plaintiff led evidence when matter was posted, when in the said suit, after the plaintiff having led evidence, when the matter was posted for defendant evidence, the petitioner, who is defendant number 1 therein, filed an application order 8 rule 1 capital A read with section 151 of the CPC to produce 3 documents. The said application being opposed, the application came to be rejected, while the impugned order dated 13/11/2024. It is challenging the said order that the petitioner is before this court. The submission of learned counsel for the petitioner is that those documents are required to establish the relationship between the petitioner and the plaintiff, respondent number 2. And if those documents are not permitted to be produced, injustice would be caused to the petitioner. The trial court, while the impugned order, has dismissed the application on the ground that there are no pleadings as regard the said documents. And without there being pleading, the documents cannot be looked into, and as such, no purpose would be served by permitting the petitioner to produce the said documents. I am in agreement with the order passed by the trial court inasmuch as without pleading, no evidence can be looked into, and no evidence led, and any evidence led without pleading cannot be considered by the court. In that view of the matter, having perused the written statement, there being no pleading in respect of the documents that are sought to be produced, the trial court has rightly rejected the application. No grounds being made out, the petition stands dismissed.
12, Mallikarjun Swamy.
Here for petitioner, my lords. Lords, office objection at serial number 7 is with regard to court fees, my lords, which was made good on 21/2025.
Court fee.
We have paid the court fees.
And counsel for the petitioner submit that the court fee has been paid. Registry to verify.
My lord, it is in connection with the collection of taxes. They seek the
Education.
exemption. They seek the exemption as it is the educational institution. But the problem is that if they are collecting the amount towards the services of electricity, water supply and other things, then it is to be exempted. If they are collecting the rent, then that is to be chargeable for the tax.
Is he an hostel guy, though?
Already, I have asked.
Educational institution being.
Educational
What is the premises? What is the premises being used?
There are several properties, my lord.
We are running all the colleges, degree colleges, PUC. And
That is to be verified.
You are running everything fine, but the concerned buildings are being used for what purpose?
for only educational purpose, nothing beyond that.
My lord, hostels are there. The building is used for the bank and also the quarter staffs have been given. So my
Adhik,
submission is that.
Adhik separate raise ಮಾಡಿ. Not for everything. Bank rent ಕೊಟ್ಟಿದಾರಾ, petrol bunk ಇದೆಯಾ, hostel ಇದೆಯಾ, ಅದು we have already dealt with in early judgment ಅದು.
Lords, Annexure C is the judgment.
My lord, there are several properties. There are several properties. So I have to verify. 2 days time may be granted. I shall get.
We will reserve liberty to you, Mr. Kulkarni.
Please.
We'll quash this.
Yes.
We'll reserve liberty to you to raise a demand on properties which are used for non-educational purposes. That they will be bound to.
Please, my lord, please. With that observation, it may be disproved.
The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that demand has been raised by the second respondent, Town Municipal Council, Nippani, for payment of property tax in respect of the buildings buildings belonging to the petitioner, even though they have been used exclusively for education purposes. The submission of Sri R.K. Kulkarni, Learned Counsel for respond number 2, however, is that several of the properties are not used exclusively for education purposes, but have been rented out for the bank, used for the hostel, used for the purpose of hostel where rentals are charged, etc. Even if the submission of Sri R.K. Kulkarni is accepted, the Town Municipal Council cannot raise a demand on the entire properties, which are some of which are exclusively used for education purposes. As held by this court in its order dated 23rd May 2023 in WP number 87922 of 2012, an educational institution who uses a property and/or premises exclusively for education purposes is not liable to make payment of property tax in view of section 94 bracket 1 hyphen capital A bracket small Roman 1 of Municipalities Act. Nimdu?
Please, Milords, Municipalities
Karnataka
Act.
Municipalities Act 1964. In that view of the matter, an omnibus demand made as regards the entire property of the petitioner is not sustainable. As such, I pass the following order. Writ petition is allowed. A certiorari is issued so-and-so at annexure D to D1 demanding property tax in respect of property bearing number so-and-so is quashed. Liberty is reserved to respond number 2 to conduct a survey, identify the properties which are not exclusively used for education purposes, and raise demand in respect of those properties which are used for commercial purposes and not for or not used for exclusively for education purposes.
Please.
Pending IA stands disposed.
13, Abhijit Kankan.
They are seeking a writ of mandamus to the respondent number 3, PDO, to issue no objection certificate pursuant to the conversion order having been passed.
In 11 is sketched.
Yeah. No objection to at annexure D.
13.
Pass over.
Please.
14, Srinivas Admani.
Pass over.
Please.
15, SG Solar Goppa.
Kindly have it tomorrow, my lords. The council on record is facing some inconvenience, my lords.
Tomorrow, ಒಳಗೆ ಇದು comply ಮಾಡ್ತೀರಾ?
ಮಾಡ್ತಾರೆ.
At the request of counsel for the petitioner, relist on 25th. Astral comply ಮಾಡಿ.
16, Abhinay.
Lords, I'm appearing on behalf of the petitioner, my lords. Lords, senior counsel is engaged in the matter. Just a short pass over, my lords.
40, 45, 47 are blank. ಏನಪ್ಪ ಇದು?
Lords, that is part of the document only, my lords. So
part of the document can't be blank.
In fact, the page number is also written.
How can it be blank?
Can you see the prayer column? Prayer lordship seeking deemed conversion because application is made a lordship on 27/11/2024.
27/11/2024.
11. How can it be possible?
4 months ಆಗಿಲ್ವಲ್ಲ?
Just a short pass over.
ಆಯ್ತು ಅವ್ರಿಗೆ ಹೇಳಿ 4 months ಆಗಿಲ್ಲ ಅಂತ.
Please, ma'am.
17, SC Kadkatti.
Ellar application for petition
During the
number
pendency of the above matter, petition number 1 expired on
28/5/24. 28/5/24, my lord.
28/5/24, hence IA 1, 2 and 3 of 24 has been filed on
6th December of 24, my lord. 6th December of 24.
6/12/24,
16,
accepting
16,
the
brother.
16 December 2024. Accepting the reasons stated in support of IA 1 of 24, the delay of 144 days in filing the applications are condoned. Consequently, IA 2 of 24 is allowed. Abatement in respect of petition number 1 is set aside. By allowing IA 3 of 24, the person named therein are brought on record as P1A and B. Counsel for the petitioner to carry out necessary amendment and file amended cause title. When will you be ready?
I am ready.
Next week, ma'am.
The request of counsel for the petitioner relist on 31st.
Please.
Interim order to be granted.
Interim order earlier granted is extended till next day.
18, D. Venkanagowda, party in person.
Number 1.
Party in person committee ಹೋಗಿದ್ಯಾ? Permission ಇದೆ?
ನಿಮ್ದೆ.
ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Form C. Form C.
My lord's submission, Lord. My lords, may look at the order 24/6/2020.
Now, first, whether Form C has been issued because IA 1 is pending.
ಸೀಸು ಮಾಡಿಲ್ಲದೇವ್ರು ಸೀಸು ಮಾಡಿಲ್ಲದೇವ್ರು
ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ. ರೂಲ್ 10 ಒಳಗಡೆ ಪ್ರೊಟೆಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು. ರೂಲ್ 10 ಒಳಗಡೆ ಪ್ರೊಟೆಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು. ಅವರು ಅದೆಲ್ಲ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಿದ್ರು ಅವರು, ಇವನು ಒಂದೇ ಪೆಟಿಷನರ್ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ, ಆಮೇಲೆ ಇವತ್ತಿಗೆ ಏನು ಸರಿಯಾಗಿ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ, ಅವನ ಫಸ್ಟ್ ಪೆಟಿಷನರೇ ಮಾಡಲಿಲ್ಲ, ಯಾಕೆ ಮಾಡ್ಲಿಕ್ಕೆ ಅಂತ ಸರಿಯಾಗಿ ಉತ್ತರ ಕೊಡಲಿಲ್ಲ ಅನ್ನೋದು ಉದ್ದೇಶಿಸ್ಕೊಂಡು ಅದನ್ನ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. ಅದಕ್ಕಾಗಿಯೇ ಈ ಫಸ್ಟ್ ಪೆಟಿಷನರ್ ಒಂದು ಮೆಮೊನು ಕೊಡಿಸಿದ್ದಾರೆ ಅವರು. ಇಲ್ಲ ನಾನು ನನ್ನ ಪರ್ಸನಲಿ ಏನಿದೆ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿನಲ್ಲಿ ಅದನ್ನ ಮೆಮೊನು ಕೊಟ್ಟಿದ್ದಾರೆ.
ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಲ್ಲ ನಿಮ್?
ಹಾ ಹೌದು ದೇವರು. ಅದಾದ್ಮೇಲೆ ಅದು ನಾನು ಪ್ರೊಟೆಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೇವೆ. ಆಮೇಲೆ ಫಸ್ಟ್ ಪೆಟಿಷನ್ ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ ಅಡ್ವೊಕೇಟ್ ಅಂತ ಅವ್ರ ಮಗಳು, ಅದ್ರ ಬಗ್ಗೆ ಮೆಮೊನು ಕೊಟ್ಟಿದ್ದಾಳೆ ಅಮ್ಮ, ಕೊಟ್ಟಿದ್ದಾರೆ ಮಗಳು. ಅದನ್ನು ತನ್ನ ಮೆಮೊದಲ್ಲಿ ಫಸ್ಟ್ ಬರೆದು ಹೇಳ್ತಿರೋದೇವರು, ಐ ಡಿ ವಿ ಜ್ಯೋತಿ unpracticed advocate is respectfully submitting that the first petitioner have got enrolled in 2009 and on same year I got registered my name in the Harapanalli Bar Association. See, one D. Abdul Rahman Saab, politician, unpracticed advocate, strong and major community leader, was intent to take Sri Gokarneshwara temple land in Harapanalli to municipality for construction of commercial complex. My father, party in person.
Nimma request was rejected by a coordinate bench on 1/6/22. ಆಮೇಲೆ ರಿವ್ಯೂ ಪೆಟಿಷನ್ ಹಾಕಿದ್ರಿ, ರಿವ್ಯೂ ಪೆಟಿಷನ್ ರಿಜೆಕ್ಟ್ ಆಯ್ತು.
ಇಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ ಇದೆಲ್ಲ
ರಿಜೆಕ್ಟ್ ಆಗಿದೆ 24/6
ಅದ್ರ ಬಗ್ಗೆ ಇದು ನನಗೆ. ಆಮೇಲೆ ಅದಾದ್ಮೇಲೆ 10 ಒಳಗಡೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೇವರು.
ನಿಮ್ದು 2 ಸತಿ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ, ನೀವು ಅಪಿಯರ್ ಆಗಕ್ ಆಗಲ್ಲ, ಒಂದು ವಕೀಲನ ಇಟ್ಕೊಳ್ಳಿ.
ಅದಂತೂ ಇಲ್ಲ ದೇವ್ರು, ದಯಮಾಡಿ ಅದಕ್ಕೆ ನಾನು ಇದನ್ನ 25-26 ವರ್ಷದಿಂದ ನಾನು ಇದು ಅಟೆಂಡ್ ಮಾಡ್ತಾ ಬಂದಿದ್ದೀನಿ.
ಆರ್ಡರ್ ಆಗೋಗಿದೆ ಆಲ್ರೆಡಿ.
ಸರಿ, ಅವರೇ ಇದಾದ್ರೆ ಮತ್ತೆ ಎಷ್ಟು ಕಷ್ಟ ಆಗುತ್ತದೆ ದೇವ್ರು. ಅದರಲ್ಲಿ ನಾಗರಿಕನ ಹಕ್ಕು ಇದಾಗ್ತಿಲ್ಲ ದೇವ್ರು.
ವೆಂಕಣ್ಣಗೌಡ ಅವರೇ, ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ನೀವು ಮತ್ತೆ ಬಂದು ಹಿಂಗ್ ಸಬ್ಮಿಷನ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ನೀವು ವಕೀಲರಾದ್ರೂ ಇಟ್ಕೊಳ್ಳಿ, ಪೆಟಿಷನ್ ನಂಬರ್ 1 ಆದ್ರೂ ಬರ್ಲಿ, ಇಲ್ಲ ಆದ್ರೆ ನಾವು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ.
ಅಲ್ಲ ಮಾನ್ಯ ನಿಶ್ಚಿತ ಅದ್ರ ಬಗ್ಗೆ ನಾನು ಮಾತಾಡಕ್ಕಾಗದೇವ್ರು. ಒಂದು ಫಸ್ಟ್ ಪೆಟಿಷನರ್ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರೆ, ದಯಮಾಡಿ ಅದನ್ನ ಸ್ವಲ್ಪ ಗಮನಿಸ್ಬೇಕು ದೇವ್ರು. ಅದನ್ನೇ ಓದ್ಲಿಕ್ಕೆ ನಾನು ಇವಾಗ ಅದನ್ನೇ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರೆ, ಫಸ್ಟ್ ಪೆಟಿಷನ್ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನೇ ಓದ್ಲಿಕ್ಕೆ ನಾನು.
ಏನ್ ಬರ್ದಿದ್ದಾರೆ ಇದ್ರಲ್ಲಿ? ಏನ್ ಹಿಂಗೆಲ್ಲ ಬರ್ದ್ ಕೊಟ್ರೆ
ಇಂಗ್ಲಿಷ್ ಸ್ವಲ್ಪ ಅದೊಂದು ಬೇರೆ ಅಂತೂ ಅದು ಅಲ್ಲಿ ಆದಂತ
ಕೇಸ್ ಇದೆಯೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ, ಬಟ್ ಇದ್ರೇನು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ ಹಿಂಗ್ ಮಾಡಿದ್ರೆ. ಇನ್ನೊಂದ್ ವಾರ ನಿಮಗ್ ಟೈಮ್ ಕೊಡ್ತೀವಿ, ವಕೀಲ್ ಇಟ್ಕೊಳಂಗಿದ್ರೆ ಇಟ್ಕೊಳ್ಳಿ, ಇಲ್ಲ ಆದ್ರೆ ಡಿಸ್ಮಿಸ್
ಅಲ್ಲ
ಮಾಡಿ.
ನ್ಯಾಯದೇವರು ಇವತ್ತೇ ಇದು ನಾನಂತೂ ಅಡ್ವೊಕೇಟ್ ಇಟ್ಕೊಳ್ಳೋದು
ಇಟ್ಕೊಳಲ್ವಾ?
ಇಟ್ಕೊಳ್ಳೋದೇವ್ರು ಅದು ಅದ್ರ ಬಗ್ಗೆ ಮಾನ್ಯರ ಇದ್ರ ಬಗ್ಗೆ ನಾನು ಮಾತಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
The petitioner is before this court seeking for the following relief.
ಅದು ಇನ್ನೊಂದು ಪ್ರಾರ್ಥನೆ ದೇವರು ಈ ಬೆಂಗಳೂರು ಮಾನ್ಯ ರಿಜಿಸ್ಟ್ರಿ ಜನರಲ್ ಅವರು ಒಂದು ಮೆಮೋನು ಕೊಟ್ಟಿದ್ದಾರೆ, ಕಳಿಸಿಕೊಟ್ಟು ಅದ್ರ ಬಗ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ದೇವರು ಬಿಜೆಪಿ ಏನು GPA ಬಗ್ಗೆ. ಅದನ್ನ ಕೊಡ್ತೀನಿ, ತಮ್ಮ ಗಮನ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
Petitioner is before this court seeking for the following relief. Petitioner Petitioners are before this court seeking for the following reliefs. The petitioner are represented by their father and GPA holder. They said father and GPA holder had made a request for appearing in the matter as party in person on behalf of the petitioners. The said request
ಇಲ್ಲಿ ಹಲವಾರು ಪರ್ಮಿಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ದೇವರು. ಇದೇ GPA ಬಗ್ಗೆನೆ ಹಲವಾರು ನ್ಯಾಯ ಕೋರ್ಟಿನಲ್ಲಿ ಕೇಸ್ನ ಅಟೆಂಡ್ ಮಾಡಿದ್ದೀನಿ ದೇವರು.
having been referred to the party in person committee for ascertaining the fitness of his fitness to represent the matter. The party in person committee, wide order dated 4/9/21, rejected the said request. Subsequently, he made a request to this court to appear as a party in person on behalf of the petitioner. This court, wide order dated 1/6/2022, rejected the said request and permitted him to engage a counsel. Thereafter, an application to review the said order dated 1/6/2022 was filed, which application also came to be rejected on 24/6/2022. Thus, from the records, it is clear that the party in person committee as also this court has rejected his request to appear as a party in person. Today, when the party in person was present before this court, he was given an option to engage a counsel to conduct the matter. However, he has flatly refused the same, contending that he would not be engaging any counsel. Legal services ಬೇಕಾ?
ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಒಂದು ಕೇಸ್ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಹೋಗಿತ್ತು ಅವ್ರು, ಒಂದು ಕೇಸು ಅದು ಯಾರೇನು RS ಅದನ್ನ ಅವರೆಲ್ಲ ನೀವು ಈ ರೀತಿ ಅಯ್ಯಕಂತೇಳಿ ನನ್ನ ಈ ಕೇಸ್ ಅಲ್ಲ ದೇವರು, ಬೇರೆ ಕೇಸ್ ದೇವರು.
ಇವಾಗ ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಬೇಕಾ ಹೇಳಿ? ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ರೆಫರ್ ಮಾಡ್ತೀವಿ, ನೀವು ದುಡ್ಡು ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂದ್ರೆ.
ದುಡ್ಡು ಕೊಡೋ ವಿಚಾರ ಅಲ್ಲ ದೇವ್ರು, ನಂಗೆ ನಾಲೆಜ್ ಇದೆ ದೇವ್ರು, ಅದನ್ನ ನನ್ನ ಪ್ರಶ್ನೆ ನಾವು
ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಇವಾಗ ನಾವೇನು
ಅವ್ರು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ ತಕ್ಷಣ ಅದಕ್ಕೆ ನಾನು ಫರ್ದರ್ ಕೇಳಿದ್ದೀನಿ ದೇವ್ರು ನಾನು.
It was even suggested to him that the matter could be referred to the legal service authority to enable a counsel to be appointed on his behalf, which was also flatly refused by him. In that view of the matter, when this court has rejected his request twice earlier to appear as a party in person, which has attained finality not having been challenged, the petitioner cannot be, the the father of the petitioner cannot be allowed to appear as a party in person in the present matter. Since he has flatly refused to engage a counsel, no purpose would be served by retaining the matter. Petition is dismissed for non-prosecution.
ದೇವರು ಪ್ರಾರ್ಥನೆ ದೇವರು ಇದು ಕೇಸ್ ಇರೋದು ಈ 32
ಆರ್ಡರ್ ಆಗಿದೆ,
ದೇವರದು
ಅದರ ವಿರುದ್ಧ ನಾವೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ, ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ ಒಂದು ಪ್ರಾರ್ಥನೆ ದೇವ್ರು ಈಗ ಪಾರ್ಟಿ ಇವ್ರೇನು ಪಾರ್ಟಿ
ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಕಳಿಸ್ತೀವಿ ಕೇಳ್ತೀವಿ ಅಂದ್ರೆ ಕೇಳಲ್ಲ ಅಂತೀರಾ ನೀವು?
ನಾಗರಿಕ ಉಳಿಯೋದೇ ಕಷ್ಟ ಆಗ್ಬೇಕಿದೆ, ತನ್ನ ಇದನ್ನ ತಾನು ಮಂಡನೆ ಮಾಡೋದೇ ಕಷ್ಟ ಆಗಿದೆ ಅವನಿಗೆ.
Yes, next.
19, Dayanandam Bandi.
Please. Preliminary notification has been questioned, madam. Subsequently, award has been passed.
For amendment of the petition.
No challenge in respect of the awards.
Challenging
the award by IA2.
No, he has not
challenged. I am challenging the preliminary notification and exempting the social impact assessment as well as the final notification on various grounds, my lord, and very recent.
Notification matra na?
Only preliminary notification. No final notification is challenged. 19(1) notification has not challenged.
Probably later on, my lord, when initially I filed a writ petition.
11(1) ಮಾತ್ರ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಮಿಸ್ಟರ್ ಬಂಡಿ?
ಇಲ್ಲ, ಆಮೇಲೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ ಎರಡು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ.
ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ, 19(1) ಮಾಡಿದ್ದಾರೆ, ಪ್ರೇಯರ್ 3
ಮಾಡಿದ್ದೀನಿ.
Yes, but award is not challenged.
ಪ್ರೇಯರ್ 3 ಮಾಡಿದ್ದಾರೆ. ಇದೇನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಇವಾಗ ಪೆಂಡಿಂಗ್ ಇರೋದು?
Proviso to rule 34, constitutional validity of proviso to rule 34, seeking an additional prayer to challenge it, my lords, by way of amendment.
Accepting the reasons stated in support of IA2 of 24. The amendment sought for being to declare the proviso to rule 34 of the right to fair compensation and transparency in land acquisition, rehabilitation, resettlement, bracket Karnataka rules 2015, is allowed since the same would be required, since the same would have to be considered to effectively and properly adjudicate the dispute list in the present matter. Counsel for the petitioner to carry out necessary amendment and file amended petition. Since a challenge is made through the virus of the rules, Advocate General is directed to accept notice. The learned Additional Advocate General seeks for and is granted.
Objection. Weeks time, we'll file it because some urgency in this matter, my lord, for last
weeks time to file a statement of objection. Objections, if any, to be filed on or before 31st January.
Please.
Relist on 4th February.
Please.
31st January, after serving a copy thereof.
Please.
The counsel for the petitioner. The amendment to be carried out on or before 25th
Yes,
January. Both the counsels are directed to exchange their respective synopsis of dates and events, list of authorities and authorities with each other before 31st January 2025.
Please.
Interim order.
Interim order earlier granted is extended till next date.
20.
Consideration of IA1 of 24 will amount to consideration of the matter on merits. As such, IA1 of 24 will be considered along with the merits of the matter.
Please.
20, Shantaf Gowda.
Proxy submission on behalf of the counsel appearing for the petitioner. He's not keeping well, my lords. I request for a short accommodation. It may be taken up on Monday, my lords.
My lords, fix the date for hearing today.
It's not well and
quite so. I am not opposing.
When people
may I request, my lord,
that the counsel for the arguing counsel for the petitioner is indisposed today.
My lord, the earlier interim order was discontinued because, my lord, they did not comply with the amendment. Thereafter, my writ appeal was filed. My lord, in the writ appeal, my lord, I was given permission to, my lord, make an application for seeking vacation of the interim order.
Anyway, we are considering it on Monday.
Monday or Tuesday. I am requesting for Monday or Tuesday.
Monday. That is what he is requesting. Is indisposed today. At his request, relist on Monday, 27th. It is made clear that no further adjournment would be granted.
Please.
Interim order earlier granted is extended till next day.
Grateful.
21, Anup Deshpande.
Connected matter, my lord.
At the request of counsel for the petitioner, IA1 of 24 is dismissed as not pressed.
One submission, my lordship.
May I make one submission? Not in 19.1. 20.1. But I appear
21.1.
Yes, 21.1. I appear for R5 and R6. And my lord, in 21,
R4 to 6.
R4 to 6 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
Kamte, you are appearing for respond number 4.
R4, 4.
R4 only, my lord. Amendment can take notice.
Or
for
5
R5.
and 6.
No, no, in 21.1,
Yes, really.
I have already appeared for R5 and 6. And
It is shown as 4 to 6.
4 to 6.
Correct ಮಾಡಬೇಕು.
Correct ಮಾಡಬೇಕು.
Registry is directed to correct the appearance of Srinivas B. Nayak as that appearing for respond number 5 and 6, since Sri B.S. Kamte has entered appearance for respond number 4.
4. And in 21, my lord, I may be directed to take notice for R5.
Mr. Kamte has appeared for R5.
No, he appears for KPTCL.
Since
And
both KPTCL and HESCOM are party, my lord.
You have filed wakalatnama or no?
Wakalat hakilla. Lord, I was directly taking this.
Srinivas 21, other 21.1, no? 21. Shri B.S. Kamte submit that he will be only appearing for respond number 4. Hence, registry is direct print the name of Shri B.S. Kamte as that appearing for respond number 4. Shri Srinivas B. Nayak submits that he would accept notice on behalf of respond number 5.
Yes.
Registry is directed to print his name as such.
Copy.
Submission, my lordship. In first matter, petitioner number 1 and petitioner number 3, I have filed bringing LRs on record. Same or impleading applicants in second matter. Impleading applicant number 1 and 3.
LRs of whom? The petitioners.
Petitioner number 1 and 3 in first matter. And same persons are impleading applicants in second matter.
The IA is not put up.
Not put up agilla.
Idya? Good.
ಅಲ್ಲ ಆ ಕೇಸಲ್ಲಿ ಅಲ್ಲ petitioner there is some ಅಲ್ಲ ಅದು 21.1 ಅಲ್ಲಿ including the application.
Petition number 1 is expired. Petition number 1 is expired.
Petitioner number 1 and petitioner number 3.
3 ಇದೆಲ್ಲಿದೆ? 1 ಮಾತ್ರ ಇದೆ ಇಲ್ಲಿ.
ಎರಡು separate.
ಇನ್ನ ಒಂದು ಸೆಟ್ ಇದೆ.
LR application, abatement and condonation appeal. 3 applications for each petitioner, 1 and 3.
One and 3.
Yes,
Impleading application ಏನಕ್ಕೆ ಹಾಕೊಂಡಿದ್ರೆ ಅದರಲ್ಲಿ?
The subject matter in second matter.
1 and 3 were not parties.
Yes,
No, they are claiming also.
The petitioner in this first petition, they are also interested in the same matter. The subject matter is same.
They may be interested. Petition number 1 and 3 in the first matter, are they parties in the second matter?
They are impleading applicants.
That already order has been passed saying that it will be taken up along with the main. 20. Continue, Marty. During pendency of the above matter, petition number 1 expired on?
Expired on 27/4/24.
27/4/2024. Hence, IA 1, 2 and 3 of 25 have been filed on 22nd January 2025. Accepting the reasons. Delay esto?
First matter 151 days. 151 days.
Fill ಮಾಡಿಲ್ಲ. ಏನು
I will rectify.
ನೀವೆಲ್ಲ ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ? Accepting the reasons stated in support of IA 1 of 25, the delay of
151 days.
151 days is condoned. IA 1 of 25 is allowed. Consequently, IA 2 of 25 is allowed. Abatement in respect of petition number 1 is set aside. By allowing IA 3 of 21, the person named in the said application are brought on record as petition number 1A to 1F. During the pendency of the above matter, petition number 3 expired on
11/5/23.
11/5/23. Hence, IA 4, 5 and 6 of 2025 have been filed. Accepting the reasons stated in support of IA 4 of 25, delay of
530 days.
532 days is condoned subject to payment of cost of rupees. ಅದರಲ್ಲಿ 121 ನಾವು ಹಾಕಲ್ಲ 500 ಎಷ್ಟು
Minimum cost.
minimum cost 10,000. 2,000 rupees payable to the advocate's clerks, so and so. Consequently, IA 5 of 25 is allowed. The abatement in respect of petition number 3 is set aside. by allowing IA 3 of 2024-25. The person named therein are brought on record as petition number 3A to 3D. Counsel for the petitioner to carry out necessary amendment and file amended cost title.
Yes.
ಯಾವಾಗ ರೆಡಿ ಆಗ್ತೀರಾ?
Today itself I am ready.
ಇದು ಫೈಲ್ ಮಾಡ್ಬೇಕಲ್ಲ. You are ready.
Today I'm also ready.
No, in other matter, I have to file my statement.
ಯಾವ್ದ್ರಲ್ಲಿ?
21 ಅಲ್ಲಿ.
Learned counsel for respond number 5 seeks for and is granted
Week's time.
week's time to file a statement of objections. Relist objections if any to be filed on or before 31st. Relist amendment to be carried out and amended cost title to be filed on or before 27th. Relist on 6th February.
Copy.
In second matter, there is no any order in this. Impleading application is to be considered along with main petition. That is the order. And this LR application.
LR application
ಅಲ್ಲಿ ಅದ್ರೊಳಗಡೆ ಅಲ್ಲೂ LR application ಇದೆ ಅಲ್ಲ.
Impleading applicant 1 and 3 ಹಾಕಿದ್ರಾ?
ಹಾ 1 and 3.
2020 matter during pendency that.
No, impleading application is still not considered. During consideration of that impleading application, they are deceased.
So now you will have to file
Fresh application.
ಮಾಡಿ.
Please.
List on 6th.
Please.
Even that may not be necessary. There is another
You are-
petition which is not.
You are here already.
Already.
We'll,
There is a separate petition.
you can always address that. Both will be taken together.
Please.
22 Gangadhar Raskeri.
Petitioner. Yes, my lords. Amicable resolution, please.
My lord,
Some more time, my lord. Some more time is required, my lords. Yesterday, time ಬೇಕು.
yesterday we had a meeting, my lord, with the representative of the petitioners and the the elected representative, my lord, in the presence of both of us. Broadly, they have come to a, my lord, understanding. Because they have to go
ಎಷ್ಟು ದಿನ ಬೇಕು?
consult all the.
ಎಷ್ಟು ದಿನ ಬೇಕು?
10 days. ನೀವು ಹೇಳ್ರಿ.
10 days.
10 days.
Both the councils submit that a meeting had been held yesterday, please. A meeting had been held on 22nd January. And certain of the aspects have been discussed. Please. Given 2 weeks' time, please, they'll endeavor to report settlement.
Please.
Relist on 14th February. Please. Deeply obliged. Interim order mechanically. Interim order earlier granted is extended till next day. Please.
23 Vyas Desai.
Due to inadvertence, my lord, not challenge annexure D. My lord, your lordship had dictated the order, my lord.
Endorsement was not challenged, only was seeking exemption. So the lordship was pleased to grant time to file necessary application seeking cautions of the endorsement.
Imposing tax upon the poultry farm.
Poultry farm.
But one judgment of this honorable court, my lord, I am appearing for the municipality minutes. Though my lord, I am not disputing the judgment of my lord. That is rendered under the Gram Panchayat Act. But under the Municipality Act, they are liable to pay the tax matters. That I can point out to lordship.
Is the Municipalities Act?
Yes, Municipality.
The property is situated in town panchayat, my lord.
The municipality or
Town panchayat is exercising powers under Municipalities Act.
ನೀವು ಯಾರು Mr. Saukar? Who are you appearing for?
For respond number 4 minutes.
4 is the Panchayat.
Yes.
It is not even a
How can
municipal.
you say under Municipalities Act you will excise? It
but-
won't apply to you.
Yes, my lord. But I am applied by the Gram Panchayat, this Municipalities Act, not the Gram Panchayat Act. It was earlier, it was not the Gram Panchayat. Subsequently, my lord, it is municipality.
Then it is for the municipality to do that.
Yes,
Not
I am.
for you.
I am appearing for the municipality.
Municipality.
Yes.
4 town Panchayat ಇದೆ.
Town Panchayat.
Where is the municipality? Municipality is not a party.
Town Panchayat, my lord, itself, my lord, is.
Demand is annexure.
Annexure D, my lord.
D.
Page 20.
ಯಾರು issue ಮಾಡಿರೋದು?
Town panchayat.
Annexure D is your reply. Where is the demand?
E annexure E, my lord.
Page 20.
Town
Page 20.
panchayat mache,
Yes, my lord.
not the municipality.
No, that's out, my lord. Though municipality or town panchayat are governed by, my lord, the Municipalities Act, not under the Gram Panchayat Act. If it is a Gram Panchayat, my lord, then it is covered.
On what basis do you say that?
Please.
On what basis do you say that this act will govern the panchayat?
Yes, but town panchayat
Huh?
is naturally, my lord, covered under the Municipalities Act.
How? How can a panchayat be governed under municipality act? Panchayat Raj Act is there.
No, no, a Gram Panchayat earlier, my lord, it was there. Subsequently, my lord, it is the due to, my lord, the population and other things. Now it is, my lord, the town panchayat. Town panchayat is governed under the Municipalities Act, not under the Gram Panchayat Act.
TMC ಆಗಿದೆಯಾ ನಿಮ್ದು?
Yes, ma'am.
TMC. ಮತ್ತೆ ಇಲ್ಲಿ ಟೌನ್ ಪಂಚಾಯತ್ TMC ಅಂತ ಹಾಕಿಲ್ಲ ನೀವು?
ಅದೇ
Town panchayat is also governed under the, comes under the directorate of
Correct.
municipality.
TMC will come.
Yes.
TMC. It is.
But it's not shown as TMC, it is shown as
itself
panchayat.
is upgraded from Gram Panchayat to town.
But the letter used is panchayat.
Taluka Panchayat, Gram Panchayat is different, it comes under Gram Swaraj Act. Whereas town panchayat comes under the directorate of municipalities.
They are now a town panchayat, not a gram panchayat.
I may address arguments on that, my lord.
Accepting the reasons stated in support of IA 1 of 2025. Considering that additional relief challenging the demand has been made, is been sought for, IA 1 of 25 is allowed. Accepting the reasons stated in support of IA 3 of 24, the production certified copy of Annexure A, A1 and B are dispensed with. Learned Counsel for respond number 4 submits that the respond number 4 is a town panchayat, and as such, the judgment dated 5th September 2023 in WP number 38871 of 2016, passed in reference to a gram panchayat, will not be applicable. Faced with the above situation, learned counsel for the petitioner seeks for and is granted a week's time to get ready and address his arguments. Relist on 31st.
Please.
Please.
24, Santosh Rao.
My lord, connected matter is coming tomorrow, my lord. Another connected matter.
With WP number
108001, my lord.
108001 of 2023 and relist tomorrow.
Please.
25, Sadiq Goodwala.
Yes, sir. Petitioner. On 6/5/2022, the auction was held on in page 9. In page 9. And after auction, I have deposited amount of rupees 1,20,000. Till today, my lord.
Who held the auction? Corporation held it.
Corporation. And this is done in 22, my lord, on 6/5/22.
Yes.
My lords, we have cancelled the auction and we have issued an endorsement to that effect, which is called in question in the present petition. Lords, brief facts of the case of this, my lords. My lords, corporation floated with the, my lords, auction of the various shops. And my lords, existing shop owners, many of the existing shop owners, my lords, filed a suit, and many of the shop owners approached this honorable court, wherein several interim orders were passed, and we could not proceed with the auction. Insofar as present petition is also concerned, existing shop owner had approached this honorable court. But process is, my lords, a bit problematic. Why, my lords, I'll explain. My lords, there is a, my lords, circular according to which we will have to conduct the, my lords, auction of the shops for every 12 years. If we go to conduct the auction, existing shop owners, they will approach this honorable court or civil court stating that since we are
Pending idea writ petition, no?
writ is disposed of, wherein, my lords, we gave undertaking that, my lords, 6 months time will be granted to the existing shop owners, and thereafter fresh auction will be called, and, my lords, as per the regulations, he can, my lords, seek for right of first refusal, or, my lords, if he does not opt that option, my lords, fresh tenderer will, my lords, take it up, my lords. This is how
ಯಾವಾಗ ಡಿಸ್ಪೋಸ್ ಆಯ್ತದು?
dispose was, my lords, 4th October 2023.
ಏನ್ ಮಾಡಿದೀರಾ?
But thereafter, my lords, we have not conducted the auction. Why I'll tell, my lords. Due to, my lords, elections and, my lords, change of commissioners.
ಏನ್ ಎಲೆಕ್ಷನ್?
1.5 years.
ಏನ್ ಎಲೆಕ್ಷನ್?
Lords, MLC elections ಎಲ್ಲ ಆಯ್ತು.
MLC election and corporation ಎಲ್ಲ will come to a standstill.
ಇಲ್ಲ ಸ್ಟ್ಯಾಂಡ್ ಸ್ಟಿಲ್ ಅಲ್ಲ, ಬಟ್, my lords, the officials will be
to record that, we'll record that.
ಇಲ್ಲ.
MLC election ಅಲ್ಲಿ corporation will not function.
ಇಲ್ಲ ಆತರ I'll not.
October 23, 6 months ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇವಾಗ 25 January.
I understand, my lords, in view of change of regular commissioners and other things, we could not proceed with the auction.
It keeps on changing. What to do?
My lords, we are finalizing, we are planning, my lords. Only thing is, few things which are coming to our, my lords, concerned is,
We are not concerned with whatever
ಇಲ್ಲ,
is coming to your
process of law, my lords.
When will you conduct the auction?
I'll secure instructions in so far as auction, when they will conduct the auction. But problem is that, my lords,
There is
ಇಲ್ಲ problem is there, my lords. I'll explain. Why I'll explain, my lords. Why I will explain. 2 minutes.
ಮುನವಳ್ಳಿ, ನೀವು ಇದೆಲ್ಲ ಹೇಳಿದ್ರೆ we'll have to deal with it. Please understand.
It has to be, my lords.
Problem ಅಂತ ಹೇಳಿ ಅಂದ್ರೆ ನಿಮ್ corporation cannot work. Is only faced with problem, is not.
Not exactly, my lords. So, procedure, I'll tell, my lords. I'll explain in 2 minutes. Lords, as per circular, we'll have to conduct the auction for every 12 years. And existing shop owner will be given right of first refusal. This aspect. Second aspect, my lords. After 12 years, they will not vacate the premises.
Yes.
They will ask us to proceed in Public Premises Act. We will proceed. That will take, my lords, 2-3 months. Thereafter, they will challenge that order in district court. There they will opt in stay. Again 1 year there. And thereafter, my lords, thereafter they will approach writ petition. My lords, this is the one aspect. And as per the circular of the government, 2019 circular, we'll have to conduct the auction every 12 years. My lords, these are the few things which we'll have to tackle, and we'll have to conduct the auction.
You will wait for 3 months after that.
ಅಲ್ಲ ಇವ್ರಿಗಂತೂ ನಾವು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದೀವಿ ಆಲ್ರೆಡಿ.
Notice.
We have already cancelled his auction because of the pendants.
Auction ಅಲ್ಲಿ ಒಂದು clause ಇರುತ್ತೆ.
ಇದೆ.
That they can cancel at their this one without intimating you ಅಂತ ಮಾಡಿದ್ದಾರೆ.
With that clause only, my lords.
ಇವಾಗ next auction ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
That I will, my lords.
You can participate.
Yes, he can participate.
You can't be holding on like this on a public property. If you are not able to do it, don't build any shops from now on.
My lords, my lords, 15 days time can be granted. I'll secure
Then
this.
shops ಇದೆಯೋ ಸೇಲ್ ಮಾಡ್ಬಿಡಿ. ಏನಕ್ಕೆ ಬೇಕು ನಿಮ್ಗೆ? If you can't handle it.
ಇಲ್ಲ, we can't handle ಅಂತಲ್ಲ. But this is how, my lords.
Sale ಮಾಡ್ಬಿಡಿ. Give an option for sale, sell it, they will take care of themselves.
Building, my lords.
Building ನಿಮ್ಗೆ ಏನಕ್ಕೆ ಬೇಕು? ಬಿಲ್ಡಿಂಗ್ ನೋಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ ನಿಮ್ಗೆ. ಬಿಲ್ಡಿಂಗ್ ಮೇಂಟೆನೆನ್ಸ್ ಮಾಡಲ್ಲ ನೀವು.
ಇಲ್ಲ, we maintain, my lords.
ಮಾಡ್ತೀವಿ.
We maintain.
ನಿಮ್ ಯಾವ ಬಿಲ್ಡಿಂಗ್ ಹೋಗಿ ಫೋಟೋ ತಗೊಂಡ್ ಬನ್ನಿ.
15 days time, my lords. I'll secure instructions with regard to when we are going to conduct the auction.
For respond number 2 and 3 seeks bond is granted 15 days time to obtain instruction, make a submission as to when the auction is proposed to be held in furtherance of the direction issued by this court on 23rd October 2020.
No, there is no direction as such, my lords. Specific direction illa. We have stated that after we will give you them 6 months time.
In terms of the undertaking given by respond number 2 and 3.
When anta ashte undertaking ella sumne, my lords, it will create a problem.
105,734.
Create a problem.
105,734.
105,734 of
23.
Otherwise, you will never do anything.
ಇಲ್ಲ, I will see to it that, my lords.
And you will be ಎಷ್ಟು 100 ರೂಪಾಯ 200 ರೂಪಾಯ
ಯಾವ್ದಕ್ಕೆ?
ರೆಂಟ್
ಇಲ್ಲ
ಅದು ನಡೀತಾ ಇರೋದು ಎಷ್ಟು ನಡೀತಾ ಇದೆ ಅಲ್ಲಿ?
ಅದು ನಡೀತಾ ಇರೋದು 2,000-3,000. Now it is once
That is
last occasion we received
public property and public money.
10,000, 20,000 up to that we have received.
You have to strictly implement it and auction it.
Yes, please.
Relist on 14th February.
Please, preliminary.
Yeah.
26, Vittal Teli.
To vacate the interim order, my lord.
Merits ಹೇಳಿ.
The petitioner is the plaintiff. Lords, filed a suit for declaration, lords, by way of my lords easement rate, by way of necessity.
Tell ಇನ್ಮೇಲೆ certiorari and ಬರ್ಕೊಡ್ದು. Set aside.
Set aside, please.
And 226 ಬರ್ಕೊಡ್ದು. 227.
220, please.
ಎಲ್ಲರಿಗೂ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Please.
Yes.
Lords, petitioner.
227 ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲಿ actually. ಹೇಳಿ.
Lords, petitioner is the plaintiff. Lords, filed a suit for declaration by way of easement rights by way of necessity and my lord's prescription. Lords, filed application under order 39 rule 1 and 2. Trial court initially granted injunction. Subsequently, it was vacated. In MA, it came to be confirmed. During the pendency of suit, my lords, I filed an application for appointment of a court commissioner. Lords, application came to be allowed and court commissioner has submitted a report. My lords, take my lords to the page number 82 for a moment, my lords. This is the sketch submitted by the court commissioner, a report which sketch discloses.
Yes.
Lords, I am a owner of my lords 160/3, 2 properties, my lords.
(160/3).
Please, Mr.
Yes.
Lords, defendants are the owners of 161/1 F2 and 161/3, my lords. Lords, this C point which my lords should get for a moment in this sketch. Here, my lords, it connects to the road, my lords, where it goes to the Halyard Redratti road.
Yes.
Lords, my lords, I am requesting, my lords, this is my contention. Here, my lords, there was a road, and court commissioner has submitted nothing regarding. Now, at the time of commission report, entire road was closed. Here, I am requesting a road. My lords, my property is at 160/3. It is nowhere connecting to the road.
What is WX?
Lords, WX.
It connects to the canal road, my lord.
Lords, canal road. That is WX is the
further connected.
Access ಇದೆ ಅಲ್ಲ.
WX is the, it is between myself and my lords, it is between two my properties. I got myself left this road. Lords, it is not connecting to any roads of a village. It is only in between the my properties. Lords, 160.
You want to buy 20 feet?
I am ready, my lords.
They are not ready. Last occasion, my lord.
Lords, I had given this proposal.
ಬರೀ 20 feet ಅಷ್ಟೇ. ಪ್ರಾಪರ್ಟಿಗೆ ಏನು ಡಿಫರೆನ್ಸ್ ಆಗಲ್ಲ. ನಿಮಗೂ ಒಳ್ಳೆಯದು ರೋಡ್ ಇನ್ನೊಂದು ಪ್ರಾಪರ್ಟಿಗೆ ಬರುತ್ತೆ 161ಗೆ. 161 has no access. 161(2) also has no access. ಬರೀ edge ಅಲ್ಲಿ
it has access, my lord. In the court commission report, it is stated para number, my lord, page number 79, my lord. That is the report.
ಎಷ್ಟಿದೆ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ?
My lords, according to my property, it will be only 3 guntas. I am ready to pay. I give my friend.
Market value ಎಷ್ಟಿದೆ?
No, don't know, my lord, but last occasion we tried both, my lord.
ಎಷ್ಟಿದೆ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ?
They are not ready, my lord, for.
ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂಗಿಂತ ಜಾಸ್ತಿ ಕೊಡ್ಸಿ. If you are agreeable.
Lords, around 20 to 25 acre for 20 to 25 lakhs per acre.
Check ಮಾಡಿ.
Check.
We'll pay much more than that, whatever the market value is, not the market value.
He has 2 alternative road, my lord. The entire 160, my lord, survey number is, my lord. Either he was the owner, 160/1, 2 and 4. He sold, my lord. That, my lord, QR road and OP road are existing, and one road is WX road, my lord.
ಕೇಳಿ, if it can be sorted this way, this litigation will come to an end. You will get some money, and you will also get a proper access.
Please.
ನಿಮಗೂ ರೋಡ್ ಚೆನ್ನಾಗಿ ಬರುತ್ತೆ ಅದು.
Please, I will ask. I will take instruction.
They will actually be paying for a road that you will get.
That is true, lords.
Please.
ನಿಮ್ ದೊಡ್ಡ ರೋಡ್ ಬೇಕು ಅಂದ್ರೆ ದೊಡ್ಡ ಸೇಲ್ ಮಾಡಿ, ಚಿಕ್ಕ ರೋಡ್ ಬೇಕು ಅಂದ್ರೆ ಚಿಕ್ಕದಾಗಿ ಕೊಡಿ.
Lords, even my lords, if my lords should permit, court commissioner report says it is not used. Paragraph number 6, page number 18.
We are not looking at it legally if it can be settled.
Lords, even I am ready to pay. That is what.
ನೀವು legally argument ಮಾಡ್ಬೇಕಂದ್ರೆ ಇದು ಬೇಡ.
Not illegally, even if I am ready.
I will take instruction.
Lords, one submission I request for my lords. Now, my lords, my sugar cane is standing. Earlier, this court directed me to. Lords, for a moment, request, my lords, one submission. My lords, now within 1 week, sugar cane industries are going to be closed. My lords, cutting, harvesting. Only I am requesting for sending of that sugar cane only I'm requesting. This court directed.
We won't create any equity in between.
Notes, this court has
Monday.
direct.
Please, Monday, my lord. Monday.
Notes, this court has directed earlier.
Monday,
Monday.
at the request of counsel for respond number 1 to 3, released on 27.
Please.
27, speak Kandagal.
Please.
Are 5 and 6,
I have filed,
sir?
I have filed.
The writ petition not maintainable.
My,
Are 5 and 6 bad antira?
Not less.
I have-
7A order.
in this case, I have filed an application for staying of the operation of annexure E, my lord. Annexure E is the order passed by first respondent granting occupancy rights in favor of respondent number 3 and 4, my lord. And the petitioner's father was also.
You have a appeal remedy.
Pardon?
You have appeal remedy. It's a order granting occupancy rights. You have appeal remedy.
Section 118.
118. Kodi.
Shall is there.
Hmm?
Shall has to file. He has to file appeal. Not
Like
may.
in this case, this annexure E is passed against dead person.
Land reforms.
Appeal remedy ಇದೆ. ಇಲ್ಲಿ ಬರಕ್ಕಾಗಲ್ಲ. That ground is available there. All ground should be available to you there.
Like here, now they are taking steps to
You are
effect
before the
entries on
wrong
the basis of
forum.
this.
You are before the wrong forum. You have to go before the right forum. Petitioner is before this court seeking for the following relief. What is essentially challenged is an order under issuing Form 7A. The petitioner has an alternative efficacy remedy in terms of subsection 2 of section 118. Reserving such liberty, the petition stands disposed. All questions are left open.
Well, may I make one submission? A direction may be issued not to take steps on the basis of this.
You file an appeal tomorrow and do it. You are wasting time here. You correct ಆಗಿ ಯಾರ ಹತ್ರ ಹೋಗ್ಬೇಕು ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು. Notice to respond number 5 and 6 is dispensed with in view of the proposed order to be passed. IA1 stands disposed.
28, Srikanti Patil.
Filed application note for dispensation of type copy of annexure A and B. And also, my lord,
ಏನು ಗೊತ್ತಾಗಲ್ಲ. You have to file.
I will file it within 4 weeks, my lord. Some urgency, my lord, that
Counsel for the petitioner has filed IA1 of 2024 seeking for dispensation of production of typed copies of annexure A and B. A perusal of annexure A and B indicates that the same is not legible. As such, IA1 of 24 stands dismissed. Petitioner is granted 2 weeks' time to file typed copy of annexure A and B. Then dispensation in 40 to 42.
Lord, in respect of annexure E and F, respective page numbers.
ಏನು ಗೊತ್ತಾಗಲ್ಲ.
Lord, I'll within 2 weeks, my lord, I'll submit, my lord, the type copy of that also.
IA2 of 24 has been filed for dispensation of production of legible copy of page 40 to 42, 52, 60 and 66. A perusal thereof, said documents indicates that the same is not legible. Hence, IA2 of 24 is dismissed. 2 weeks' time is granted to the counsel for the petitioner to produce the type copies of the above documents. Yes.
Lord, the annexure E and F, my lord, is challenged before this honorable court. Lord, the present petitioner, my lord, have purchased, my lord, the agriculture land, Lord, in the year 1969. The disputed property is, my lord, RS number 97/2A. Lord, this is measuring 3 acres, my lord, and situated, my lord, in Rattiali village. Lord, and accordingly, my lord, in the year 1970, my lord, the entries were made in respect of, my lord, the registered sale deed. Lord, your lordship may kindly see, my lord, that on 1977, Lord, as per, my lord, the synopsis, that, my lord, land acquisition, my lord, has taken place in respect of this RS number 97. And, my lord, in respect of that, my lord, a writ petition came to be filed in the year 1988. And my
Yes.
lord, as per annexure C, page number 31. My lord, in respect of land acquisition proceedings, my lord, it has been set aside. In respect of RS number 97. That is at my lord, page number 31, annexure C. Impugn order passed in the writ petition. The final notification has been set aside.
Yes.
And my lord, for a moment, your lordship may kindly see, my lord, annexure C. Lord, in the page number 33.
Yes.
Last paragraph, my lord, that therefore the writ petition is allowed in the rule made absolute. Final notification is quashed. The matter stands remitted to the Assistant Commissioner Land Acquisition Officer Haveri to hold an inquiry afresh as per section 3 subclause 3 of the Act. And after
You have
notice,
only 1/3 share in 97/1.
Lord,
1/3 share in 97/1.
please, my lord, in respect of the southern portion of, my lord, the property to the extent of 3 acres of land, I have purchased it in the year 1969 itself.
Yes, but the petition was filed
Please,
challenging 1/3 share in 97/1 and full extent in 97/2A.
please,
Your subject matter of this petition is
Please.
97/1.
no, my lord, 97/2A,
2A.
please. Based on the sale deed,
2A2 is 30 guntas ida.
Lord, that is different. My lord, grievance before this honorable court, that in the year 2013-14, the Taluka surveyor, my lord, he has, my lord, conducted the survey and prepare a petty sheet. And I have challenged that petty sheet, my lord, before the DDLR, saying that without looking at into my registered sale deed and looking at the boundaries of, my lord, my purchased property, petty sheet has been prepared. Challenging that, my lord, I have challenged it, my lord, before DDLR. And, my lord, DDLR, my lord, at annexure E.
Where's your sale deed?
Sorry, my lord.
Where's your sale deed?
My lord, sale deed at annexure A.
As to extent as to.
Lord, extent is, my lord, 3 acres of land.
ಎಲ್ಲಿದೆ ಅದು?
My lord, at page number 27. My lord, fifth line, my lord, from the bottom.
ಮೂರು ಎಕರೆ.
3 acres of land has been purchased.
0 ಗುಂಟೆ. Yes.
Lordship, my lord, may kindly see, as per annexure E, my lord, at page number 47, in respect of, my lord, the findings given by, my lord, the DDLR, at para number 14, page number 47, my lord.
Yes.
Lord, may I read, my lord, for a moment? ಉಪವಿಭಾಧಿಕಾರಿಗಳು ಸದರಿ ಜಮೀನು ಖುಲ್ಲಾ ಇರುವ ಬಗ್ಗೆ ಖಾತ್ರಿಪಡಿಸಿಕೊಂಡು ಮುಂದಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಆದೇಶಿಸಿರುತ್ತಾರೆ. ಆದರೆ ವಿವಾದಿತ ಜಮೀನಿನಲ್ಲಿ ಈ ಕೆಳಗಿನಂತೆ ಜನವಸತಿ ಅಭಿವೃದ್ಧಿಯಾಗಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಖರೀದಿ ಚಕ್ಬಂದಿಯು ಭೂ ಸ್ವಾಧೀನವಾಗಿರುವ ಕ್ಷೇತ್ರಕ್ಕೂ ಹೊಂದಾಣಿಕೆ ಇರುವುದಿಲ್ಲವರಿಂದ ಭೂ ಸ್ವಾಧೀನ ಕುರಿತಂತೆ ತಯಾರಿಸಿರುವ ಪೋಡಿ ದಾಖಲೆಗಳನ್ನು ರದ್ದುಪಡಿಸುವ ಅವಶ್ಯಕತೆ ಕಂಡುಬರುವುದಿಲ್ಲ. They say that the identification of the property, it is in dispute. And my lord, in further, ಮೂಲ ಮಾಲೀಕರು ಈಗಾಗಲೇ ಎಷ್ಟು ಜಮೀನು ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ, ಎಷ್ಟು ಜಮೀನು ಅವರ ಮಾಲೀಕತ್ವದಲ್ಲಿ ಉಳಿದಿದೆ ಎನ್ನುವುದನ್ನು ಪರಿಶ್ರಮಿಸಿ ಹಕ್ಕು ದಾಖಲೆಗಳ ಬದಲಾವಣೆ ಮಾಡುವ ಅವಶ್ಯಕತೆ ಕಂಡು ಬರುತ್ತದೆ. ಮಾನ್ಯ ಉಪವಿಭಾಧಿಕಾರಿಗಳು ಆದೇಶದ ಸದರಿ ಜಮೀನು ಖುಲ್ಲಾ ಇರುವುದರ ಬಗ್ಗೆ ಖಾತ್ರಿಯಾದಲ್ಲಿ.
Where is the RTC of the property and where is the encumbrance certificate?
Lord, in respect of record of rights, my lord, annexure H, page number 72, pertaining to my property.
Where is the encumbrance certificate?
Encumbrance, my lord, I have not submitted. I will.
Get us the encumbrance certificate. As per this plan, there are so many houses which are built.
I'm sorry, my lord.
Page 47 picture alli.
Please.
There are so many houses which are built.
Lord, to that extent, my lord, I have, my lord, the petty sheet prepared by, my lord, the Taluka surveyor.
How did these houses come about?
It is also finding at page number 66 also.
Lord, for a moment.
Page number 66, it is a finding.
May I pass on, my lord, the petty sheet, my lord, prepared by the Taluka surveyor.
There are houses in the property, Patil.
My lordship, my lord, Lord, here, my lord, your lordship may kindly see. Here, my lord, they say that, my lord, in respect of this property, there is an acquisition, my lord, by the SLAO. And, my lord, in respect of this property, my lord, we say that, my lord, this is our property, agriculture land, to the extent of 3 acres of land.
There are constructions which are there in this property.
Lord,
There's a
they say
finding
that, my
on
lord,
that.
but
The
now-
respondents are in possession of those constructed properties. We can't grant you this stay that you are
Now,
seeking.
my lord, the difficulty is, my lord, in respect of open space, my lord, that before both the
Only
courts,
after
my lord, I have a
notice.
benefit of, my lord, injunction order.
Only after notice, not before.
But may I pass on, my lord?
And AGA accepts notice for respond number 1 to 4.
1 second, my lord. I have benefit of, my lord, before both the court regarding, my lord, not to alienate the property, my lord, because they are
Not
likely
to
alienate.
alienate. Not to alienate will.
There is no interim order sought for.
Lord, I have filed a separate application for
Separate
injunction.
IA 3 of 24 file ಮಾಡಿದೆ.
May I pass on, my lord, the interim order passed
Interim order.
before the trial court. Here, my lord, on the last page, my lord,
This was enforced till the impugned order was passed. This is in.
Lord, it is before the DDLR. On 5/4/2017.
29 of 2016-17.
Please.
What are you challenging here?
Lord, Annexure E and Annexure F both are challenged.
Passed by?
Lord, passed by, my lord, DDLR and also, my lord, the JDLR. That is, my lord, the respondent number 4 and, my lord, respondent number 3 and 4.
This is in which proceedings?
Lord, Annexure E is, my lord, passed by, my lord, respondent number 4.
This is in 179 of 2016-17. This order is being passed in 179 of 16-17, which came to an end on 31/8/2020, which you challenged before the DDLR.
ADLR, my lord.
ADLR in 105. Was there a stay in 105? Was there
Lord, even, my
injunction?
lord, he has a benefit of, my lord, stay order in before the JDLR also.
105 ಅಲ್ಲಿ order, interim order ಅಲ್ಲಿ.
In the final order, my lord, it has not been mentioned, but he has a benefit of, my lord.
Show us that order.
I'll produce it, my lord.
ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ? This order which you are producing came to an end on 31/8/2020.
Please.
So from 31/8/2020, you will have to show us what is the benefit of the interim order you had.
Please,
We can't change it after 4 years.
Lord, even he has a benefit, my lord, before the JDLR. I'll produce.
See, if there is a benefit, we'll extend the benefit.
Please.
If there is no order, we won't. Pass over.
Please, pass on.
29, VV Somapur.
Yes, Mr. Somapur.
Please, my lord, here in this case, the petitioner has filed an application to regrant the land which is in his possession since from his ancestors. He was cultivating the said land, my lord. And earlier, the Tahsildar has also recommended for regrant of the said land. But later on, an endorsement has been issued to the petitioner that it cannot be granted.
ಉಲ್ಲೇಖ 2 ಮತ್ತು 3 ಸರ್ಕಾರ ಪತ್ರ of 28 to 24.
Yes.
Where is ಉಲ್ಲೇಖ 2 and 3? Where are those documents?
Annexure G and H, my lord.
Annexure?
Annexure G.
G. G is 28 to 24. That is Uleka Erdo.
Yes. This land comes under the Saranjam Enams Act, Abolition Act, my lord. Not comes under the either Bombay Enams Abolition Act or certain Enams Abolition Act.
So it doesn't come under the Enams Abolition Act 1977.
Saranjam Enams Abolition Act where the Bombay Enams Abolition Act where?
You'll have to challenge Annexure G.
Yes.
You're not challenging Annexure G.
Annexure G, yes.
You're not challenging Annexure G and you're not challenging Annexure H.
I'll look into this.
Adಎರಡು challenge ಮಾಡಿದ್ರೆ ಅವರು ಕೇಳಬೇಕಾಗುತ್ತೆ. What is the applicability?
I'll note this.
Counsel for the petitioner.
Time. 2 days time.
Learned AGA accepts notice for respond number 1 to 4. Counsel for the petitioner seeks for a week's time to file necessary application to challenge Annexure G and H by way of amendment. Relist on?
Next week.
31st.
Please.
30 PNS money.
A is challenged, my lord. Annexure A is challenged, my lord. Deputy Commissioner passed order declaring a
Recorded habit.
unrecorded habit in connected matter, my lord.
And AGA accepts notice for respond number 1 to
4, my lord.
4.
Respond number
5
5.
Yaro.
Vijay Kumar Balgeri Matt. Vijay Kumar.
Please also accepts notice for respond number 6. ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀರಾ?
My lord, 6, my lord, not necessary. One of the sharer, my lord.
And counsel for the petitioner submit that respond number 6 is also a co-owner of the property in question, but could not be made as a petitioner
Yes, my lord.
due to
Not
his non-availability.
Yes, ma'am.
Hence, notice to respond number 6 is dispensed with since there is no conflict of interest between the petitioners and respond number 6. Petitioner is before this court seeking for the following reliefs. ಏನು ಅಲೋ ಮಾಡೋಣ ಏನು ಮಾಡಿಲ್ಲ ಅದು ಇನ್ನೂ
No notice, no objections, my lord. Even not issued notice.
The grievance of the petitioner is that respond number 2 has issued a notification under section 38 capital A of the Karnataka Land Revenue Act, Land Reforms Act.
Yes, ma'am.
1961, declaring the lands of the petitioner in survey number
98, ma'am. 98 bar 5.
98 bar 5
Total measuring 10 acres, my lord.
as
Unrecorded habitat.
unrecorded habitation. The submission of law and counsel for the petitioner is that the petitioner being the owner of the said land and being in occupation thereof, no notice has been issued to the petitioner, nor a public notice issued so as to enable the petitioner to submit his objection. His further submission is that if the revenue records had been perused,
Yes, ma'am.
the right title and interest of the petitioner in the said survey number would have been clear to the deputy commissioner. As such, he submits that the notification issued is without any basis and is required to be quashed. This court is coming across several matters where notifications under section 38 capital A of the Karnataka Land Reforms Act 1961 have been issued by the deputy commissioner without issuing any public notice and or even verifying the revenue records. The RTCs which have been produced along with the present petition at Annexure B indicates the right title and interest of the petitioner in respect of the aforesaid property. Such being the case, the deputy commissioner could not have, without verifying the revenue records pertaining to the relevant properties, gone ahead and issued notices, notification under section 38 capital A. The deputy commissioners will be well advised to in future refer to all the revenue documents, obtain the details as regards the properties which are proposed to be notified under section 38 capital A before issuing any notification. In the event of any entries available in the revenue records, notices would necessarily have to be issued to the persons named in the said revenue records. In the event of no entries in the revenue records being available, the notifications issued under section 38 capital A would have to record such a statement so that the same could be verified in the event of any challenge being made. The first respondent is directed to issue necessary instructions to all the deputy commissioners coming under his jurisdiction in respect of the above directions. In view of the above, I pass the following order. Writ petition is allowed. A certiorari is issued. The notification bearing dated 14/12/2021 bearing number so and so at annexure A, insofar as survey number 98/5 is concerned, is quashed. A mandamus is issued directing respondent number 3 to delete the name of the government in respect of the aforesaid land and restore the entries of the names of the petitioners in the relevant RTCs.
Third is in the event, my lord.
In the event of the deputy commissioner coming to a conclusion that the said lands are required for any public purpose, the deputy commissioner would be at liberty to initiate such proceedings for acquisition in terms of the applicable law.
Able to file an wakalat lodge.
Much obliged.
Sivan, Vadiraj.
On humble submission, it may kindly be passed or will file a memo for withdrawal, my lords.
File a memo. Petitioner is
seek,
before this court seeking for the following relief. Counsel for the petitioner has filed a memo signed by dated 23/1/2025, signed by the counsel for the petitioner. Auru sign ಮಾಡ್ತಾರೆ ನೀವು ಒಬ್ರೇನಾ?
Kindly have it tomorrow, my lords. I'll ask the party to come.
Signed by the counsel for the
Please,
petitioner.
obliged.
Accepting the memo and submission of the counsel for the petition, petition dismissed as withdrawn. Kodi.
Directed take notice. Directed.
And AGA accepts notice for respondent number
1 to 3.
1 to
3.
3. ಇನ್ನಾರು ಇದಾರಾ?
Is last. Because they have to file a suit ಆಗುತ್ತೆ. Have to file a suit.
I'm appear for petitioner in this case, my lord.
Yes.
My lord, petitioner is the Gram Panchayati president, my lord. And the respondent is the company, my lord. The property is situated Grama Panchayati village, Danapura village.
Filing this petition? What is your right to file this petition?
My lord, tax collect ಮಾಡಬೇಕು ಅಂತ as per the circular.
If you have a right under the act to take action, you can't have a mandamus from this court to respondent to pay tax to you. What is your authority to file this petition?
Panchayati president has
to file a mandamus.
Yes, sir.
Your panchayat president doesn't know what powers he has under the act. ಇದು ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ತೋರಿಸ್ಬಿಟ್ಟು ಅವ್ರ ಮೇಲೆ ರೋಪ್ ಹಾಕಕ್ಕ ಇದು
ಹಾಗಲ್ಲ ಸರ್.
ಹಾಗೆ
Already I have given the notice.
Cost and dismiss this petition. Petitioner is before this court seeking for the following reliefs. The petitioner claims to be the president of the Danapur Gram Panchayat. In whose jurisdiction it is contended that in the jurisdiction of the petitioner, the respondent is carrying on business and tax has not been paid. And there being a decision taken by the panchayat to cause a demand on the respondent, a demand has been made on 24/2024, as regards which the respondent has not made payment of the taxes. And it is in that background that the petitioner is before this court seeking for a mandamus, directing the respondent company to make payment of taxes to the petitioner panchayat. The manner in which the above petition has been filed is unknown to law. If at all there are any powers of the petitioner under the relevant act, of the panchayat under the relevant act, necessary action would have to be taken under the relevant act, and the panchayat cannot approach this court seeking for a mandamus. I am the considered opinion that the filing of the above petition in the manner as filed is a complete abuse of the process of this court to obtain orders from this court directing the respondent to make payment of taxes. In that view of the matter, I am of the opinion that costs would have to be imposed on the president who has filed it. As such, cost of rupees 10,000 is imposed, which shall be paid from the personal funds of the president and not from the funds of the panchayat. No grounds having been made out, the above petition stands dismissed.
Cost ಬೇಡ.
ಅದರಲ್ಲಿ ಏನು cost to be paid to the clerks association.
33, PB Ballari.
I am for the petitioner, my lord.
Yes.
My lord, the petitioner is the JDR, my lord. My lord, though the sufficient properties available for executing the movable properties are, my lord, the honorable court has issued an arrest warrant against the petitioner. Lordship, kindly see, my lord. On 4/3/2023, my lord, the court has issued an attachment of movables, my lord. The bailiff, my lord, instead of going to the shop, my lord, he went to the house, and thereafter, my lord, he filed
ಎಷ್ಟು amount due?
9,02,657 ರೂಪಾಯಿ.
ಎಷ್ಟು ಪೇಮೆಂಟ್ ಮಾಡ್ತೀರಾ? ಇದು 2017 ಅದರ ಮೇಲೆ ಇನ್ನ ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕಿದ್ರೆ ಇವಾಗ 20 ಲಕ್ಷ ಆಗಿದೆ.
50,000 ಪೇ ಮಾಡಿದೀನಿ ಸರ್. 50,000 has been paid.
ಬಹಳ ಚೆನ್ನಾಗಿ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರು. 20 ಲಕ್ಷ ಇರೋದ್ರಲ್ಲಿ 15,000 ಏನು?
ಅಲ್ಲ, ಅವಾಗ
ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ?
1 ಲಕ್ಷ.
8 years execution petition.
Matter was about to settle, my lord. He requested to waive off some because he has not challenged the award, my lord.
Substantial amount of 20 lakhs ಹೇಳಿ ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
ಇದು 20 lakhs ಅಲ್ಲ ಸ್ವಾಮಿ, ಬರೀ 9 ಲಕ್ಷ.
9 ಲಕ್ಷ as on 2017.
No.
Interest ಎಷ್ಟು? Interest at the rate of? ಇಲ್ಲ award ಎಲ್ಲಿ?
Award execution petition is at page number 13.
Award ಎಲ್ಲಿ?
Award copy hazard ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಎಷ್ಟು ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ? 12% 18%?
12% ಅಂತ ಹೇಳ್ತೀನಿ.
12% on 9 lakhs for 8 years.
He lost his job opportunity of.
ಅದೇ 10 ಲಕ್ಷ ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು. 20 ಲಕ್ಷ ಆಗಿದೆ. ಇವಾಗ ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಹೇಳಿ?
ಒಂದು 2 ಲಕ್ಷ ಮಾಡಿದ್ರೆ ಅಂದ್ರೆ then subsequently, my lord, I will ask him to pay, my lord, because he is not challenged the award, my lord.
We can't challenge.
I leave it to your lordship, my lord, whatever the amount he is ready to, because he is not will
issue notice.
Respond number 1.
ವೀರಶೈವ ಪಂಚಮಸಾಲಿ ಕ್ರೆಡಿಟ್ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇದಾರಾ? Issue notice to respond number 1 to 3 returnable by emergent notice returnable by 17th February. The operation of the order dated 20/11/2024 issuing an arrest warrant to the petitioner is suspended till the next date of hearing, subject to the petitioner making payment of a sum of rupees 3 lakhs to respond number 1 on or before
10 days time may begin, my lord.
On or before 3rd February.
Please.
And filing an acknowledgement thereof before this court.
Please.
If acknowledgement is not filed by 5th February, the interim order above passed will automatically stand vacated.
Please.
Relist on 17th. Process fee and copies to be furnished by end of day 24th January, failing which the interim order will stand automatically vacated.
Please.
34, DM Malli.
Petitioner.
Yes.
Plus the petitioner of the JDR. Plus petitioner of the JDR.
JDR.
Plus suit is decreed. Plus suit for specific performance. But EP has been filed.
Plus in EP, item number 7 is filed. Plus page number 42, annexure G. Plus the direct the ADLR to conduct the survey, to visit the property and plus identify the measuring and submit the duly prepared map. Plus the kindly see page number 38, annexure F plus daily plus the typed copy.
38.
38 plus typed copy at page number 40 plus daily files plus filed report plus may I read? May I read?
ಏನು ಓದ್ತಾ ಇದ್ದೀರಾ?
Plus bailiff report. Bailiff report. Plus delivery warrant has been issued. Plus the bailiff has filed a report to the court. Plus may I read?
Page?
Page 40. Typed copy.
Yes.
May I read?
Page 14 judgment ಇದೆ. 14 or 40 na?
40 malars.
40.
Typed copy at annexure F. Yes. May I read? ಬಿಲಿ ವರದಿ ಮಲರ್ಸ್ 22-23 ಹಾವೇರಿ ನಗರದಲ್ಲಿ ಮೆಹಬೂಬ್ ನಗರಕ್ಕೆ ನಾನು ಮತ್ತು DHR ಅವರು ಕೂಡಿಕೊಂಡು ಹೋಗಿ ಮಿಲ್ಕನ್ ನಂಬರ್ ಡೆಲಿವರಿ ವಾರಂಟ್ ನಮೂದು ಇರುವ ಕಬ್ಜಾ ಆಗತಕ್ಕ ಆಸ್ತಿ ನೋಡಲಾಗಿ ವಯಸ್ ನಂಬರ್ 98/6 ಡಿಗ್ರಿ ಕಾಪಿ ತೋರಿಸಿದ ಪ್ರಕಾರ ಖರೀದಿ ಪತ್ರ ನಕಲಿಯ ತೋರಿಸಿದ ಪ್ರಕಾರ ದಾವಾ ಆಸ್ತಿಗೆ ಹಾವೇರಿ ತಾಲೂಕು ಪೈಕಿ ಹಾವೇರಿ ಶಹರದ ಹದ್ದಿನಲ್ಲಿ ಬರುವ ರಿಸಾ ನಂಬರ್ 46 5 ಎಕರೆ ನೆದರ ಪೈಕಿ ಮಧ್ಯಭಾಗ 2 ಗುಂಟೆ ಜಾಗೆ ಮತ್ತು ಪ್ಲಿಂತ್ ಸಹಿತ ಕುಲ್ಲ ಜಾಗೆ ಚಕ್ಪಂದಿ ಆಸ್ತಿ ಕೆಳಂತಿರುವ ಮ್ಯಾರಿ ಈ ಮೇಲ್ಕಂಡ ಚಕ್ಪಂದಿ ಮಧ್ಯದಲ್ಲೂ ಕಬ್ಜಾ ಆಗತಕ್ಕ ಆಸ್ತಿಯ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ಆದೇಶ ಪ್ರಕಾರ JDR ಇದ್ದವರು DHR ಅವರಿಗೆ 2 ಗುಂಟೆ ಕುಲ್ಲ ಜಾಗ ಪ್ಲಿಂತ್ ಸಹಿತ ಕಬ್ಜಾ ಕೊಡಿಸುವ ಆದೇಶವಾಗಿದ್ದು ಈಗ ಸದರಿ ಕಬ್ಜಾ ಕೊಡಿಸುವ ಆದೇಶವನ್ನು ನೋಡಲಾಗಿ ಸದರಿ ಕಬ್ಜಾ ಆಗತಕ್ಕ ಆಸ್ತಿಯಲ್ಲಿ ಪ್ಲಿಂತ್ ಹಾಗೂ ಕುಲ್ಲ ಜಾಗ ಇರುವುದಿಲ್ಲ. ಸದರಿ ಮೇಲ್ಕಾಣಿಸಿದ ಚಕ್ಬಂದಿ ಮಧ್ಯದಲ್ಲಿ 2 RCC ಮನೆ ಹಾಗೂ ಇದರಲ್ಲಿ ಒಂದು ಮನೆ ಮೇಲ್ಭಾಗ ಒಂದು ರೂಮ್ ಇರುತ್ತದೆ. ಮನೆಯ JDR ನೆದ್ದವರ ಮತ್ತು JDR ನೆದ್ದವರು ಕೊಟ್ಟಂತ ಬಾಡಿಗೆದಾರರು ಸಹ ಮನೆಯಲ್ಲಿ ವಾಸವಿರುತ್ತಾರೆ. ಕಾರಣ ಸದರಿ ಆಸ್ತಿಯನ್ನು JDR ನೆದ್ದವರ ತಾಬಾಕ್ಕೆ JDR ಅವರಿಗೆ ಕಬ್ಜಾ ಕೊಡಿಸಬೇಕಾದ್ರೆ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಪ್ಲಿಂತ್ ಇರುವ ಹಾಗೆ ಕಟ್ಟಡ ಮನೆಯನ್ನು ಕೆಡವಿ ಕೊಡಿಸಬೇಕು ಅಥವಾ ಇದ್ದ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ 2 ಗುಂಟೆ ಇದ್ದಂತ 2 RCC ಮನೆಗಳು ಮತ್ತು ಒಂದು ಮನೆ ಮೇಲ್ಭಾಗದಲ್ಲಿ ಒಂದು ರೂಮ್ ಸಮೇತ ಕಬ್ಜಾ ಕೊಡಿಸಬೇಕು ಎಂಬುದನ್ನು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ಸೂಚಿಸಿದೆ ನೋಡಿದೆ. ಪ್ಲಸ್ ನೌ ವಿ ಆರ್ ಫೈಲ್ item number 7 annexure G page number 42. Direct the ADLR highway to visit and visit the suit property and identify the land and to submit the duly prepared map. Now the trial court has rejected my application.
Why do you want that? It's already identified the construction is there and the report is there.
No, as per agreement there is a vacant khali jaga.
You are only vacant to even you construction ಮಾಡಿ ಬಾಡಿಗೆ ಕೊಟ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? you have constructed.
That is also filed
ಬೇರೆ ಯಾರು
application.
ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿಲ್ಲ, ನೀವೇ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿ ಬಾಡಿಗೆ ಕೊಟ್ಟಿರೋದು.
Now
You can't take advantage of that.
now I filed application checking plus without appointing the court commissioner the trial court has
Not required. Notice to respondent is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. A suit in OS number 98 of 2006 had been filed by the respondent seeking for specific performance of an agreement to sale, which came to be decreed on
17/3/2008.
17/3/2008. Pursuant thereto, execution proceedings had been filed in execution case number 70 of 2013. When the bailiff had been directed to inspect the property and submit a report, which has been so submitted on 22/2023, indicating that the subject property shown in the decree to be a vacant site now has certain construction and is in occupation of the tenants of the judgment debtor. Pursuant thereto, the petitioner had filed an application and order 26 Rule 9 and 10, read with section 151 of the Code of Civil Procedure, seeking for appointment of a ADLR, seeking for appointment of commissioner, namely the ADLR, to visit the property, identify the same, and submit a duly prepared map to facilitate the execution of the decree, which having been opposed by the respondent has been rejected by the trial court. Challenging the same, the petitioner is before this court. The submission of learned counsel for the petitioner is that the ADLR's report is required to identify the property, since what is required to be sold is only a vacant land and not one with construction, and the constructed area cannot be sold to the cannot be made subject matter of sale deed to be executed by the court. in favor of the decree holder. I am unable to agree with the submission made by the counsel for the petitioner, inasmuch as the construction has been put up by the judgment debtor and has been leased by the judgment debtor to his tenants. The judgment debtor cannot be allowed to take advantage of his own wrongs and now contend that since there's a construction which has been put up, the sale deed cannot be executed without identifying vacant land. The judgment debtor having chosen to put up construction during the pendency of the subsequent to the agreement of sale, a decree having been passed, the judgment debtor is bound to execute a sale deed in favor of the decree holder. I am the constant opinion that the application for appointment of commissioner is only to protract the proceeding and serves no other purpose. There is no requirement to appoint a commissioner as sought for. The trial court, I do not find any infirmity in the order of the trial court. The petition stands dismissed at the stage of admission itself.
Sachin Angadi.
Lord, in this case, my lord, the government lordship has directed the state to verify the facts, my lord. Last occasion, my lord. May I...
Yes, Mr. Kannur.
Next week, your lordship. I have not received instruction. Next week, your lordship.
And AGA submits that he is yet to receive instructions released on 31st January.
31st was on next month, first week, my lord. 4th of
Released on 6th February.
much of the, in preliminary hearing, my lord.
Same stage. 36 SS Patil.
Petitioner filed this writ petition for quashing of annexure F, my lord. The petitioner and my lord, respondent are my lord, husband and wife, my lord, and their marriage was solemnized on my lord 20/12/2015, my lord. After 1.5 years, my lord, petitioner respondent left the company of the petitioner, my lord. My lord, after several attempts, my lord, she not came back, my lord. Hence, my lord, in the year 2018, my lord, petitioner filed divorce petition. In the year 2019, my lord, respondent, my lord, filed, my lord, restitution of conjugal rights, my lord. After lapse of, my lord, 7 years from the separation, my lord, in the year 2024, my lord, she filed the, my lord, petition.
Divorce agidya?
My lord, it is pending for consideration, my lord. Lord, already, my lord, in my lord, restitution of conjugal rights, maintenance is awarded, and I am paying the maintenance, my lord, as per instruction of the client, my lord. Once again, my lord, in this petition, she seeks for, my lord, maintenance, my lord. The double, 2 times maintenance, my lord. She has never challenged the maintenance awarded by the trial court before this honorable court, my lord.
Where is that order?
Maintenance order is at, my lord, annexure, my lord, annexure D, page number 36, my lord. Operative portion is at, my lord, page number 42, my lord. Order, my lord, with lordship permission, may I read, my lord? The petitioner
Now,
is
what happened in the DV case, in criminal miscellaneous DV case, there's no order passed, only service of notice has happened.
ಇಲ್ಲ ಸ್ವಾಮಿ, restitution of conjugal rights ಅಲ್ಲಿ ಮೇಂಟೆನೆನ್ಸ್ ಆಗಿದೆ.
ಅದ್ರಲ್ಲಿ ಆಯ್ತು, ಇವಾಗ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ ನೀವು?
Proceedings initiated in DV Act, my lord. I have challenged before
place this facts before that court.
My lord,
and ask for quashing of those proceedings the way that you have asked for.
Lord, ಎರಡ್ ಟೈಮ್ ನನ್ನ ಮೇಲೆ ಇದು ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ ಐ ಆಮ್ ಬಿಫೋರ್ ದಿಸ್ ಆನರೇಬಲ್.
ಅಲ್ಲಿ ಹೋಗಿ ಹೇಳಿದ್ರೆ ನೀವು ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ, ಟೋಟಲ್ ಏನಾದ್ರು ಜಾಸ್ತಿ ಮಾಡ್ಬೇಕು ಕಮ್ಮಿ ಮಾಡ್ಬೇಕು ಎಲ್ಲ ಮಾಡ್ತಾರೆ.
She never, my lord, challenged, my lord, this order, my lord, maintenance petition before the
but that is for that court to decide, not for this court. The Supreme Court has held that multiple maintenance could be provided, but everything has to be taken into consideration.
Please, my lord. And my lord, my humble submission before honorable court is, my lord, there is a lapse of 7 years, my lord, after the separation, my lord.
That will have to be considered in that matter. We can't quash that proceedings under DV Act on that ground. Notice to respondent is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The petitioner claims to be aggrieved by the issuance of summons in criminal misdemeanor number 150 of 2024, filed under the Protection of Women from Domestic Violence Act 2005. The submission of learned counsel for the petitioner is that in the said proceedings, maintenance is sought for, additional amount of maintenance is sought for. Maintenance having already been
Serial number 38.
awarded in MC number 51 of 2019, no further maintenance amounts could be awarded in criminal misdemeanors number
150 of
150 of
2024.
2024, which has been filed five years after MC number 51 of 2019 had been filed. And as such, he submits that those proceedings are non-est and are required to be quashed. I am unable to agree with the submission made by the Mantesh Arpati learned counsel for the petitioner, inasmuch as proceedings under section 12 of the Protection of Women from Domestic Violence Act 2005 is always available to the woman. If at all the petitioner has any defense in respect of the payment of maintenance amount or the quantum, the same could be placed before the said court, which would necessarily have to be considered by the said court before passing any orders in the said proceedings. With the above observation, the petition is disposed.
Please.
37, Vidyavati, Puttur Setter.
I undertake to file wakalat for first respondent.
For respondent,
1.
she so and so undertakes to file wakalatnama for respondent number 1. Yes, what is?
Please, Mela.
Which
The
is
respondent
directly
number, the respondent number 2 filed an IA number 13 for reallocation of the share. That is held by the court below. That, my lord, that reallocation is correct and one of share is made, my lord. What happened in this case, my lord? The petitioner is a legatee of one Channava. Channava has two sons, my lord. Thereafter, the Channava has filed a OS 100 of 2010 for partition. And 1/3 share is allotted and it is attained finality in RFA. In the RFA, my lord, the bill is produced and the Honorable Court said that, my lord, in the RFA, my lord,
On an application, this has been done without inquiry?
No, it is inquired, my lord. After
Evidence
direction of
lead
the
agide.
Honorable Court.
evidence agide.
Application and.
It is a registered will and witnesses is also put in witness box, my lord. Only the court below suspicious circumstances. This is the only finding by the court below, my lord. Your lordship, kindly come to page number 27.
This will require hearing.
My lord.
This will require hearing.
Yes,
You
yes.
stay this order.
Appeal provided, my lord. Because they have to challenge the findings on the will as well as the allocation of shares, my lord. Therefore, there is a appeal lies to either on the basis of valuation, my lord, either it is to district court or before this honorable court.
It's a finding on fact. Writ petition barala. I'll ಹೋದ್ರೆ stay ಮಾಡ್ತಾರೆ.
Please, my lord.
Petitioner is before this court seeking for the following reliefs. What is challenged is a finding of fact rendered in FDP 21 of 2014, wide order dated 4/1/2025, reallocating the share between the parties. The petitioner as an alternative efficacious remedy in terms of appeal, reserving such liberty and leaving all questions open, the petition stands disposed.
In the meanwhile, my lord, because they are hurriedly enter their name in the record of rights, my lord. Now the legatee name is there in the record of rights.
ಇನ್ನ ಹಾಫ್ ಶೇರ್ ಆಗ್ಬಿಟ್ಟು ಇನ್ನ ಫರ್ದರ್ ಕಮಿಷನರ್ ಎಲ್ಲ ಆಗ್ಬಿಟ್ಟು ಮುಂದೆ ಹೋಗ್ಬೇಕು. ಬರೀ ಇದು ಪ್ರಿಲಿಮಿನರಿ ಡಿಗ್ರಿ, ಸೆಕೆಂಡ್ ಪ್ರಿಲಿಮಿನರಿ ಡಿಗ್ರಿ ಇದು.
Till the filing of appeal period, my lord.
ನಾಳೆ ಫೈಲ್ ಮಾಡಿ ಮೇಡಮ್, ಏನಿದೆ.
38, Rajshekhar Halli.
Please, my lord.
Yes.
My lord, the impugned order is annexure M, page number 82, my lord. This is passed on issue number 5. Preliminary issue number 5 regarding court fees, my lords.
Yes.
Page number 92, issue is like this, my lord. Page number 92, relevant page, issue number 5. Whether plaintiff proves that court fee paid by the defendant number 1 on the said relief is not correct and proper. Lord, the question is
by defendant number 1 on the counterclaim.
How the counterclaim? Counterclaim. Lord,
Yes.
I am for the plaintiff. Originally, I was filed a suit for declaration and injunction, my lord. The subject matter of the suit is saided, my lords. The suit property was purchased by me for consideration of 38,50,000, my lords. Thereafter, my lords, I was withdraw the suit, my lords.
Yes.
Thereafter, counterclaim is in force. I was filed an application under section 11 of Karnataka Court Fees and Suits Valuation Act, directed to the respondent number 2, respondent 1, to pay the correct court fees and valuation on the subject matter of the suit, my lords. Immediately what happened, my lord, trial court was rejected my application. Thereafter, my lord, I was filed a writ petition before this honorable court, my lord. The honorable court was disposed of a writ petition with direction to that, my lords, to dispose of the matter by considering the issue number 5 as a preliminary issue by invoking section 38 of Karnataka Court Fees and Suits Valuation Act.
You respondent, right?
No, respondent number 2, no claim against them, my lords, formal parties, my lords.
She so and so accepts notice, AGA accepts notice for respondent number 2. Issue notice to respondent number 1, returnable by 19th March. The further proceedings in OS number 140 of 2022 pending on the file of the senior civil judge and JMFC Kallatgi is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 24th January. An acknowledgement of service of notice on the counsel appearing for respondent number 1 before the trial court to be filed with the registry of this court by end of day 31st January. Failing either of which, the interim order will stand automatically vacated.
Lord, next date is 25th, my lord, before trial court, my lord. Hand delivery, my lord.
Counsel for the petitioner is also permitted take out.
Could this,
Is hand delivery na? Hand summons to respondent number 1. Is upload aga.
B group matter 39, Vidya.
Records. Bandidya, Mr. Kannur?
Milords, I pray for short accommodation, Milords.
Why?
The council is not in station. Next week, any date may be fixed.
2007 matter. At the request of counsel for the petitioner, relist on 25th January, Saturday.
Milords, next week, Milords.
Next week. Relist on 31st January. It is made clear that no further adjournment would be granted if arguments are not advanced by the petitioner on that date. Petition would be liable to be dismissed for non-prosecution.
40, Srinand Pachapure.
Appear for the petitioner's counsel in this. Writ petition
Who is
filed.
for the respondents? Mr. S.S. Patil, Santosh Malgaudar.
Santosh Malgaudar, SP Dodgaudar.
Retired, my lord. Santosh Malgaudar and SS Patil retired. Now AC Chaklabi and SP Dharwad.
SP Dodgaudar.
Since AC Chaklabi and SB Dodugowda have entered appearance for respondent. Registry is direct delete name SS Patil, Santosh Bimalgowda, Rajshekar Rai Saudati and Pooja R. Saudati as that appearing for respondent number 1A to 1A bracket A to E. Where is it?
Not sure, man.
Instructing
My only
counsel,
request is kindly don't pass over the matter, man, because at 2:30 I have one matter before your lordship, that KIDB matter, and also one matter before Court Hall 2. Then if there's, no, if pass over
2010.
bad, pass over
Bad
bad,
answer.
bad, because one
2010 matter.
Court Hall 2 also have a batch of.
ಎಲ್ಲ ಮುಗಿಸ್ಕೊಂಡು ಬನ್ನಿ 2010 matter ಹೆಂಗ್
I understand. I'm ready, man. I can start even now.
you are here you can
Yes, man.
your flight is at 8 o'clock so no problem.
No, in fact, to be honest, man, I have a flight booked for tomorrow also, because Court Hall 2 indicated that may.
Then even better.
I'll take a chance, man. I'll come back at 2:30. Well, it's good. Oh, correct. Yeah, that's okay. But
Pass on.
just one, your lordships could call it out at 4 o'clock, because division bench is breaking, I'm told, at 4 o'clock. So I'll come back at 4 o'clock without.
Yes.
Grateful.
41.
In this matter, my lord. So, the out of 5 owners, my lord, that is who are the maternal uncle of the.
ಯಾರಪ್ಪ ಇವಾಗ ಇದು respondent VK Patil, SP Patil, SP Deshpande.
Last occasion also, my lord, they are not appeared. Matter was passed out. Again, they are.
If none were out to appear ಅಂತ ಹೇಳಿದೀವಿ already. Yes.
There are 5 owners, my lord, 2 guntas, 2 owners.
AGA ಯಾರು? Mr. Kannur, ready? Yes.
2 gunta, 2 owners is the, my lord, the suit property. There are 5 owners, my lord, who are maternal.
Suit property.
Suit property, my lord, the
KLR.
property are gifted, my lord, by the, my lord, the maternal uncles of the, my lord, the present petitioner. Out of 5, my lord, owners, my lord, only 3 brothers have, my lord, the executed oral gift, my lord, Hiba.
Two guntas and 12 annas
12 annas, my lord.
Was owned by 5 persons.
5 persons, my lord, who are maternal uncles of the, my lord, the present petitioner. Out of 5, my lord, only 3 brothers, my lord, 3 owners, my lord, they have executed the, my lord, the oral gift. And based on that, my lord, I have given Verde and it was effected.
Favor of the petitioner.
Petitioner,
Mohammed Abdul Karim Mujawar.
who is died during pendency, my lord, and his LRs were brought on record.
Mohammed Abdul, he was not the owner. He was not one of the 5 owners.
No, my lord, not.
Yes.
And I gave Verde, my lord, and it was mutated in favor of, my lord, the present petitioner. And thereafter, my lord, the remaining 2, my lord, owners, my lord, they have preferred appeal before the assistant commissioner, stating that they have not executed the gift, my lord. It's only other 3 owners have executed. And the assistant commissioner, my lord, looking into that, my lord, he has remanded back the matter to the, my lord, the Tahsildar, to verify whether, inquire and verify whether, my lord, the owners, my lord, all the owners are executed or not on that ground. And DC has also confirmed the same.
The gift shall enable to the extent of their share.
But your lordship, page number 12, your lordship making this. The findings given by the deputy commissioner,
Page number 12.
12, your lordship, last paragraph.
Yes.
I have heard the arguments from both the sides and produced the records of the case. On purpose of the oral gift submitted along with a worthy application dated 19 to 2003 by the revision petitioner, it reveals that the land in dispute is not mentioned.
Not mentioned.
No, no, that is no declaration oral gift, my lord, I have produced at Annex D, my lord, where in the description of the, my lord, the land is stated. Page number 17, my lord, Annex D.
Annex D.
D, my lord, Annex D, page number 17.
17.
17.
Just on more number.
Once, Annex D, my lord. Yeah, in this, my lord, there is a clear description of the, my lord, the suit property has been stated. This is the, my lord, the oral gift, my lord.
Old number 133/2, new number 133/9 ಅಂತಿದೆಯಲ್ಲ.
ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಇದೆ, ಪೇಜ್ ನಂಬರ್ 18.
ಪೇಜ್ ನಂಬರ್ ಸ್ಕೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂದ್ರೆ ಬಾಡಿಯಲ್ಲಿ ಸ್ಕೆಡ್ಯೂಲು ಇದೆ.
Schedule ಇದೆ, my lord. Next page ಅಲ್ಲಿ.
ಇನ್ನೇನು how can the deputy commissioner come to this kind of a conclusion?
And I was put into possession and also, my lord, taken loan, and it is thereafter, my lord, it was challenged.
It's a very bad order.
It is contrary to this, Your Lordship.
Petitioner is before this court seeking for the following release. It is claimed that the land bearing RS number 133/9, measuring 2 guntas and 12 annas of Piranwadi village in Belgaum district was owned by 5 persons, namely page 5 alide. Out of the aforesaid 5 persons, sale number 2, 3 and 4 are stated to have executed a oral gift in favor of the deceased petitioner, now represented by his legal representatives. In furtherance of which, a declaration was filed, signed by the aforesaid persons named at 2, 3 and 4, in furtherance of which a mutation entry was made in ME number 1857 of 2002-03. The said entry was challenged by the person named at serial number 2, 4 and the legal representative of the person shown at serial number 5 before the Assistant Commissioner Belgaum, who allowed the appeal and set aside the mutation entry while ordered at 13/4/2007 on the ground that there being 5 joint owners, only 3 joint owners having executed a oral gift without joining the other 2 joint owners, the gift cannot be given effect to, and had remanded the matter to the Tahsildar for fresh enquiry. A challenge being made before the Deputy Commissioner, while the impugned order dated 9/12/2010 dismissed the revision petition on the ground that the oral gift, that the declaration does not indicate the details of the property gifted and accepted by the donee, as also on the ground that only 3 of the owners had gifted the property by way of a hiba. It is challenging saying the petitioner is before this court. The counsel for the petitioner submits that the impugned order passed by the Deputy Commissioner is contrary to the document, namely the declaration. A ex facie perusal of the said document would indicate that there is a detailed schedule with boundaries which has been provided, and as such, the Deputy Commissioner could not have come to a conclusion that the details of the property were not provided. Secondly, he submits that irrespective of whether the other co-owners, the gift by 3 of the co-owners would inure to the benefit of the late petitioner and thereafter to his legal heirs who have been brought on record. which fact has not been considered either by the Deputy Commissioner or the Assistant Commissioner. Learned AGA would seek to support the order of the Assistant Commissioner and Deputy Commissioner by contending that the entry cannot be made for the entire property, but could be only made in respect of the property gifted by the three persons aforesaid. And as such, the order passed is proper and correct, and the Tahsildar would hold necessary inquiry in relation thereto. Heard so and so peruse papers. It is not in dispute that the subject property was owned by 5 persons and only 3 persons have executed the oral gift, and a declaration in relation thereto has been filed. Thus, the persons named at serial number 1 and 5 above have not executed any gift in favor of the deceased petitioner. As such, their right in the property has not been gifted, and the petitioners cannot claim any right in relation thereto. As rightly contended by the learned AGA, the petitioners can only claim interest in respect of the property, can claim only right as regard the interest of persons named at serial number 2, 3, and 4 above, who have gifted the property and executed a declaration. The petitioner would therefore be only entitled to 3/5 rights in the property, the remaining 2/5 right not having been gifted to the father, to the late, to the original petitioner. In that view of the matter, the orders passed by the Assistant Commissioner and the Deputy Commissioner would require modification. And as such, I pass the following order. A writ petition is partly allowed. The order passed by the Assistant Commissioner at Annexure C, dated 13/4/2007, is modified. The matter is remitted to the Tahsildar for holding an inquiry and cause the entry of the name of the petitioner in respect of 3/5 of the land in old number 133/2 and new number 133/9, and retain the name of the persons named at, retain the name of Sri Mujawar Sadruddin Maktoum Saab and Mujawar Mohammed Saab Sadruddin in respect of the 2/5 share, in respect of their 1/5 share respectively. The inquiry to be conducted and completed within a period of 6 months from the date of receipt of a copy of this order. Please.
42, Ahmad Ali, J. Rahman Shah.
And for respond number 2, my lord. Last time also they are not present.
None appears for the, despite the order dated 7/1/2025, the petitioner is before this court seeking for the following relief. Despite the order dated 7/1/2025, none appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
43, Hanmant Reddy Sahukar.
I request for some time for this reason. I was told that not some suit is filed. I will verify and.
If the counsel for the petitioner is present and seeks for a week's time to obtain instructions as regards whether a suit is filed in respect
No,
of the
I was told
subject
that the suit is filed and it is there and it is
and is
disposed.
still pending.
ಇಲ್ಲ ಅದೇನೋ ಡಿಗ್ರಿ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರು. Unless I look into it, I can't say.
Whether a suit has been filed and is still pending, then everything is open for you. We list on 31st. If arguments are not advanced on the next date of hearing, the petition will be liable to be dismissed
No, if it
for
is any,
non-prosecution as
Already.
already observed in the earlier order.
Sorry, man, on that day I was held up in the other court for compromise. I did not.
ರೆಗ್ಯುಲರ್ ಬರೋರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮ್ಯಾಟರ್ ಇಸ್ ಡೆಡ್, ಅದಕ್ಕೆ ಬರ್ತಾ ಇಲ್ಲ ಅಂತ. 2 ಸತಿ ಫೋರ್ನೂನ್ ಅಂಡ್ ಆಫ್ಟರ್ನೂನ್ 2 ಸತಿನೂ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮ್ಯಾಟರ್ ಇಸ್ ಡೆಡ್.
Yes.
ಇಲ್ಲಿ ಎವ್ರಿಬಡಿ ಅಪಿಯರ್ಸ್, ಬೆಂಗಳೂರಂಗೆ ಜಾಸ್ತಿ ಅಂತಲ್ಲ,
Correct.
ಇಲ್ಲೇ 5 ಕೋರ್ಟು
ಇಲ್ಲ, ಇದು ಮೀಡಿಯೇಷನ್ ಒಂದಿರುತ್ತೆ, ಹಂಗಾಗಿ ಸೊ
ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡೆಡ್ ಮ್ಯಾಟರ್ ಅಂತ ಒಂದು ಆಪರ್ಚುನಿಟಿ.
Yes, yes. If a suit is declared, then I will file a memo for withdrawal.
Yes.
Much.
Before VS Kamte.
This matter arise under the
Litigation was pending, you will obtain instructions ಅಂತ ಹೇಳಿದ್ರು. Mr. FB Patil.
FB Patil.
In fact, matter arise under the petition proceedings, I had taken last time, since 2011 matter, several suits were filed by both the parties. In fact, I was not able to contact the parties. Nevertheless, this is a case where the entries.
You are ready. You are ready in this.
I should get instruction what has happened subsequently, because ultimately.
If they are not responding to you,
of course,
we
I was
can't
not
give you
able
time.
to.
There's no point in holding a 2011 matter if they are
I
not
said so because the entries sought to be in the revenue
We'll
records.
pass over, let the other side come, then we'll take it up. Pass over.
It's a pass over short accommodation so that like will mele, they are claiming entries on the basis of
None
will.
appears for the respondents. Counsel for the petitioner also seeks for a short accommodation to get ready and address his arguments. If none were to appear for the respondent on the next date of hearing, the matter would have to be taken up for consideration on the basis of submission made by the counsel for the petitioner. If arguments are not advanced by the counsel for the petitioner, petitioner would be liable to be dismissed for non-prosecution. Relist on 31st.
Please.
45 then 46, Jagdish Patil.
In this matter, I appeal for petitioner, my lords. Seeking quashing of the order passed by the deputy commissioner, my lords.
Yes.
My lords, the deceased petitioner number 1 and respond number 4's father were the owner of the property bearing survey number 501/1A, measuring 2 acre 13 guntas, my lords, of Solapur village. The land in question was originally standing in the name of one Srimati Neelava, my lords. She had 2 sons by name Appanna and Bandappa, deceased petitioner number 1 and father of respond number 4, my lords. In the year 1983, they have made a oral partition deed, my lords, wherein western half portion was granted to petitioner and eastern half portion was granted to father of respond number 4, my lords. Thereafter, my lords, the deceased petitioner number 1 had dug an open well in the western side of half share, and the work was completed in the year 1985. Accordingly, mutation entry was entered, my lords, by the revenue inspector in column number 11 on 27/2002, my lords. Thereafter, my lords, after the death of father of respond number 4, the respondent number 4 preferred an appeal before the assistant commissioner after 4.5 years, stating that after the death of respond number 4's father, entry was effected and revenue inspector without notice behind the back of father of respond number 4 has passed order. After hearing both the parties, my lords, the same was dismissed. Being aggrieved by the same, the respond number 4 preferred an appeal before the DC, wherein it was contended that after the death of respond number 4's father, revenue inspector effected the entry in column number 11, and without considering the facts and circumstances of the case, they have allowed the revision petition, my lords.
Annexure E.
Annexure E at page 25, my lord.
So you're challenged only the entry made as regards the well,
please,
not as regards the name of anybody.
No, ma'am.
Column number 8.
Please.
Column number 8 ಏನಕ್ಕೆ? Where is the RTC? What is the entry made?
Mutation entry, my lord said.
RTC.
RTC ಅಲ್ಲಿ.
RTC they have not produced, we have not produced, my lords.
ಅದೇ ಮೇನ್ ಅಲ್ಲಪ್ಪ. ಇಲ್ಲಿ ಇದೆ
RTC
ಅಲ್ಲ RTC. You have produced.
A record of it at page 19.
ಬಾವಿ. ಕೇತ್ವಾರ ಪ್ರಕಾರ ನೀರಾವರಿ Why a well cannot be mentioned in column 8, Mr. Kannad?
Column 11, your lordship, acquisition of the.
Column 11 ಅಲ್ಲ, 8 ಇದೆ. 8 ಕೇತ್ವಾರ ಪ್ರಕಾರ ನೀರಾವರಿ. Well is also ನೀರಾವರಿ ಅಲ್ವಾ?
ನೀರಾವರಿ.
It is also, your lordship.
ಯಾರ ಹೆಸರು ಇಲ್ಲ. Column 8 ಅಲ್ಲಿ ಬರೀ ಬಾವಿ ಅಂತ.
In the half portion of the property, your lordship, well is there. It has to be entered.
So it has been entered.
So long as it is there, it has to be entered.
Because when
The
he has
deputy commissioner says,
then when he has become the owner of the property, will half share along with the well.
deputy commissioner says under section 127 and 128, it does not come. Certification of the mutation entry in question, the order passed by the Assistant Commissioner Belgaum are without jurisdiction since column number 8 of the record of rights is specifically meant for entering source of water. Therefore, entry of well cannot be incorporated in column number 11.
In exercise ಬರೀತಾರೆ. In the annexation mutation entry, it is mentioned it has to be entered on column 11 ಅಂತ ಹಾಕ್ತಾರೆ.
Column number 11 ಅಲ್ಲಿ ಬರಲ್ಲ. He is right in that. Column number 8 ಅಲ್ಲಿ entry ಆಗಿದೆ.
It is only finding that in column 11 it cannot be.
ಬಾವಿ ಅಂತ ಹಿಂಗೆ 11 ಅಲ್ಲಿ ಹಿಂಗೆ ಎಂಟ್ರಿ ಮಾಡ್ತಾರೆ. There's not any other right. Right to access or right to this one, that will come. There's nothing wrong. Column number 8 ಅಲ್ಲಿ entry ಮಾಡಿದ್ದಾರೆ. Please. Petitioner is before this court seeking for the following reliefs. The petitioner is aggrieved by the order dated 9/6/2011 of the Deputy Commissioner, setting aside the order of the Assistant Commissioner directing the entry of a well in column number 11 on the ground that no such entry could be made in column number 11. The contention of the learned counsel for the petitioner is that a well has been dug by the petitioners, predecessor of the petitioner, and as such, the right to use the well would have to be entered into in column number 11. And as such, the order of the Deputy Commissioner, setting aside the order of the Assistant Commissioner who had directed such entry, is not proper. Heard learned counsel for the petitioner and learned AG and counsel for the petitioner, learned AG and peruse papers. This short question that would arise for consideration is whether a owner of the property or a person claiming any right in the property can seek for entry of a well in column number 11 when there is a specific column provided thereto in column number 8 of the RTC. In the present matter, the right of the parties in respect of the title of the parties in respect of the subject property is not an issue. Column number 11 relates to other rights and charges as regards the property for which the RTC is issued. The other rights would necessarily mean and include any rights in the property like easementary rights, mortgage rights, or the like. The existence of a well and causing a entry of a well in column number 11 would neither confer any rights nor would it amount to other rights coming within the purview of column number 11. Column number 8 of the RTC deals with the source of water for irrigation, for agriculture. In the present case, there is an entry made of a well in the said column number 8. Such entry, made in column number 8, in my considered opinion, would be sufficient. And there is no entry which is required to be made in column number 11. No, there is no infirmity in the order passed by the Deputy Commissioner. The petition stands dismissed.
Forty-seven urgent, 48, PV Gunjal.
Mr. Gunjal.
I'm unable to come to the court today for some family commitment. Tomorrow it may be taken up, my lord.
If you want to address arguments through VC, it is fine.
I don't mind. I would not mind. I'll make my efforts. I don't mind, my lord. In fact, I'm ready. But, my lord, I will go ahead with the matter.
Mr. Mandagani is here. Ready? Mandagani?
Please.
Here.
My lord, the petition, the property shown at paragraph number 2, 4 distinct properties belong to the respondent's family. The petitioner therein were the cultivators of the said family, under the said family. With the coming into force of the Land Revenue Act, they made an application for grant of occupancy rights. The same came to be allowed, my lord. And the respondents accepting the said order received their compensation also. However, as the said order was not signed by all the members of the tribunal, the matter was taken up for reconsideration in the year 1994, my lord. At that time, the uncle of the petitioner, one by name Ningappa, is said to have made given a statement saying that they are in possession of only a part of survey number 117 but 2B, which measures 2 acres and 20 guntas. On the basis of this statement, there was some modification made in the grants, and only 32 guntas, all the other properties, whatever was granted was retained. However, as far as property number
118 but 10 also has been reduced.
That is the littlest one. They are not concerned. We are concerned. We are at the moment only this one.
177 bar 2B.
Is 117 bar 2B, where initially and the entire 2 acres and 20 guntas had been granted to the petitioners.
Yes.
However, during reconsideration, only 32 guntas have been granted. Being agreed by this order, the petitioners are before the Honorable Court. My lord, it can be seen that even the respondents in their second statement say that the petitioners were cultivating half of the said property, which means around 1 acres and 10 guntas. That is 50 guntas. That is 50 guntas. However, only 32 guntas have been granted. My lord, I have furnished typed copy of the statement given by the petitioners and the respondent before the tribunal, dated 1994, madam, at page number 30. It is typed copy of the statement given by both the respondent and the petitioners, madam.
You appear only for respond number 4.
Yes, ma'am.
The other respondents are not contesting.
Only respond number 4 in respect of 117 2B dalli. They themselves given a statement before the land tribunal that so far as 117 2B is concerned.
That will come to you. You are only for one of the owners.
Yes, yes, yes.
All the owners are not before this.
Only one.
Yes. Yes, Mr. Kunjal.
Yes, my lord. The page number 30 could please be perused, my lord. That is a typed copy of the order sheet before the tribunal. In fact, the contention of the petitioner is this very statement is concocted for the very reason that, my lord, you could,
Yes.
the last two lines, my lord, that is a statement. Nanu Ningappa Baswantappa Mushapugod, ವಯಸ್ಸು so and so ಹೇಳಿ ಬರೆಸುವ ಜವಾಬು. ನಾನು ನನ್ನ ತಮ್ಮ ಶಿವಪ್ಪನ ಮಗ ಶಂಕರ ಇವನ ತರ್ಪಿ ಜವಾಬು ನೀಡುತ್ತಿದ್ದೇನೆ. ನನ್ನ ತಾಯಿ ಬಸವ ಮೃತಳಾಗಿರುತ್ತಾಳೆ. Now, even Shankar was not, he was also deceased even prior to the filing of this petition. He was, in fact, he had predeceased his father. So the statement saying,
1992, Shankar was dead?
yes, man, in fact, he had predeceased his father, my lord. Father is Siddhappa. Because when father died in 2000, on 28/9/1984, succession certificate has been issued, my lord. In that, Shankar is shown as having predeceased.
Where's
And
the
this,
death certificate? Where's the
no,
death certificate of Shankar?
that is not furnished there. In fact, it's with me. It's with me, my lord.
ನೀವು
That
ಕೊಡ್ಬೇಕು.
certificate is there. That is furnished at F&G.
ಆಯ್ತು, ನಾಳೆ ಬಂದು ಕೊಡಿ ಅದು. If it's not
The
been
E
furnished,
and F
that
death
would be-
certificates have been furnished, my lord.
ಎಲ್ಲಿ? E and F.
E and F, yes, my lord. They have been furnished.
Not been produced ಅಂದ್ರೆ?
No, I mean, succession certificate is not produced. Death certificate is produced.
ಬೇಕಾಗಿಲ್ಲ.
Idರಲ್ಲಿ Siddhappa died on 28/9/1984.
4. Shankar.
And then Ningappa died. Ningappa, the person has given a statement, died in 2007. That is not in dispute. And what I am saying is, the statement is said to have been made on behalf of Siddhappa's son Shankar. However,
Where is
he had
Shankar's death certificate?
predeceased Siddhappa, my lord.
ಅಲ್ಲ, where is Shankar's death certificate?
ಅವ್ರದ್ದು ಹಾಕಿಲ್ಲ, only it is seen in the succession certificate issued by the Tahsildar, my lord. ಗ್ರಾಮ
ಎರಡು ಇಲ್ಲ, ಸೆಕ್ಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ಲ, ಡೆತ್
ಇಲ್ಲ,
ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ಲ.
ಅದ್ರಲ್ಲಿ ಇಲ್ಲ, ಅಲ್ಲಿಲ್ಲ.
ಕೊಡಿ, ಇವ್ರಿಗೂ ಕೊಡಿ, ಮಂಡ್ಗಾಣಿ ಅವ್ರಿಗೂ ಕೊಡಿ. We'll have it next week. Let him get instructions.
Okay. Otherwise, it could be disposed of. This one is only to the extent, they are given it only to the extent of 32 guntas. At least 50 guntas should be given. And then, because even the response have agreed that they were in portion of 50% of the total land. They have agreed, response in the said statement.
Yes, Mr. Mandkani.
So far as that is concerned, subsequently it has been on the statement, their statement only half portion. They are stated that the half portion was being cultivated by the Siddhappa and the Ningappa. So far as 117 is concerned.
So ಇನ್ನು 18 ಗುಂಟ ಬೇಕು ಅಂತ ಇದ್ದಾರೆ.
ಅಷ್ಟೇ.
ಓಕೆನಾ?
I'll put to my party.
Learned counsel for the petitioner seeks for and is granted a week's time to place on record the death certificate of Shankar, son of Siddhappa, as also the succession certificate issued by the court.
With the Gram Laka, that is village accountant, with respect to.
By the village accountant.
Yes, Siddhapa's death. Siddhappa.
Copies thereof to be furnished to the counsel for respondent on or before 25th January to enable the counsel for respondent number 4 to obtain instruction, make his submission. Released on 31st January for further hearing at 2:30 p.m.
Please.
My lord, with your lordship's permission.
31st January, you serve it on him.
I agree. Next one, I mean, with your lordship's permission, 107 on the day, I will not be available to be on the, I am for the respondents. That also could be taken up next week. 107. Well, if your lordship could oblige me. But I'll take instructions also. I'll take instructions on that day, and then it's a Mandamus matter. I will.
At the request of counsel for respondent number 1 to 6, released on 31st.
Oblige me.
49 Arjun, 50 Chetan Manoli.
Lords, in the present petition, the petitioner is challenging my lord's impugned order at Annexure A.
R2, R3.
R3, my lords.
Please for R3.
Shri P.N. Ethi appears, my lords.
Where is he? Beka ಅವರು contesting ಅವರು
Contesting are private respondents, my lords, who are represent.
He is not required.
He is not.
ಹೇಳಿ ಬಂದ್ರಲ್ಲ.
Lords, by.
ನೀವು ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. Between them only. ಹೇಳಿ.
By virtue of Annexure A, my lords, the application filed under section 30 of the Land Acquisition Act for apportionment of compensation, my lords, has been rejected by the executing court. Lords, just to, my lords, narrate the background facts.
Yes.
Lords, in the year 1944, the petitioner's father purchased, my lords, the petition property. Lords, the survey number 150/1 is totally measuring 1 acre 32 guntas, my lords. And out of that, 27 guntas was purchased by petitioner's father.
This has been rejected on the ground that you did not seek for reference.
I had filed, my lords, reference application also. That was not
Where is that?
referred. My lords, Annexure E is my reference application, dated 6/11/1982.
So what has happened to this?
Lords, this reference was not, my application was not referred. However, the adjacent owners, which are also, my lords, in respect of remaining portion of 150/1.
ಇಲ್ಲ ಮಿಸ್ಟರ್ ಅಟ್ಟಿ ಬೇಕು ಇದರಲ್ಲಿ ನೀವು ಯಾಕೆ ರೆಫರ್ ಮಾಡಿಲ್ಲ?
It was referred, madam. Award has been passed and it was referred, madam.
There were 2 reference applications, my lords.
This application at Annexure E, was it referred?
Please.
If it is referred, then the finding is wrong because there is no reference on that.
In LAC, they are party, madam.
Is a party in LAC proceedings.
Lords, there were 2 reference applications, one filed by respondent number 2 and one by me, my lords. The reference application filed by respondent number 2 was referred, and my lords, registered as LAC. Annexure G is the, my lords, judgment and award. In that, I was arrayed as opponent number 2. Reason being, my lords, in the SLAO award,
She has to be arrayed as the
claimant.
Within the limitation, they have not approached.
Is there an order passed?
Yes.
ರೆಫರ್ ಮಾಡಿದಿರೋ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಿರೋ ಆರ್ಡರ್ ಇರ್ಬೇಕಲ್ಲ?
Then I will verify it, madam.
Lords, one more submission.
Paragraph number 23, the lower court has referred that. Paragraph, page 23, paragraph number 11, madam. In page 23, last 4 lines.
Yes.
Third additional civil judge and senior division Belgaum has granted probate and success certificate to the decree holders, P and C so and so, and claimed the entire compensation occurred on the land bearing so and so, measuring 1 acre 32 guntas of Kakti Taluk, Belgaum district so and so, dated so
Now,
and so.
finally, the reason why it has been rejected is para 22. That without seeking for reference, they cannot be considered anta. That is right. But they have filed a reference application. What has happened to that?
Within the 90 days, they have not filed. Within the limitation.
ನಿಮ್ಮ ಆರ್ಡರ್ ತೋರಿಸಿ ಏನ್ ಮಾಡಿದೀರಾ ಅಂತ.
Lords, one more submission. This happened because, my lords, although I had a registered sale deed in my favor, in the record of rights, only the respondent number 2's name was, my lords, forthcoming. And, my lords, before the award was passed, after I came to know that the land is being acquired, I submitted my objections, my lords. And after that, my lords, after passing of the award, I received a notice. And in the award also, my lords, it is stated that at para 8, there is a, my lords, observation that with respect to my claim, it is to be referred to civil court under section 30 for apportionment of compensation. However, even under section 30, it has not been referred, my lords. And after.
What to do about it? It was filed such a long time ago.
Please, it was not referred.
ಅಂತ ಹೇಳಿ ಇದ್ರಲ್ಲಿ how can you raise it? Without.
Even after passing of the award, my lords, after issuance of notice within 90 days, I have filed reference application.
Okay, you have filed your reference application.
Please.
Mr. Atti will find out what has happened.
Please.
Suppose it has not been referred, what have you been doing from 82? You filed it on 6/11/1982.
Please. Lords, thereafter.
If you slept over your rights, how do we help you?
Continuously, my lords, I have been submitting my objections and applications.
Your objections are irrelevant until a reference is made. Only
Even
after a reference is made, then you can make your submission.
Even apart from reference, my lords, for apportionment of compensation, at least it has to be referred to civil court. Since, my lords, in respect of 27 guntas, I am claiming my right. And
That is what your reference you have to make and follow it up.
Moreover, they have not produced any document to show that they are in possession. Yet paragraph number 14.
Possession.
It is for the court to ascertain.
Sorry, madam.
That is for the court to, we can't go into that merits. Whether a reference, they have filed a reference on 611, application for reference on 611. What has happened on that?
And I will verify.
Shri Piyanati,
Because in paragraph number 14 of the,
ಅದ್ರಲ್ಲಿ ಇರಲ್ಲ ಇದು. ಇದು ಅವ್ರು ಬೇರೆ ಫೈಲ್ ಅಲ್ಲಿ ಇರುತ್ತೆ.
in lower court order, the
ಟ್ರಯಲ್
paragraph,
ಕೋರ್ಟ್ ಆರ್ಡರ್, ಲೋವರ್ ಕೋರ್ಟ್ ಅಲ್ಲ.
paragraph number 14, madam.
ಹ್ಮ್.
On perusal of the oral evidence of PW1, he has clearly stated that in the cross-examination that he has not produced any document to show that he has got how many lands in Kakti, and he has also admitted that he has not produced any revenue paid receipt in respect of register survey number 150/1/150/1, and has also stated that he has not produced any document to show that the land RS number 1 standing in the name of his father or in his name. They are not at all shown. Moreover, at page paragraph number 15, further he has also admitted that the RS number 150/1, there is no existence of 27 guntas of land independently. He has also admitted that neither his name nor his father's name is appearing in exhibit P2 or P5. At paragraph 17 also.
You tell us what happened to Annexure E. Shri Piyanati, learned counsel appearing for respond number 3 seeks for and is granted 10 days time to obtain instruction, make his submission as to whether any orders have been passed on Annexure E, and if so, to produce copy of the said order, released on 6th February for further hearing at 2:30 PM.
Moreover, there is a huge delay, inordinate delay is there in that.
ನಿಮ್ದು ಆರ್ಡರ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲೇ ಮುಗಿಯತ್ತೆ ಇದು. If you allowed it, then the order passed at para 22 is wrong.
Please, I will produce.
51 Arjun, 52 Jay Shetty. Jay Shetty,
Paso.
53 VG Bhatt.
I'm appearing this phone number 3, my lord.
Ready?
Yes, my lord.
Paso.
54 Arjun, 55 HM Darigond.
Where was petition?
Yes.
Challenge the accusation proceedings, not the. The lands of the petitioner acquired by the Malad, the respondent, for the purpose of construction of railway track, Malad, the oral notification issued
In 2012. Final notification 2013.
13.
You filed it in 2016.
Award passed 11/7/2006, beyond 2 years, Malad. That is contrary to section 11, as well as the new act.
Award is passed on
11/7/2016. Beyond 12 months,
11/7/2016.
please.
Final notification was on
26/10/2013.
award date in Andre?
Annex D 11/7/2016. Page 118 and 110.
Have you accepted the award amount?
No, Malad.
You're not accepted. Yes.
Now, if he has completed, my lord, I will make submission. Other than this, my lord, if he wants to make any submission, then thereafter I will make submissions.
In
First
identical.
ಇದು ಹೇಳ್ಬಿಡಿ ಆಮೇಲೆ.
ಅಲ್ಲಲ್ಲ, ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಆಮೇಲೆ ಅವರು ನಾನು ಇದನ್ನ ಹೇಳ್ಬೇಕಿತ್ತು ಅಂತ ಅಂತಾರೆ ಅದಕ್ಕೆ.
ಅದು ಆಮೇಲೆ ಬಿಡ್ತೀವಿ ಅವ್ರಿಗೆ. ಇದು award ಅಲ್ಲೇ ಹೋದ್ರೆ ಇದೆಲ್ಲ ಕೇಳೋದ್
ನಾನು
ಬೇಕಾಗಿದೆ.
ಹೇಳ್ತೇನೆ, there are certain dates which has to be notified.
Similar issue, Malad, decided by this honorable court. Very similar issue, Malad.
ಇನ್ನ ಇದೆ ಅಂತ ನೀವು ಫುಲ್ ಮುಗಿಸಿ ಆಗ.
ಅದಕ್ಕೆ
Please.
ಹೇಳ್ತೇನೆ.
My submission is, Malad, the award passed, Malad, beyond 12 months, Malad, the,
ಹ್ಮ್.
that is contrary to section 25 of the, Malad, the new act.
ಹ್ಮ್.
Very same issue, Malad, decided by this honorable court in conducted writ petition 1000676 of 2007. Already produced before the honorable court.
100676.
Please.
Yes.
On that case, Malad, the foreign notification issued on 15/12/2012.
Same acquisition or ಬೇರೆ acquisition?
Same accusation. I'm Malad, notification is different, but very same purpose.
ಅದರಲ್ಲಿ 4-1 issued on 15/12/2012. 6-1 issued on 9/4/2014. Award passed on 24/5/2016.
But ನೀವು ರಿಲೀಫ್ ಕೇಳಿಲ್ಲಲ್ಲ,
Challenge my lord, the
ಲ್ಯಾಬ್ಸ್ಟ್ ಅಂತ ಕೇಳಿಲ್ಲ ನೀವು.
notification itself challenge my lord.
ನೋಟಿಫಿಕೇಶನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರ ಅಷ್ಟೇ.
Please. That is main ground my lord, the beyond the my lord.
Notification has not been challenged on the ground of the award being passed subsequently and it having been lapsed. Your prayer is not there for that.
Only section 17.
Prayer ನೋಡಿ ನಿಮ್ದು.
Challenge, but the next day also challenge my lord.
ಎಲ್ಲಿ, where is your ground in the petition?
My lord, the page 20, para 22 my lord.
Yes.
That is the main ground my lord. The one more thing is my lord, the that is also my lord, the relied judgment my lord. The neighboring village my lord, that is my lord, very same purpose.
Yes, ಅಷ್ಟೇನಾ?
Please, that is only ground.
Please. My lord, as per the contention of the petitioner, my lord, 4-1 notification was published in the official gazette on 8/11/2012.
8/11/2012. It is dated 25/10/2012.
10/2012. It was published through official gazette on 8/11/2012. And thereafter in two local papers on 5/12/2012 and 3/12/2012. And in the village Chowdi, it was published on 15/12.
Right.
Thereafter, my lord.
The ground is the award has been passed beyond period of 12
No,
months.
no, for that reason only I am specifically dating with regarding to that. It is passed within 2 years.
6-1 then preliminary is not required.
Yes, no. My lord, 6-1 was published on 13/1/2014.
13/1/2014.
So, and the draft award was submitted to the deputy commissioner on 10/10/2015.
10/10/2015.
And it was approved on 5/12/2015. 5/12/2015. And my lord, notification, that is 11/7/2016.
Award.
Yes. So, my lord, taking into consideration, my lord, the limitation starts from the date of publication is that is on 13/1. Yes. Commences from the last date of submission of the publication.
Section 2017. Within 12 months.
Yes.
From the publication.
Yes.
Your publication is 13/1/2014.
14.
So it had to be done by 12/1/2015.
Yes.
But you have done it on 11/7/2016.
Thereafter, my lord, we can have the government has the power to further extend.
Where is the order of extension?
Yes. Extension, my lord, I have produced along with the statement of objection.
By what period can it be extended?
1 year further. 12 months.
So 12/1/2016.
Yes.
At the most.
Yes.
You are 11/7/2016.
No, no, the award itself was approved on 15/12/2015 itself.
Not concerned
And
with
it
your
was published on 11/7/2016.
We are only concerned with the publication.
Yes.
As per section 25.
Yes.
ನೀವು ಇಂಟರ್ನಲ್ ಅರೇಂಜ್ಮೆಂಟ್ ಏನಿದೆಯೋ ಅದೆಲ್ಲ ನಿಮ್ಮ ಇಂಟರ್ನಲ್ ಅರೇಂಜ್ಮೆಂಟ್.
ಅಲ್ಲ ಇಂಟರ್ನಲ್ ಅರೇಂಜ್ಮೆಂಟ್
ಅಪ್ರೂವ್ ಮಾಡಿದ್ರು, ಕಾಮಾ ಚೇಂಜ್ ಮಾಡಿದ್ರು, ಅದೆಲ್ಲ ನಿಮ್ದು. It has, even if you accept your 1 year extension,
yes,
it will have to be 11 12/1/2016.
Please,
You are late by 6 months.
please. Thereafter, my lord, one more ground.
Hmm.
Compensation have been already paid to all the petitioners herein. That has been received prior to the approval. That is on 12/2/2020. That is before 12/2/20.
Other
Yes.
documents, Cody, will come back.
Yes.
If compensation has been received, then
Yes. For that, ಅಲ್ಲ ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇವೆ. It is produced.
ಅವ್ರು ಕೇಳಿದ್ದು
ಆಯ್ತು,
compensation
ಅದಕ್ಕೇನೆ
receive
ನಾನು
ಮಾಡಿದ್ದೀರಾ ಅಂತ.
ಹೇಳ್ತಿಲ್ಲ.
ಅಲ್ಲ, you have not produced any documents, my lord.
ಅಲ್ಲ ಹಾಕಿದ್ದೇನು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಜೋಡಿ ಹಾಕಿದ್ದೆ ನಾ ಹೇಳ್ತಾ ಇರೋದು.
ಹಾಕಿಲ್ಲ.
ಅದರ್ ದೆನ್ ದಟ್ ಮೈ ಲಾರ್ಡ್ ಐ ಆಮ್ ನಾಟ್ ಮೇಕಿಂಗ್ ಎನಿ ಸಬ್ಮಿಷನ್ಸ್.
I have not seen any copy, my lord.
Statement of objection copy ಇಲ್ವಾ?
ಕೊಟ್ಟಿದ್ರೆ ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ.
ಕೊಟ್ಟಿರ್ತೀವಿ.
ಅಲ್ಲಿ ನನಗೆ ಕೊಟ್ಟಿಲ್ಲ. ಅದರಲ್ಲಿ ಹೇಳಿದಾರೆ ಅಷ್ಟೇ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದಾರೆ.
ಒಂದು
ಡಾಕ್ಯುಮೆಂಟ್ ದೇರ್ ಇಸ್ ನೋ ಡಾಕ್ಯುಮೆಂಟ್.
ಇವತ್ತು ಕೊಡಿ ನೋಡ್ಲಿ.
ಸರ್ ಇದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಚೆಕ್ ಮುಖಾಂತರ ನಿಮಗೆ ಕೊಟ್ಟಿರೋದು ಡೀಟೇಲ್ಸ್
ನೋಡ್ಕೊಳ್ಳಿ ಲಂಚ್ ಟೈಮಲ್ಲಿ.
ಆಯ್ತಾ?
Dharwad bench matter, 230 mood matter. Number 1, Mohan.
So I am for petitioner.
Yes. Yes.
So VC the.
Yeah.
N Shivkumar sir. N Shivkumar sir VC the. Sir VC.
Shivakumar.
Appear for the petitioner, my lord.
Yes.
What is challenged is annexure F3. Annexure F3. My lord, very briefly, the facts are petitioner is a power manufacturing company. Now, my lord, they are given permission to set up 27 megawatt power plant. Therefore, at Naragal village. Therefore, they made an application by annexure F at Impay 34 to respond number 3, saying that they have taken certain properties on lease and wanted to know what is the demand. And my lord, by annexure F1 at Impay 36, a demand for 11,21,544 was made. And by annexure F2, we have made the payment of the amount, my lord. Such being the case, by annexure F3 at ink page 40, this is the main document, my lord. By annexure F3 at page 40, a demand again has been made on 28th of August 24, my lord, at the signature portion below the date is there. And I may be permitted to read this, my lord.
Yes.
ಈ ನೋಟಿಸ್ ಮೂಲಕ ನಿಮಗೆ ತಿಳಿಸುವುದು ಏನೆಂದರೆ ದಿನಾಂಕ 1/4/20 ಮಧ್ಯದ ಯಾವ ವರ್ಷ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ರಿಂದ 31/3/20 ಅದು ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಯಾವ ವರ್ಷ ಅಂತ ಅವಧಿಯ ಸ್ವಯಂ ಘೋಷಿತ ಆಸ್ತಿ ತೆರಿಗೆ ಪದ್ಧತಿ ಪ್ರಕಾರ ತೆರಿಗೆಯನ್ನು ಆಯಾ ವರ್ಷದ ಜೂನ್ 30ರ ಅವಧಿಯಲ್ಲಿ ಪಾವತಿಸಬೇಕಾಗಿತ್ತು. ಅಲ್ಲದೆ 64ನೇ ಕರ್ನಾಟಕ ಪೌರಸಭೆಗಳ ಅಧಿನಿಯಮ ತಿದ್ದುಪಡಿ ನಿಯಮ 105(1) 105(2) ಅನ್ವಯ ಸ್ವಯಂ ಘೋಷಿತ ಆಸ್ತಿ ತೆರಿಗೆ ಪದ್ಧತಿಯಲ್ಲಿ ಪಾವತಿ ಮಾಡಲು ತಮಗೆ ಅವಕಾಶವಿದ್ದಾಗ್ಯೂ ಸಹ ತಾವು ತೆರಿಗೆ ಪಾವತಿಸಲು ವಿಫಲರಾಗಿದ್ದೀರಿ. ಆದ ಕಾರಣ 1964ನೇ ಪೌರಸಭೆ ಕಲಂ ತಿದ್ದುಪಡಿ ನಿಯಮ 105(4) ದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ತಮ್ಮ ಆಸ್ತಿಯ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿ ಈ ನೋಟಿಗೆ ಲಗತ್ತಿಸಿರುವ ವಿವರಗಳ ಪಟ್ಟಿಕೆಯಲ್ಲಿ ಮೇಲಿನ ಅವಧಿಯ ತಮ್ಮ ಆಸ್ತಿಯ ತೆರಿಗೆಯನ್ನು ನಿಯಮಗಳಡಿಯಲ್ಲಿ ಸನ್ 2002-3 ರಿಂದ 24-25ನೇ ಸಾಲಿಗೆ ವರ್ಷ.
You established your unit on which year?
It's still being done, my lord. We are putting up construction now.
So when did you purchase the property or lease the
It's
property?
taken on lease, my lord, in 23. Annexure. Yes, my annexure is the letter.
2002 to.
Yes, my lord.
They have taken the lease only in 23, but demand is made from 2002.
And my lord, by the next letter at annexure G, my lord, I replied to them and I asked them, what is the breakup?
Yeah, we'll state, learned AG accepts notice for respond number 1 and 2. Naregal Town Panchayat.
ರಾಜಶೇಖರ್ ಗುಂಜಳ್ಳಿ
ರಾಜಶೇಖರ್
ಇಲ್ಲ ಅಂತಿಲ್ಲ
ಸರ್ ಅವ್ರು ಇಲ್ಲ ಸರ್ ಅವರು ಪೆನಲ್ ಇಲ್ಲ ಅಂತೆ ಸರ್.
ಮತ್ತೆ ಯಾರಿದ್ದಾರೆ?
ಗೊತ್ತಿಲ್ಲ ಸರ್.
ಹಾಗಾದ್ರೆ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಡಲ್ಲ.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಅಂತ ಹೇಳಿ
ನೀವು ಹೇಳಿಲ್ಲ ಯಾರು ಪ್ಯಾನಲ್ ಅಲ್ಲಿ ಅಂದ್ರೆ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಇಲ್ಲ.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಕ್ ಹೋಯ್ತಾ ಸರ್ ನಾನು ಇಲ್ಲ.
ಇದು ಎಂಟ್ರಿ ಆರ್ಡರ್ ಇಲ್ಲ, ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ.
ಅದು ಒಂದೇ ಸಮಸ್ಯೆ ಏನಂದ್ರೆ ಅವರು
We told you in the morning, find out who is this.
ಬಟ್ ಹಿರೇಮಠ ಸರ್ಗೆ ಕೇಳಿದೆ ಅವ್ರಿಗೆ ಕೇಳಿದೆ ಸರ್ ಇಲ್ಲ.
No entry order.
My lord, ಒಂದೇ ಸಮಸ್ಯೆ ಇದೆ. Comment taken possession of the
We
property.
told your counsel here to verify who is the standing counsel and make a submission. If you don't even make that effort, then we can't help you.
I'm sorry, my lord, but I have produced photograph. They have comment taken
We
possession
are
of the
also
property.
sorry. We have told your counsel that if that is not mentioned, we won't grant any interim order. And we have asked him to serve the counsel also, and you don't do it. We'll list it tomorrow. By then, do it.
Yes, ma'am.
And AG accepts notice for respond number 1 and 2, relist on 25th January.
2, Subhendu Akalwadi.
Plus, petitioner is a second year law student plus.
Helli, KSLU yaru standing counsel.
Sir, Beturmut sir.
ಕೊಟ್ಟಿದ್ದೀರಾ ಕಾಪಿ?
Please. It is served to the clerk.
ನಿಮಗೂ ಹೇಳಿದ್ವಿ ಬೆಳಿಗ್ಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ನಾವು we won't
It is
take
actually
it.
served. In the morning itself it is done.
Yes. ಮತ್ತೆ ಎಲ್ಲಿ ಅವ್ರ ಕಾಪಿ?
It is given there, Mulats. I'll give it right. In the morning itself I've given Mulats. But what has happened here, Mulats? I may be permitted, Mulats, to take your lordship's, Mulats, to the timeline of the examinations. But
Yes.
now in the month of July, the first semester examination as well and re-examination was held, for the subjects that is not cleared. The announcement of that result, was done in the month of October. Meanwhile, in the month of May, the second semester classes were already begun, and the petitioner was attending the classes. But subsequently, the second semester exams was announced. After announcing of that result, now in the month of December, again the re-examination of second semester was conducted, wherein the petitioners cleared all the other 5 subjects.
When is the exam scheduled now?
Now the examination has already begun on 21st. Today, as I'm making this submission, second paper is being conducted. I sought permission,
You
to
missed
write
both the exams.
other 3 papers. Other 3 papers now it is as yet remaining. The next paper is on Saturday.
ಹೆಂಗೂ ಎಲ್ಲ 2 subject ಮಾಡ್ಬೇಕು, ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಮಾಡಿ.
Indeed, but the other 2 subjects may be written in the
Attendance ಎಷ್ಟಿದೆ ಇವಾಗ? What is the attendance?
Attendance is
For
more
the
than
attendance, my lords. He has not cleared the subjects.
the result, as far as the semester exam that is being conducted now, the notification for the said exams was published in the month of December, first second week of December 2024. But the result of the earlier re-examination was announced on 14/1/2025, and now the third semester exams is on 21st, which has already begun. I did not have any scope of even opting for any other references also to take.
ಇವಾಗ 14/1 result ಅಲ್ಲಿ what are the results?
We have cleared all the 5 subjects. Yes.
Then I have to take instruction to that regard, my lords.
We'll qualify the order saying that
Please,
it
if
is
he is,
cleared.
please.
Then ನಿಮ್ scheduling ಸ್ವಲ್ಪ ಕಷ್ಟ ಇದೆ.
Because of the timeline,
Sri KL Patil accepts notice for respond number 1. Respond number 2 ಯಾರು? ನೀವೇನಾ?
Same.
Same.
1 and 2. The petitioner is permitted to appear for the remaining exams of the third semester in the event of subject to the petitioner having cleared all the papers in the results announced on 14/1/2025. Respondent university and college shall respectively collect the fees and process all the requirements, including issuance of all ticket, etc., to enable the petitioner to take up the examination.
Please, grateful.
Released on 24th February.
Yes. Sir, may I seek for hand delivery,
Hand delivery ordered.
Please. Grateful.
Learned counsel for the respondent shall inform the respondents about the above order,
I'll inform you.
It is on
and the
Saturday.
respondent shall act on a printout of the uploaded copy of this order without insisting on a certified copy.
Please, grateful.
230 matter, 114. Santosh Maligwad.
My Lord, in this matter, I am appearing for the first time, my Lord. Learned AG was appearing when the matters were called out through Bangalore matters. But as per the instructions given by the learned AG, they have complied. I will place before the court. ಅದಕ್ಕೆ ಒಂದು 2-3 ದಿವಸ time ಕೊಟ್ಟರೆ it will be
AG seeks for and is granted a week's time.
Please.
To report compliance, to file compliance of
Yes, my
released on 31st January.
Please.
115.
Lord, sir, your lordship has directed me to keep the party present as he owes money to the opposite side. Lord, I have intimated him. Today also in the morning, I called him up. He said that I am arranging a money.
He won't come.
Lord,
So no money, no nothing andre ಏನ್ ಮಾಡೋದು?
my lord, however, the trial court has already issued an arrest warrant. My petition may be dismissed, my lord. My lord, may I seek, my lords, the petition?
You have done the best for him ಅಷ್ಟೇ.
Petition be dismissed for default, my lords, so that if at all he comes, at least he comes up with the money instead on merits.
That counsel for the petitioner submits that he has no instructions in the matter.
No, Lord, I have
In that view of the matter, the petitions are dismissed for non-prosecution.
Yes.
Ella, 115, 115.1 and 2.
116, VM Shilwant.
Where is Mr. Panindra?
Respond number 4 and 5. Sunil.
ನೀವಿದ್ದೀರಾ?
Yes.
ಅವ್ರಿಗೇನ್ ಕಾಯ್ದು ಬೇಡ.
ಇಲ್ಲ,
ಬರ್ತಾರೆ,
we'll join. We'll join.
The very issue is very simple, my lord, sir.
ನೀವಿದ್ದಾಗ ಸಿಂಪಲ್ ಇರ್ಬೇಕು. WP 10631. Yes.
Plus, petitioners, my lord, 1 to 3. Petition number 1 is, my lord, the owner of 2 survey numbers. 130/1, 130/1, 130 AP 1, measuring 4 acres 22 guntas.
So state is there. KDB, who is represented? You are for KDB. Mr. Panindra is for
4 and 5.
4 and 5.
beneficiaries, huh?
Beneficiaries. Yes. Plus, 3 lands, 4 lands totally, measuring about 29 acres, 28 acres and odd, have been acquired. Plus, that acquisition was challenged before this honorable court, in writ petition. I produced it, page number. Annexure C, page 35. Writ petition was dismissed.
Writ appeal allowed.
Writ appeal was allowed, quashing the entire proceedings of the
allowed.
acquisition. Then when they went to Supreme Court, the Honorable Supreme Court allowed the SLP. In the meanwhile, there was a stay order, there was a status order
So
by the
acquisition
Honorable
is
Supreme Court.
upheld.
Yes, my lord. Now acquisition is upheld. This is, my lord, this acquisition, ultimately Supreme Court, my lord, on wide order dated, my lord, allowed the SLP on 11/10/2022. The response for, there was no joint measurement conducted by the authorities. No compensation is paid.
ಇದುವರೆಗೂ ಕೊಟ್ಟಿಲ್ವಾ compensation?
ಇಲ್ಲ, ಇನ್ನ ಕೊಟ್ಟಿಲ್ಲ. Compensation called James in Manila. I have got more 5,000 trees in my 28 acres of land. About 1,000 trees are uprooted by the response 4 and 5. Then I approached this on the court. The KIDB says no general award is passed as on today. Compensation is not paid. Only consent award is passed. They are asking me to give the consent award pursuant to the direction issued by this honorable court. Till today, compensation is not paid.
Consent award in
So as far as others are concerned, consent award is passed. As far as persons who have not consented for the award, now they have to pass a general award. Till today, general award is not passed. They admit on the last date of occasion that the award is not passed. Compensation is not paid. And they respond 4 and 5 high-handedly want to take possession of the property. They have uprooted about 1,000 trees. Still about 4,000 trees are there. Therefore, approach this honorable court, my lords. I am not disputing the fact that the acquisition has become final. My grievance is they have to conduct the JMC and, my lords, pay the compensation. Authority may take possession in accordance with law. That is my case. No, sir, I made a complaint. Kindly see, my lords.
Section 4 of section 28 says vest with the government.
Oh, I'm not disputing that. I'm not doing it. Vest with the provided no, the award is passed and possession is notified under section 16(1).
The issuance of notifications subsection.
It vests with the, I am not disputing that part. But they have to conduct the JMC, joint measurement, and the general award is to be passed. Let them pay compensation, let them take possession. Till today, they have not taken possession by the competent authority. They respond 4 and 5 want to take possession. Kindly see, my lords, kindly pay Annexure J. My grievance is at 270, page number 270. 270 of my petition.
Yes.
Plus the last about 7 lines from the bottom. We are requested, my lords, we are ready to hand over land to the company as per the order of the apex court and requesting that kindly pass the general award to the said lands and pay compensation. Your lordship got it? Yes. Pay compensation to the acquired lands as per new Land Acquisition Act 2013. Till passing of the award and paying the compensation, our land should not be should not take possession and not demolish and alter the lands and make an award to the Malkis. This is my prayer. Admittedly, no award is passed, no compensation is paid, and respond 3, 4, and 5 who are beneficiaries want to take possession of my land. Therefore, my position is protected till joint measurement is conducted and let them pass an award. Let them pay. Last occasion, court has asked me to furnish the accounts so that they can pay the at least compensation as consent award is passed. No, so I have given the account details also. Till today, they are not deposited.
Yes, Mr.
This is my case.
In fact, I issued a notice on the last day to provide those details and told that details are provided. Not yet provided, whatever, not provided.
Account details, sir.
No, all the documentation regarding there were some other documents also which we required. I'll just give a background to this one. Now, a threshold question possibly your lordships may have to consider is, if my lords were to see the Supreme Court's judgment in this very same acquisition, there is, I'll take my lords through it, there is a detailed narration of the chronology of events where they take note of all aspects of section 28 and section 29. So a threshold question possibly is, my lords, whether the petitioner can even re-agitate all these questions in light of a specific finding of the Honorable Supreme Court that all procedures under the KIAD Act have been followed.
Where is the award? Give us a copy of the award.
Yes, my lords.
Give us a copy of the
My
award.
lord, I'll just take my lords through. Award was not there. What had happened is, my lords, initially we had 28-4 notification was issued. Then, my lords, the price fixation committee, we called them to attend the price fixation committee meeting where the price was fixed. Then, my lords, we issued them a notice. My lords will file, if my lords were to see the objections filed by the KIDB.
Lords, if your lordship just sees the chronology set out by the Supreme Court.
Who is going to argue first?
No, Supreme Court chronology sets out.
Don't want interference.
No, I'll let Mr. Pandit.
But you are nobody. We'll have to hear KIDB.
Award inno agilla. That is the fact.
You are only a beneficiary, Mr.
No,
Pandit.
but the stay is on possession. My activities are going on now. He has
You
moved the
can
court.
only hang by the coattails of Mr. Vikram.
Lords,
You have no independent existence.
No, because the Supreme Court has recorded possession is given to me. The lease cum sale agreement is entered. All that is
You don't
in
want
their
to-
SLP.
You
No,
don't
no,
want
they-
KIDB to
Lords, we are ready to pay. They are to pay. Only thing is there is a stay operating now. My activity has come to a standstill.
Have you paid, has a demand been made by KIDB to you and have you?
Yes, that is recorded by the Supreme
How
Court.
much amount have you remitted?
My lords, subject to correction, my lords, the Supreme Court's order itself records that my lords deposited about 3 crore 64 lakhs 98,000 at 213, page 213 of that writ petition, my lords.
213.
Yes.
3 crores 64 lakhs 98,000.
And then, my lords, please turn over to 214. Everything is recorded. Please see Roman 20.
Now, this possession is taken only to the extent of 100 acres,
Oh, my lords,
as stated by them in the writ petition, in the writ appeal, not
You can
entire
always
extent.
reply.
The chronology starts from 210. The Supreme Court has set out the chronology, my lords, from 210. Just 43 crores. In fact, after that, we have paid 40, it's totally paid 43 crores. For the land extent is more. The total acquisition was for about 1,000 acres and odd, my lords, 900 acres and odd. And my lords, 550. ನಮ್ಗೆ ಇದರಲ್ಲಿ ಇದೆ. I am going by this record.
ಅಲ್ಲಲ್ಲ 3,000 totally.
And it's recorded for 550 acres, they had passed award, they had paid. I don't know what has happened later, but we have deposited the amount. And lease deed is executed prior to Supreme
We
Court.
are asking them and you.
My lords,
all-
only the amount, only thing, my only interest is, my hurry is, my lord, that my activity has come to a standstill.
Not going to allow them to argue, then you will be continuing to wait. ಅಷ್ಟೇ.
ಅಲ್ಲ ಅವರು ಅವಾರ್ಡ್ ಮಾಡಿ ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ ಇರೋದು.
Because you will not be able to answer any of the questions.
Not on the award part. I have deposited so far as I am concerned, but the stay is operating against me now. Stay of dispossession ಅಂತ ಆರ್ಡರ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
Prevail upon them to pay.
That's
Prevail upon
Early
them.
as 24th September, if my lords were to see our
If you are in
objections,
such a hurry.
my lords may kindly see page 29 of our objections. The
Now, has the award been passed, Mr. Vikram?
award has admittedly not been passed, my lords.
So when will you pass the award?
We've called upon them once again. From 2007, we've been calling upon them to give certain documents. We'll pass the award as soon as they give these documents. And we've been
How-
calling upon them to
Why
come
is the document relevant for you to pass an award? Are you determining title?
No, there's no. Since it was. It
2006 acquisition, you are in 2024.
Kindly, that's my point. Of course, I can't stand on, I can't possibly defend the action of not passing an
Writ
award.
petition was dismissed.
Correct. There was, of course, the division bench had stayed it, and then.
So
No. So then, my lord, what had happened subsequently, division bench may have stayed it.
the Supreme Court judgment was passed on.
11/10/22, my lords.
What is preventing you from passing an award?
Because now we're taking steps. Now, of course, now that this writ petition file, we're taking steps. We'll hand over the compensation.
So take your time, no problem.
But,
Let
as
the interim
recently
order
as-
continue.
I'm
You
sorry.
can take your own sweet time.
No, but in fact, no, we've been proactive, at least to be in all honesty, after this writ petition, but at least in December 24th, we've called upon them to come and collect the compensation. Let them come and collect. If they give the details, we'll transfer it.
Cody details.
Plus account statement is, plus account details are furnished pursuant to the order of this honorable court. As on 4/12/2024. Account details, court has asked me to furnish account details. And what they say, my lords, is I have to give consent award. For consent award, I have to sign.
That's the whole issue, my lord. Now in
No,
2007.
we don't want consent award.
Revisiting the entire issue. Now,
There,
I'll-
whatever is the amount determined, you pay.
Yes, ma'am, that
Any
we-
excess amount, they can
that we will
always
do, ma'am. That we will do.
file a
My lords may-
reference.
My lords may pass an order, we will set a time frame. We'll ensure we'll do it.
Your
But,
guest amount.
subject that- Guest amount, ಪರ್ವಾಗಿಲ್ಲ. Guest amount.
ಎಷ್ಟು ಅಮೌಂಟ್ ಯಾವಾಗ ಕೊಡ್ತೀರಾ? We'll reserve liberty to them to.
Per acre, my lords, 3,50,000 plus,
ಎಷ್ಟು ಎಕರೆ ನಿಮ್ದು, Mr. Shilwant?
9 acres, 12 guntas.
29 acres into 3, so roughly around.
ಖುಷ್ಕಿ ಜಮೀನುಗಳಿಗೆ ಪ್ರತಿ ಎಕರೆಗೆ 3 ಲಕ್ಷ.
That is the consent award.
ದರಿ ಜಮೀನುಗಳಿಗೆ
Let the
4 ಲಕ್ಷ.
court has suggested them to deposit first, then conduct JMC and pass an award. That is
JMC
the.
was done again. That report also is there.
All those things can be done. Now, whatever 29 acres, 12 guntas into 3 lakhs.
Yes, sir.
3 and 4, depending on the nature of land. 3.5 lakhs or 4 lakhs, depending on the nature of land, that will compute.
When will you do that?
Game documents,
Tomorrow, day after, Mr. Pranindra is in big hurry.
I understand.
Giving you all the money.
Do it, my lord.
I'm only saying this,
We'll do it
or
within a
madly.
week's time, my lord.
If you don't do it, we'll give this account statement to Mr. Pranindra, he will transfer the
Yes,
amount.
that we have
My
already.
lord, we have transferred to about 44 crores. Supreme Court order alirodu kammi 44.
Subject to adjustment to account between both of you, you pay this money.
My only problem, let them give an
ನೀವು ಫಾಸ್ಟ್
undertaking.
ಆಗಿ ಮಾಡ್ತೀರಾ, ಅವ್ರು ಬಹಳ ಸ್ಲೋ ಅವರು. ಇವಾಗ ನೀವು ಹೇಳಿದ್ರೆ ಸಾಯಂಕಾಲದೊಳಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗತ್ತೆ, ಇವರು ಇನ್ನ ಒಂದ್ ತಿಂಗಳು ಮಾಡ್ತಾರೆ.
ಇಲ್ಲ, we'll do it, my lord. Whatever, as per this computation, my lords, within 2 weeks, we'll,
ನೋಡಿ 2 weeks anತಾರೆ.
I mean, it's not has been dragging. I can.
Pranindra will tell you it is only a 2-minute work. Why are you taking 2 weeks ಅಂತ
No.
ಅವ್ರು will say.
Lords, I am only saying this. ಅವ್ರು ಮಾಡ್ತೀವಿ ಅಂತ undertaking your lordship may record. This representation for award is given on 21st October, 27th they file a writ. Within 7 days they file. I am only worried my activity, my lords, in between development.
2 weeks.
I'm sorry.
2 weeks, no, these details were given to you on 4/12/24
Yeah, but
and
we
you
will do it,
are sitting over everything. Sitting or sleeping over everything. Not possible. By Monday, transfer the money. Subject to that, we will vacate the interim order. Till your pay, the interim order will continue.
We'll do it. We'll, I think by Wednesday or Thursday, little more reasonable. It's up to me, I'll do it by Monday, but then I still have to prevail upon.
Mr. Pandita will be breathing down your neck. His client will be breathing
Lords,
down.
that we have been doing for a long time. No, after the stay, my lords, we have to, my lords, because ultimately my act, my lords, this land is recorded to be in between. The entire project is 1,000 acres.
We will do it.
And in the earlier round of proceedings itself, it is recorded. These are all in the midst, not in the corner.
We will ensure it's done.
So when will you do it? We'll list it on that day and dispose it on that day, or you want us to dispose it of today?
Let them take time, also, till that.
My lords, I am.
Government has no funds now.
We see.
The problem is inadvertently set the absolute correct
You
event.
transfer it subject to your adjustment of accounts. We'll observe that. ಇನ್ನ ದುಡ್ಡು ಕೊಡ್ಲೇಬೇಕು.
ನಾವು ಕೊಟ್ಟಾಗ ಹೋಗಿದೆ.
ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಆಗೇ ಆಗತ್ತೆ, ಕೊಡ್ಲೇಬೇಕು. 70 ಲಕ್ಷ 80 ಲಕ್ಷ ಕೊಡಕ್ಕೆ ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೀವಿ?
Lords, ನಾವು ಕೋಟಿಗಳು ಇವರಿಂದ ನಿಂತೋಗಿದೆ ಅಲ್ಲಿ.
ಆಯ್ತು, ನಿಲ್ಸ್ಕೊಳ್ಳಿ, ನಮ್ಗೆ ಆಪ್ಷನ್ ಬೇಡ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, ಇವ್ರು ಕೊಡ್ಬೇಕು. Problem is recovering from the other agency is the biggest difficulty.
It is only 1 crore of rupees that you have to pay. Why are you delaying your project because of that? ತಿಳ್ಕೊಂಡು ಹೇಳಿ.
Just pass over. Before
ಅಕೌಂಟ್ ಡೀಟೇಲ್ಸ್ ಪಣೀಂದ್ರ ಅವ್ರಿಗೂ ಒಂದು ವಾಟ್ಸ್ಆಪ್ ಕಳಿಸಿ.
ಅಲ್ಲ
ಅವ್ರು ಕೊಡ್ತಾರೆ.
ಅಲ್ಲ, ನಾವು ಕೊಡೋದಿರ್ಲಿ. Issue was only on compensation ಅಷ್ಟೇ.
That will reserve that. So now if you pay that money, the interim order will be vacated. You go ahead with the project. They will raise the issue about enhancement or otherwise by filing a necessary application for reference, which will be referred to the court.
Otherwise, we'll have to deposit with them directly. Avaru kotra. Anyway, let me first find out, my lords. I am going one step ahead.
You can convince me. Confidence, Mr. Police.
Pass over matters. Number 8, SM Kalwat. SM Kalwat.
None appears. None appears for the petitioner, though called twice. A week's time is granted to the petitioner to comply with the office objection. If office objection is not complied by 7th, relist on 12th for dismissal.
9, DLR Khan.
Lord, I had ascertained with my client that the application, that is the IA number 10, was filed by plaintiff to bring defend number 5 and 6 on record. That application came to be rejected, against which a writ petition is pending before this court.
WP number?
102425 of 22, my lord.
Take the above matter with WP number
2425 of 22, my lord.
2425 of 22. 2. Relist on.
May I request some urgency, my lord?
Allah,
now the
relist on 25th, Mr. Latta.
Please, my lord. 25th, no issue, my lord. Please.
13, Abhijit. Abhijit.
None appears for the petitioner, though called twice. 10 days time is finally granted to the petitioner to comply with office objection. If office objection is not complied by 7th, relist on 12th for dismissal.
14, Srinivas Natmani.
Office is the objection regarding annexed H, my lord. Asking for the entire regulation copy of the Gram Panchayat to be produced. I have produced the relevant regulation passed by the Panchayat, my lord.
Annexure to be described.
Annexed H, page number 55, my lord. page number 55. Relevant portion of the regulation I have produced along with the copy, my lord, the petition.
ಇದು ಕಟ್ ಆಫ್ ಆಗಿದೆಯಲ್ಲಪ್ಪ.
I have typed the copy, I have pasted in the next page, my lord. The only serial number 9 I have challenged.
Only that resolution.
Yes, my lord.
The submission of counsel for the petitioner is that only the resolution at serial number 9 of Annexure H has been challenged.
In the other objection regarding
Objections have not been challenged. Hence, office objection at serial number 56 is overruled.
57 regarding the index to be properly mentioned, I mentioned the order dated and data dated. Office is reading that order passed by the which authority has to be mentioned in the index.
Accepting submission of counsel for the petitioner, office objection at serial number 57 is overruled. Yes.
Lord, I am only seeking of quashing of the regulation and also for the Mandamus.
Quashing ಎಲ್ಲಿ sir?
Annexed H, my lord.
ಏನ್ resolution ಏನಾಯ್ತು?
There was a tender passed to repair the road work. Same was said by the regulation saying that as it has to be kept in and no work has to be conducted on the said road. On my request, this tender was passed, my lord. Annexed F.
And AGA accepts notice for respond number 124. Taluk Panchayat Siddhapur. They are standing
Not
counsel.
no one.
Yarappa standing counsel. Uttara Kannada. Sri SV Yaji is directed to accept notice for respond number 5 and 6. Counsel for the petition furnish 2 sets of the petition along with annexure on the said counsel. Relist on 5th February.
16. Abhinay.
Petitioner in this case. Very simple prayer, my lords, where we're seeking the benefit of the statute section 95 insofar as it contemplates deemed conversion.
Legible copy of annexure C and D.
Well, there is annexure C, my lords, is what is that? It's the sale deed, my lords. We had purchased the land. There's no dispute regarding this, the purchase of the land itself. I think one of the pages,
No,
all the pages
it's
are
not legible and some of the pages are blank. Why are they blank?
That's blank, my lord. That's the back of the page, my lord. There's nothing. If my lords were to see, there's a sequentially, it goes from para 1.2, it goes to para 1.3. It's just that while the sale deed was being registered sequentially.
And counsel for the petitioner seeks for and is granted 10 days time to produce a proper legible copy of annexure C and D. Insofar as the objection at serial number 57 is concerned, his submission is that though the pages are blank, the continuity is there in the other pages. Hence, office objection at serial number 57 is overruled.
In the alternative, my lords may also consider my submission that we won't be really relying on it. The grievance is very limited. Grievance insofar as, my lords, is that we filed an application for conversion. We're a wind power generator. We have obligation to sell this wind power to various purchasers in various.
When did you make the application?
The application was filed, my lords, on 27th November 2024. My lords, we filed an annexure D.
Then 4 months have not lapsed.
No, my lords, it's not 4 months, my lords. It's 30 days now. It's now amended. If my lords were to see the section, we've extracted the section at page 10 of our writ petition.
95 has been amended.
Yes, my lords. The second proviso provides 30 days. 30 days from date of receipt of the application. So we're only seeking the benefit of what the statute itself provides. Can you see page 11 of our petition, second proviso?
Amend agide, Mr. Kannur. You've been made more
stringent,
more responsible.
More responsible. That is very well.
Correct ಆಯ್ತು amendment.
I'll verify tomorrow.
ಹೊಸ book. ಯಾವಾಗ amendment ಆಗಿದೆ ಇದು?
23, what date?
If it is that is so, your lordship.
Where is the amendment date?
27/7/23.
27/7/23.
ಯಾವ book? 23, 24? Use a book containing.
My lords has the. My lords has. My lords the take.
That has the amendment.
This has the amendment. This has the.
So ತರ್ಸ್ಯಾರಲ್ಲ ಮೊನ್ನೆ.
This amendment.
ಏಟ್ ಏನದೆ ಏಟ್ 12 ಹಂಗ 5 ಜನ ಐತೆ ಆಮೇಲೆ 13 ಸೇಮ್ ಹಂಗ 5 ಜನ ಐತೆ ಇದು ಟೇಕ್ ನೋಟಿಸ್ ಆಯ್ತನ 14 15 ಅದು ಹಂಗ 5 ಜನ ಐತೆ
Yes, extensive
No.
and AG accepts notice for respondent. Petitioner is before this court seeking for the following leaves. ಅಲ್ಲಿ ಇದು 2 weeks time ಅಂತ ಹೇಳಿದ್ವಲ್ಲ ಫಸ್ಟ್ learned counsel for the petitioner submit that he shall not be relying on the sale deed at annexure C and D. His submission is accepted. Office objection sale number 27 is overruled. 57 I. Petitioner is before this court seeking for the following leaves. Petitioner claims to be a special purpose vehicle incorporated. Petitioner is aggrieved by the inaction on part of the respondent in processing and approving the application filed by the petitioner for conversion of the land bearing survey number what is survey number?
Yes, I just point out. 353/7. 353/7, Lakkundi village, Gadag.
353/7, measuring about 1 acre, situated at Lakkundi village. Lakkundi village where?
Gadag.
Gadag district. His submission is that any application filed for conversion of agricultural land from agricultural land to non-agriculture purposes is required to be considered and necessary orders passed in terms of the second proviso to
95
to Roman 2 of subsection 2 of section 95 within a period of 30 days from the date of the application. And if no such order is passed within the time prescribed, then the deeming fiction under the said second proviso would be applicable, granting deemed conversion in respect of the property covered under the application, subject to the exceptions made out in the said provision.
14 date ever appeal for the dismissal.
And as such, he submits that the relief sought for are required to be granted. Section 95(2) is reproduced hereunder for easy reference. A perusal of the second proviso to clause 2 of subsection 2 of section 95 indicates that if the deputy commissioner of, clause 2 of subsection 2 of section 95 provides for an occupant of land assessed or held for the purpose of agriculture wishing to divert such land or any part thereof for any other purpose, and if such lands are falling outside the local planning area for which a master plan has not been published, an affidavit along with an application could be submitted to deputy commissioner in the manner prescribed. As regards which, an opinion is required to be furnished within 15 days from the date of receipt of the application. And the deputy commissioner shall issue the approval for diversion subject to the opinion furnished by the concerned authorities and subject to payment of fee. The first proviso to clause 2 of subsection 2 of section 95 provides that if the opinion is not furnished within the period of 15 days, it shall be deemed that the concerned authorities have no objection to the said diversion as per the application. The second proviso to clause 2 of subsection 2 of section 95 provides that in the event of the deputy commissioner failing to give his decision and issues the order, then it's not reading properly.
Fails to give a decision and issues the,
Fails to give his decision and issue the order.
Correct.
Within 30 days from the date of receipt of the application,
Sir.
then the approval of the diversion for use shall be deemed to have been granted by the deputy commissioner, and the same shall be certified and issued in such manner as may be prescribed, subject to payment of fees under subsection 7 of section 95. Thus, the provisos to clause 2 of subsection 2 of section 95 bring about two deeming fictions. One, as regards the opinion which is deemed to have been granted within 15 days of the application filed, if not so granted, unless refused. The second proviso deems that the permission for diversion of land for non-agricultural purposes is deemed to have been granted within 30 days from the date of the, after the expiry of 30 days from the date of the application, unless rejected. And the only requirement being is for the applicant to make payment of the necessary fees, subject to the application being in compliance with the other clauses of subsection of the compliance with the applicable law. In that view of the matter, I pass the following order. Writ petition is allowed. A mandamus is issued directing respond number 1.
Only respond, sole respondent.
To respondent to issue a certificate of conversion for land bearing survey number 353/7 measuring 1 acre situated at Lakundi village, Gadag, in terms of the application number ID 937779 and request ID 729142 within a period of 7 days from the date of receipt of a copy of this order. The said on the payment of the amounts, you know what the amounts are?
In fact, we have written to them asking them to give us a demand note for the conversion charges. Once they issue us that note, then we...
On receipt of the amounts, on receipt of the fee payable for such conversion, respondent shall communicate the amount required to be paid by the petitioner within a period of 7 days from today. The payment to be made within 3 days thereafter, and the certificate to be issued within 7 days thereafter. The grant of the certificate shall be subject to the compliances, if any, required to be made by the petitioner in terms of the applicable law.
Good. Just one, that serial number 40, which was, I think morning it was passed over. The other side, I'm told that
and they sought for an
be
adjournment.
taken up on 7th. I think your lordship indicated 31st. 31st may not be possible. 7th February, could it be possible? 7th. Great.
Kind permission, my lord. Serial number 14. The lordship was pleased to issue notice since I was 14. There is an appeal provision under 269. They have challenged the resolution passed by the Gram Panchayat.
But how can they pass such a resolution?
That can.
When the state has said form the road,
Yes.
they pass a resolution saying, no, we'll hold it in status quo.
Srikanti Patil.
Passing on not the
Order passed by the JDL, my lord.
Stay idea.
My lord, there is a stay, my lord, till further orders at page number 3. On 16/2/2023. On the right side, my lord, page number 3. Until further orders, my lord, there is a stay order in respect of order passed by the DDLR.
Learned age, sale number 28, ಬೆಳಗ್ಗೆ ಒಂದು part dictation ಆಗಿದೆ. Learned AGA accepts notice for respond number
1 to 4.
1 to 3, 1 to 4. Issue emergent notice to respond number 5 to
80, my lord.
80. Returnable by 12th March. Petitioner is also permitted to take out hand summons on respond number 5 to 80. The respond number 5 to 80 are restrained from in any manner alienating any portion of the land in RS number 97/2 capital A, situated at Rattihaldi village, Hirekerur Taluk, Haveri district. Process fee and copies to be furnished by end of day 25th January, failing which the interim order will stand automatically vacated.
Please. God bless.
52, J. Shetty. 52,
None appears for the petitioner, though called twice. If none were to appear for the petitioner on the next date of hearing, petitioner would be liable to be dismissed for non-prosecution. Relist on 1st February.
53, VG Bhatt.
Though counsel for respond number 3.
Respond number 3, my lord.
None appears for the petitioner, though called twice. If none were to appear, once in the forenoon and once in the afternoon session. None were to appear on the next day, dismissal. Relist on 1st February.
Please, ma'am.
55, HM Dharigon.
Verified, my lord.
Yes, compensation ತಗೊಂಡಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದ್ದೇವೆ. Along with the statement of objections, additional statement of, we have filed, ma'am. It is part of the record. Additional statement of objections,
At
ma'am.
the
Additional.
want issued
Yes.
by the, my lord, the petitioner. Under protest, my lord, the subject result of the writ petition, my lord.
ಎಲ್ಲಿದೆ ಅದು ಪ್ರೊಟೆಸ್ಟ್?
Fine affidavit in the.
ನೀವು ರಿಸೀವೇ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಇವಾಗ
ಅಲ್ಲಲ್ಲ,
affidavit ಎಲ್ಲ
ಈಗ ನಾನು
ತಗೊಂಡ್ ಬರ್ತಾ ಇದ್ದೀನಿ.
affidavit ತರಿಸಿದೆ, affidavit ಹಾಕಿದ್ದಾರೆ. affidavit ತಗೊಂಡು ಕೊಟ್ಟಿದ್ದಾರೆ. ಪ್ಯಾರಾ 5 ನಲ್ಲಿ ಸದರಿ ಪರಿಹಾರ ಧನವನ್ನು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅಥವಾ ಭೂಸ್ವಾಮ್ಯ ಮರಳಿ ತುಂಬಲು ಆದೇಶ ಮಾಡಿದಲ್ಲಿ ನಾನು ಯಾವುದೇ ತಕರಾರು ಮಾಡಲು ತುಂಬಲು ತಯಾರಿರ್ತೇನೆ ಅಂತ ಈ ಮೂಲಕ ಪ್ರಮಾಣೀಕರಿಸುತ್ತೇನೆ.
Why did you accept it under protest 1? What is the meaning of subject to the result?
The new of urgency, my lord, the issued that amount subject, my lord, the assistant complaint instead the, my lord, the claimant to receive.
We will reserve your right to seek for enhancement if any ಅಷ್ಟೇ.
But in this case,
You
my lord,
received
the
in 2019.
my lord, in this case, deputy commissioner added, my committee added by the deputy commissioner. My lord, the given amount, my lord, in dry land, my lord, the 7,78,000.
They will reserve your liberty to seek for enhancement
ಅಲ್ಲ ಇದರಲ್ಲಿ
without reference to limitation.
amount awarded in this case only 1,98,000. Irrigated land. 70
ನಾವು
lakh
ಡಿಟರ್ಮಿನ್ ಮಾಡಕ್ ಆಗತ್ತಾ ದರಿಗೊಂಡು ಇದು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ?
But award itself is, my lord, the contrary to the, my lord, section 25.
But you have accepted it.
ಅಲ್ಲ amount not accepted, my lord, subject result of the writ petition.
One more,
Your acceptance is complete.
one more submission.
One more judgment of,
ಕೊಡೋದಾಗಿದೆ.
my lord, for a moment can see one more judgment.
You should not have received the money. Yes.
My lord, the para 29 of the, my lord, the order. The High Court, while dismissing the batch of the writ petition filed by the landowners, including the applicant, treated the same as having entered in practice, observing that the final award already been passed on 3 October 2023.
It is not in dispute that the writ petition came to be filed in September.
That is for passing the award. You have
My lord,
accepted the amount.
in this case also, my lord, the not complied, my lord, the mandatory provision. My lord,
You have accepted the money, which is completely different. You can't maintain both the things. You should not have accepted.
My lord, the under protest, my lord, the under
You
protest.
can't be doing that.
One more submission.
Aಷ್ಟೇ
Alala, pursuant to which they filed 64 reference. Now that has been referred to the civil court.
ಆಗಿದೆ already.
ಆಗಿದೆ, ಅದು ಆಗಿದೆ.
ಇನ್ನೇನು ಉಳಿದಿಲ್ಲಪ್ಪ. ಅದನ್ನ ರಿಸರ್ವ್ ಮಾಡೋದು ಬೇಕಾಗಿಲ್ಲ ಇವಾಗ.
The date on which it has been referred, all the applicants.
My lord, at the time of granting interim order, they have not produced any document. Interim order granted by this honorable court in the year 2020.
ನಿಮ್ಮ ಡಾಕ್ಯುಮೆಂಟ್ ನೀವು
Not to ಬರೀ disposes so.
You have asked for reference. ನಿಮ್ಮ
ಅವ್ರದೇ ಡಾಕ್ಯುಮೆಂಟ್ ನಾ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೇನೆ.
ಯಾರು ರೆಫರೆನ್ಸ್ ಯಾರು ಕೇಳಿ ನೀವು ತಾನೆ?
ಅಲ್ಲ ನಾವು ರೆಫರೆನ್ಸ್ ಕೊಡಿ.
Petitioner is before this court seeking for the following reliefs. The contention of Shri H.M. Dharwad, learned counsel for the petitioner, is that the final notification has been published. Final notification of subsection 1 of section 6 of the Land Acquisition Act 1894, dated 26/10/2023, and been published 2013, and been published on 13/1/2014. The award was required to be passed within 1 year.
Within 2 years.
Within 2 years, in terms of the Land Acquisition Act 1894. And the same not having been done, section 25 of the 2013 Act would become applicable. And since the award has not been passed within the applicable time frame, the acquisition is deemed to have been lapsed under section 25 of the Act of 2013. The award having been passed, published on 11/7/2016. Learned AGA would submit that though there may be a delay in publishing the draft, the petitioners have received the compensation amounts in terms of the said award on,
My lord, along with Lord, on date is not check on 18/8/2018, 19 in the year 18 and 19 and 2023, my lord, as per the chart.
in the years 2018 and 19.
Yes.
And the petitioners have also filed an application under section 64 of the Act of 2013, seeking for seeking for enhancement by reference. In pursuance thereof, an order under section 65 has also been passed.
Yes.
And the matter has been referred to the reference court.
Please.
Thus, he submits that the petitioner, having received the compensation amount and having sought for enhancement, cannot now contend that the award is passed belatedly and or that the acquisition has lapsed. The submission in reply by Shri H.M. Dharwad is that the amount have been received under protest, and as such the same cannot be held against the petitioners. Having gone through the documents, it is clear that though there is delay in the publication of the award, the petitioners themselves have accepted the compensation amount and have also filed an application under section 64 of the Act of 2013 for enhancement. Once the compensation amount is accepted, though the contention of Shri H.M. Dharwad is that the amounts were received under protest, the same could have been accepted by this court if not for the petitioners having filed an application under section 64 of the Act of 2013 for enhancement of compensation. Once the land loser has filed an application for enhancement of compensation, the land loser cannot maintain a challenge to the acquisition per se. In that view of the matter, no grounds being made out, the petition stands dismissed.
Fifty-six, K. Raghavendra Rao, P. Vidya.
I seek for short accommodation. Counsel on record is out of station.
At the request of counsel for the petition released on 1st February.
Please.
57, Anand P. Savadi. Anand Savadi.
Mr. Saudi. इधर यार respondent यार है ना LBMVJSI
The superintendent engineer.
ಲೋಕ ಬಂಡಾರು ಮತ್ತು ಒಳನಾಡು ಜಲಸಾರಿಗೆ ಇಲಾಖೆ ಅದು PWD ಆಯ್ತು ಇದು ಮತ್ತು ಒಳನಾಡು ಜಲಸಾರಿಗೆ ಇಲಾಖೆ
ಆತರ ಏನಿಲ್ಲ.
How can the PWD and irrigation be together? Superintendent of engineer. ಅದೇ ಇದೆ respondent has filed objections. By AGP early. So you accept notice. None appears for the petitioner and AG accepts notice for the respondent. If none were to appear for the petitioner on the next date of hearing, liable to be dismissed for non-prosecution. Released on 7th February.
57, 58 urgent, 59, Mrutyunjay Tata Body.
Next week. Next week.
Thank you.
I filed statement, my lords.
You ready now?
Not ready.
Though counsel for respondent is ready, counsel for the petitioner seeks for a short accommodation. Released on 1st February.
Please, lords, first.
Clear that no further adjournment would be granted.
Lords, first madam.
Saturday, ಒಳ್ಳೆ ದಿನ.
Oh, Saturday working ಇದೆ. Please, watch.
60, Vittal Teli.
On the request of learned AAG, it may be taken, on the request of learned AAG, it may be taken on 30th.
At the request, 30th ಬೇಡ. 31st or 29th?
31st ಅವರು ಬೆಂಗಳೂರಲ್ಲಿ ಮ್ಯಾಟರ್ ಇದೆ, ಪಾರ್ಟರ್ಡ್ ಮ್ಯಾಟರ್.
29th.
30. Yes, yes.
30th, lot of matters are listed.
Yes, 29th. I will.
80 ಆಗೋಗಿದೆ.
Please, 29.
ಅದು ಯಾಕೆ ಅಷ್ಟೊಂದು ಆಗಿದೆ 30th?
ಯಾವ ಏನಂತ ಗೊತ್ತಲ್ಲ.
ಅಷ್ಟು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಆಗಿದೆ ಒಂದೇ ದಿನಕ್ಕೆ. At the request of the learned AGA, released on 29th.
Please. 61, Bhatt Ganapati. Bhatt Ganapati.
None appears. None were to appear. For dismissal released on 7th.
62, Rajshekhar Burji.
May I request some time? I request for a week's accommodation. But
Represent the local body. They are occupants of the stalls. You know, they have challenged the order of deputy commissioner. According to them, 12 years was extended from 2012. That is reduced by the deputy commissioner by imposing fresh conditions. One thing, my lord, they have not paid the rent from 2018.
But we have.
And, my lord, 12 years come to end by this December 2024.
Take, issue the notification tender.
Because of this interim order.
But I'll ascertain, my lord, whether these people,
You can participate, subject to 2019 circular.
but weeks accommodation, I'll get ascertain.
Weeks accommodation, ಇವಾಗ್ಲೇ ಹೇಳ್ತಾ ಇರೋದು. You can
Yes.
participate in tender or right to
And
exercise
my lord,
first
since
refusal.
from 1993 onwards, my lord, they are continued, their tenure is renewed, my lord, thereafter also, my lord.
ಸಾಕು.
But
93 ಇಂದ ಮಾಡಿದ್ದು.
priority, my lord, has to be considered.
Priority ಅಲ್ಲ. You participate in the tender.
Definitely.
If you are successful for the same shop, you will continue. If you are not, if you don't participate, you can exercise first right of
But
refusal.
under the previous order, government orders, my lord, the term, one of the condition was that not after completion of the tenure, if the lessee intends to continue.
ಅದೆಲ್ಲ ಹೋಗಿ ಆಯ್ತು. ಅದೆಲ್ಲ everything has been misused, abused. ಇವಾಗ ನಿಮ್ಮ ಹತ್ರ ಎರಡು ಆಪ್ಷನ್. Participate and be successful, no problem.
Yes,
If you participate and are unsuccessful, your right stops.
yes.
You don't participate, you can exercise first right of refusal
Till
by
such.
giving more than 5% more. Right?
5.
5% more than what the highest bidder gives.
Yes, I'll ascertain, my lord. If that is, till the tender is called for, my lord, I may permitted to continue that.
Till the tender is called for, you will be permitted to continue.
Yes,
You will
yes.
be directed to vacate and hand over the premises,
Provided if I,
provided ಏನು ಇಲ್ಲ within 15 days of the tender being concluded.
next week. my lord.
ಅಷ್ಟೇ.
Yes, yes, next.
At the request of counsel for the petitioner, relist on 31st January. ಇಲ್ಲ 1st February.
First beda, first beda.
ಫಸ್ಟ್ ಬೇಡ. ಏನ್ ಎಲ್ರು ಫಸ್ಟ್ ಬೇಡ ಅಂತ ಇದಾರೆ. ನಾವು ಬರೋದೇ ಬೇಡ ಅವತ್ತು.
Next week, first week, my lord.
31st. 63 Arjun,
Lord,
64.
serial number 61, my lord. Maybe permitted, my
Serial
lord.
number?
61, my lord, I am appearing the response number 4, my lord. This matter, my lord, when I.
61 no petitioner. So next time ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ dismissal ಅಂತ ಹೇಳಿದ್ವಿ Mr. Bas.
This is the industrial policy matter, my lord. Your lordship is already directed the third respondent to consider the request and pass the appropriate order. In similar matter, this is industrial policy matter, my lord. That is, your lordship.
ಅಲೋ ಮಾಡಿಬಿಡೋಣ ಅಂತೀರಾ?
There is a direction to the third respondent to consider the request of the, my lord, petitioner in accordance with law, my lord. That is the. Seeking the exemption of
Already
the market
petitioner
fees, my lord.
ಬಂದಿಲ್ಲ ಇವರು. They don't seem to be interested. 7 years. ಅದು ಯಾವ್ದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿರೋ WP ನಂಬರ್?
And one that Dinesh Kulkarni matter, my lord, last week, my lord, your lordship is.
ಅಲ್ಲಿ ದಿನೇಶ್ ಕುಲಕರ್ಣಿ
Consultant may knows, my lord, that is.
ಮೊನ್ನೆ ಯಾವ್ದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದು? This market says 7 years exemption. Petitioner is before this court seeking for the following reliefs. The list in the present matter has been considered by this court in detail in WP, in its order dated blank in WP number so and so. The same would be equally applicable to the present matter. Hence I pass the following order. Writ petitions allowed, same order. 64.
64, Srivatsa Hegde.
64.1 million.
Hegde, Sangram SC Booty. Where is Mr. Booty? He could have shift again. Yes.
Lord, the
64.1 may kindly be taken up.
no, 64, I'll explain, my lord. The petitioners
Yes.
are the archakas and hereditary trustees of a certain temple in city of Belgaum, my lord. Now the respondents claiming that they have taken over, they are the devotees and they have taken over the administration, were trying to prevent the petitioners from discharging their duties. I had to rush to the civil court with a prayer for injunction. Injunction came to be granted. I made a further application saying, Lord, despite an order of injunction, still violent means are being used to prevent me from entering the temple premises and sought for police protection. The trial court refused to grant that police protection, my lord. In the meantime, I had also filed a miscellaneous petition under, as my lord is aware, 1920 Act. Then these respondents tried to interfere and the district judge was of the opinion that they have no locus standi and their application came to be rejected. That writ is 64.1. Then, my lord, the grant of injunction was in challenge for a period of nearly 5 years before the district court.
Yes.
And there also the court was of the opinion that the respondents lack in, locus. Therefore, they thought it fit to continue the order of injunction. My only grievance is, my lord, I am left with no means to implement this order.
So we'll have to allow WP 1000043 of 22.
Yes.
Set aside the order passed appointing these trustees.
That is not an order appointing us as trustees, my lord.
Whoever has been appointed, that will go.
No, there was no appointment.
It is hereby declared that the following person being legal as of hereditary trustee so and so, I become hereditary trustee so and so.
Who are the
Kapilnath
plaintiffs in that
Kashinath Pujari, Srinath Kashinath Pujari.
They were already trustees. There is no question of appointment, my
Nive
lord.
Kapilnath Nive. Srinath Nive.
Oh, but
Srimati Prema is not a party.
no, that is my mother.
This order will go.
No, my lord, the observation is they lack in locus. So even in, for the purpose of writ
Court
petition.
has no locus to take it up is what we have held.
Lord.
It has no jurisdiction to consider all these things is what we have held. So this petition itself was not maintainable, which was filed. So that will go.
No, even if that goes, my lord.
And in this one, it is a question of IA 3.
Yes.
That file application seeking police protection, my lord.
Hmm.
And they say that they have continued performing puja. So the application is rightly rejected by the court below, saying that there is no police required for performing puja, my lord. And as far as the order that was passed on the interim application, my lord, that is already challenged by the respondents, my lord.
Is there a stay? Is there a stay after challenge?
My lord, that is yet to be listed, my lord. In WP number, there are two new writ petitions which have been filed, my lord. WP number 106919.
So we'll connect these to those two and take it up.
Yes.
This we will.
Now I will address arguments on all the writs, my lord, if my lord permits.
What is there to address on this, Mr. Hegde?
No, there are many things to address, my lord, because the district administration also has found that these people without authority have entered temple premises and also
That
taken.
we'll consider in this. 3 and 7 of the Act of 1920, the court has no power. That has
yes.
been clearly held,
Yes, my lord.
upheld and closed.
Yes, I understand, my lord.
So this will have to go.
That may be, my lord, but the thing is, the ramifications of setting aside that order should not be that the declaration of me not being a trustee.
That is different. That will be considered independently of this.
Yes, yes, my lord. Because it is already established and prima facie found to be correct.
If you are there, you are there. This declaration, the court could not have given, and irrespective of that, we will hear you on that. We will observe that. 64.1. Petitioner is before this court seeking for the following leaves. The petitioner, he is aggrieved by.
No, my lord.
The order dated 6 December 2021, passed in miscellaneous application number 112 of 2018.
Correct, but now
Passed on a petition filed under section 3 and 7 of the Charitable and Religious Trust Act 1920.
My lord,
By virtue of which.
One submission, my lord. I'm sorry, my lord. My objection with regard to that locus to challenge in this writ also.
All questions will be left open.
Yes.
Came to be allowed and a declaration issued that the respondent number 1 to 3. 1 to 3 Allah. Respondent number 2 and 3.
And also Kapil Nath, my lord, who has been shown to have been representing respondent number 1, my lord.
And one Sri Kapilnath Kashinath Pujari were declared to be the hereditary trustees. This court in.
Yes. I mentioned the writ petition number in WP number 101436 of 2018. Point number 11.
This court, while its orders dated blank and WP number 101436 of 2018 and other connected matters, has categorically come to a conclusion that the powers under section 3 and 7 of the Hindu Religious Charitable Trust Act 1920 does not provide the district court any powers to declare anyone as a trustee and or appointment of trustees. The petition having been filed, the petition in MA number 112 of 2018 having been filed for such purpose was not maintainable, and as such the orders passed therein are not sustainable. Be that as it may, any issue, any dispute between the petitioner and respondents as regards they being trustees or otherwise would have to be independently ascertained in appropriate proceedings, irrespective of the dismissal of MA number 112 of 2018. In that view of the matter, I pass the following order. Writ petitions allowed. A certiorari is issued. The order dated 6/12/2021 at Annexure C, passed by the 8th Additional District and Session Judge Belgavi in MA number 112 of 2018 is hereby quashed.
My lord, one submission.
Connect with.
Now this would be treated as a victory for these, trespassers, my lord. And I am not a trustee by virtue of this order.
Which are the other two connected matters? Connect with WP number
106859 of 2020.
106859 of 2024 and 106919 of 2024. You have been served, everything, pleadings are complete?
No, my lord, I will have to serve him.
Serve him.
Yes.
Relist on Monday, 27th.
Monday, no, my lord, I would not.
Tuesday. Yavat ಹೇಳಿ?
5th.
ನೀವೇ ಅರ್ಜೆಂಟ್ ಅಂದ್ರೆ 5th.
I request for a clarification, my lord, because if this order is used against us, because they have no locus either to participate in the temple
That
administration.
will be dealing in the other three matters. In those three matters which are there, we'll be dealing with that.
No, this order itself will be used against me is what my apprehension
That
is.
order could never have been passed. 5th.
65, Jai Gachinmat.
I requested for Tuesday, my lord.
Hmm?
I requested for Tuesday.
Tuesday. At the request of counsel for the petitioner, relist on 28th.
Please, oblige me.
66, Government.
Please.
Requested day after tomorrow.
At the request of counsel for the respondent, relist on 25th.
At interim order.
Interim order earlier granted is extended till next date.
But my lord, last it was extended on 23/8/2023. And thereafter, my lord, it is not extended. For the first time, it was extended on 20th. So interim.
Nothing has happened, so we'll extend.
Yes.
67, Suresh Gundi.
Chief, without giving me the opportunity to the petitioner, my form number 9 has been cancelled by the executive officer, Taluk Panchayat. Even the party in the appeal, I was not made a party, but my property was challenged.
Annexure P, page number?
39, Lordship.
Veeraya Iremat. Versus
That is
Panchayati Abhivrudhi
respondent
Adhikari.
4.
Yes. What about annexure? Yes.
Yes, after filing a review petition, yes has been passed,
What do they
rejecting
say?
my review petition also,
On what ground?
saying that the property
was already dealt in P, annexure P. And that reasoning is correct.
So you've been given an opportunity, you have addressed your arguments, it's been considered. So the first ground will not, you'll have to argue on merits.
Please.
On
Please.
annexure yes.
Annexure,
Why is annexure yes wrong ಅಂತ ಹೇಳ್ಬೇಕಲ್ಲ?
annexure P and S both are,
P is now merged with annexure yes.
yes,
In annexure yes, whatever you wanted to say, you said, it has been rejected.
without considering my grounds that my property, I have not given an opportunity while passing annexure P.
P is fine. Annexure yes ಅಲ್ಲಿ ನಿಮ್ಗೆ opportunity ಬಂತು ತಾನೆ?
ಅದನ್ನು ಯಾವುದು grounds consider ಮಾಡಿಲ್ಲ annexure S.
ಹೇಳಿ, what ground that you raised and what has not been considered.
My property is,
Where is your review petition?
pardon Lordship. Review petition is annexure R.
Yes. What has not been considered?
That is para number 5. I have specifically stated that I was not made a party there while passing.
ಅದು repeat ಮಾಡಬೇಡಿ, ಅದಾಯ್ತು. Next merits.
Annexures, para number 7, the property, how it devolved to me, I have stated Lordship. Even that is not considered.
Where is the document for that?
I have produced from annexure A. Annexure C is the relevant document where the property, annexure A, where I got my property converted into NA, non-agriculture land.
Where is your title document? Devolution of the property and the title document.
Title annexure D is form 9 Lordship, where my name is shown. My title is not disputed Lordship. Only thing, without giving me opportunity, annexure 9 is cancelled.
ಅದು P ಆಯ್ತು. We are speaking of annexure yes.
Yes.
Where you filed an appeal. Revision.
Review.
And you placed all your contentions on record.
Please.
Why is annexure yes wrong ಅಂತ ಕೇಳ್ತಾ ಇರೋದು?
ಏನು reasonings ಏನು ಇಲ್ವೇ ಇಲ್ಲ ಅದರಲ್ಲಿ.
Form number 9 was form number 9, which was issued, which was cancelled by the impugned order, was there was a change in the measurement. The initial measurement was changed unilaterally by the authorities at his instance. That is nullified by virtue of this impugned order, and the earlier entries which stood the measurement of the property, that has been retained by the authorities
without giving notice. So that has not been considered even in annexure.
The authority did not have a jurisdiction. So far as issuance of form number 9 is concerned, the government circular says that the issue crop up for this.
Number 9 has been issued.
So form number 9 was issued after following due procedure. Now he applied, based on that application, he applied for the allotment of rural outlet dealership. The first requirement was to have, the first requirement itself was that he should have 20 by 20 site. Now, if you just take the connected petition, the form number 9, which was issued at that relevant point of time, showed the measurement of the property as 19.2 by 28.34.
Could you connected petition?
It's page 113, if your lordship sees in that.
Yes.
113. Now his property bears number 2A. If my lord sees the measurements there, Purva Paschima 19.20, Uttara Dakshina 28.34. Now this was at an undisputed point of time pursuant to his application, the competent authorities has issued.
Yes.
Now what he does is, since he was not eligible for that the allotment, he gets it changed and the measurement has been changed as 20.19 by 27.34.
Yes.
Now, the authorities, by virtue of the impugned order, said the subsequent change was without there being a report, which could not have been done. It was only pursuant to the report by the survey department that should have been done. So, a subsequent form number 9 which was issued has been cancelled and the earlier one has been retained. Now, you will actually kindly take note of the dates also there. The first one which was issued in Annexure R, page 113 is dated 13/11/2014. This was as on the date of his application before the respondent in the second writ petition. Now, subsequently, to overcome that eligibility, he gets it changed on 10/8/2016. Now, this.
What do you challenge in your petition?
In my petition, myself and these respondent, the present in the first petition, were the applicants to the invitation that was made for allotment of rural outlet dealership. Now, he was adjudged as being eligible for that. I had questioned that by filing a complaint under the
But where is this considered in annexure? Yes.
Please. Lords will get annexure, yes. Lords will kindly take page number 49.
Para?
It's unnumbered para, internal page number 5 of that impugned order.
Annexure yes of serial number.
Lords are referring to the first writ petition.
Yes.
Yes. Lords will get it as annexure, yes. Page number 5, internal page number 5, running page number 49.
5.
Yes.
Yes.
ಸರ್ವೆ ನಂಬರ್ 132A3 ಅಂತ ಈ ಆಸ್ತಿಯ ಚಕ್ಬಂದಿ ಹಾಗೂ ನಕಾಶೆಯನ್ನು ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿಗಳಿಂದ ಪಡೆದುಕೊಂಡಿದ್ದು ಇರುತ್ತದೆ. ಅದೂ ಅಲ್ಲದೆ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ ದಾಖಲೆ ಪ್ರಕಾರ ಆಸ್ತಿ ನಂಬರ್ 2A ಉತ್ತಾರಗಳನ್ನು 73ರಿಂದ 77ರವರೆಗೆ ವಾರಸಾ ಪ್ರಕಾರ ದಾಖಲು ಅಂತ ಇದ್ದು, ನಂತರ 2011ರಿಂದ 15ರವರೆಗೆ ಹಕ್ಕುಪಟ್ಟು ಪತ್ರದ ಮೇರೆಗೆ ದಾಖಲ ಅಂತ ಇರುತ್ತದೆ. ಅರ್ಜಿದಾರನು ದಿನಾಂಕ 13/11/2014ರಂದು ಗಣಕೀಕೃತ ಉತ್ತಾರವನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದು ಇರುತ್ತದೆ. ನಂತರ ಅದೇ ಆಸ್ತಿಯ ಗಣಕೀಕೃತ ಉತ್ತಾರವನ್ನು 23/2017ರಂದು ಪಡೆದುಕೊಂಡಿದ್ದು, ಸದರಿ ಆಸ್ತಿಯ ಅಳತೆ ಬೇರೆ ಬೇರೆಯಾಗಿದ್ದು ಇರುತ್ತದೆ. So he gets the measurement change there. So that is now cancelled, and the form number 9 issued on 13/11/2014 has been retained.
Yes.
Fact,
your condition have been considered and rejected properly. How did you make the change in the measurement?
But the village accountant at annexure Q, Lordship, he is very specifically says the measurement of the property.
This is 2019. 2019.
Yes, Mr. Rangdi. You are appearing for whom?
I am only party in the second writ petition, my lord. Since during the field verification of credentials, 2-3 letters were issued to the Taluka Panchayat regarding the litigation between the two parties therein. And since the property extract found.
Appearing for the oil corporation.
Yes, my lord. I am party only in the second writ
Who appears
petition.
for the state?
Panchayat is represented by Panel counsel, Mr. Osmat. Rajendra Osmat.
Rajendra Hosmat.
The impugned order is passed by the Taluk Panchayat.
Rajan Swami Osmat. Where is he? Bartara? Though counsel for the petitioner and respondent number 4 were present and have addressed their arguments, none appears for respondent number 3 in WP 116434 of 2019. To give an opportunity for respondent number 3 to be represented and address arguments, relist on 29th January at 2:30 PM for further hearing.
January. 68, interim order in both the
Both the
matters.
cases.
Interim order earlier granted is extended till next year.
68, KL Patil.
Suit filed by the trust.
Raibagi, you are appearing
Yes,
now.
yes, ma'am. Yes, ma'am.
Sri Ganesh Raibagi has entered appearance for respondent number 125, registry that delete number Shaila Velikatti has that appearing for R125. Yes, Mr. Patil.
Short point is that, my lord, the last time a petitioner was a permanent lessee, was purchased the leasehold rights and constructed the building and running there. The present plaintiffs who are respondents claims that this is a trust property which was not in, and they, for recovery of arrears of rent from 1959, etc., they files a suit before district judge court claiming it to be under section 92 CPC. And we are neither the trustees nor that will be covered under any of the provisions of section 92. Even if they want to file a suit, they have to file a suit before the civil judge court.
Why should it be under 92 for recovery of rent?
Last time, my lord, they opined that the inquiry should have been conducted. If that is so, my lord, the section 2 before inquiry, the order has been passed according to them. Without giving opportunity to them. Let the trial court may be directed to hold an inquiry, then my lord, the suit may be instituted. That can be done.
You'll have to, if you have to file for recovery, it has to be filed.
That
as
is
a
what I'm recovery,
recovery, not under section 92.
No, but we have to seek, since this property is the trust property, we have to seek permission from the trial court first under section 92. That is what has been. That order has been challenged before this court.
For recovery of rent, 92 allotment.
Your lordship's decision of
Any trust
Kalburgi High
dealt
Court
with that matter.
Yes,
is not required. ಎಲ್ಲದಕ್ಕೂ 92 ಹಾಕಕ್ಕಾಗಲ್ಲ.
92 is squarely in, but the provisions under 92 which are covered. A, B, C, D, E, F, G, H. But my lord, admittedly the property is the trust property and the respondents are the trustees, hereditary trustees. And for recovery of the rent in the name of trust, they have to file a suit itself.
Section 92 is for what purpose?
That is 92 is for according to leave. Leave has been granted just to, that is purely an administrative nature. That is what has been ordered by the trial court, and accordingly the suit has been instituted.
Removing any trustee, appointing a new trustee, vesting any property, directing a trustee, directing accounts and inquiry.
Yes.
Declaring proposal or interest, then authorizing whole or any part of trust property, let sold mortgage, settling scheme, granting such as an.
Yes.
Recovery of rent is not part of it. You can file a separate independent suit for recovery.
Before civil judge court, not under
before the
section
court
90.
of competent jurisdiction.
Merely because if inquiry is my lord,
merely because respondent is a trust would not require a suit to be filed in 92. Ellandu 92 ಅಲ್ಲಿ ಹೋಗುತ್ತೆ ಆಮೇಲೆ. Jurisdiction would vest with the principal district judge for all purpose. ಆಗಲ್ಲ ಅದು.
Then I may be reserved. I may be reserved.
The petitioner is before this court seeking for the following relief. The respondent had filed a suit in OS number 7 of 2018 for recovery of arrears of leasehold rent before the Principal District and Session Judge, Dharwad,
And for actual position also.
recovery and for possession. In the said suit, an application under Section 92 of the Code of Civil Procedure was filed seeking for leave to file the suit, which came to be allowed. Wide order dated
Order dated at page number 41, my lord.
26/2018.
Yes.
It is challenging the same, the petitioner is before this court.
No, my lord. For that, then this application was ex parte allowed. Thereafter, after appearing, I filed application to hear that application that came to be rejected. Against that, I am here.
They'll the other order.
Page 47.
The petitioner, being the defendant therein upon appearance, had sought to contend that the court would not have jurisdiction, the principal district judge would not have jurisdiction, and that the application in 92 was not maintainable, and as such sought to address arguments on the same. The said request was rejected by the impugned order dated 22/8/2019 on the ground that the application under Section 92 had already been allowed. It is challenging.
And it is to be heard along with the main.
The same, the petitioner is before this court. The submission of Sri K.L. Patil, learned counsel appearing for the petitioner, is that the suit being won for recovery of rentals and for possession would have to be filed before the jurisdictional court and not before the principal district judge on the ground by filing an application under Section 92 on the ground that the petitioners are trustees, the plaintiffs are trustees. His submission is that this being a general suit for recovery of money, recovery of rentals, the same would not come within the purview of Section 92 of the Code of Civil Procedure. In this regard, he relies upon a decision of this court dated 19 June 2023 in WP number 203194 of 2022. More particularly, para 11, 12, 13 and 14 thereof, which are reproduced hereunder for easy reference. Placing reliance on the above, he submits that the above petition is required to be allowed. The order passed on the application under Section 92 set aside and the suit dismissed. Learned counsel for the respondent would however submit that the plaintiffs being trustees, the trust and/or the trustees would be required to file and proceed with the suit before the principal district judge. And as such, he submits that the order passed by the trial court, principal district judge, is proper and correct. Heard so and so, peruse papers. The list in the above matter has been decided, has been dealt with in detail and decided by this court wide order consequently dismissed by exercising powers under Rule 10 of Order 7 of the Code of Civil Procedure. The plaint is returned to the plaintiffs to be presented before the court of appropriate jurisdiction. The formal order in relating to return of the plaint to be made by the principal district judge, complying with sub-rule 2 of Rule 10 of Order 7.
Much. And all the contentions for both the
Contentions are
parties are
left open.
because 1959 in the arrears case.
All contentions are left open. This court has not expressed any opinion on the merits of the matter.
Much.
Great. PM Shilvan.
Either transfer.
We are requesting KIDB to do it, my lords. Because they feel they have invested too much of money, and their fault they don't want to now get into this.
We make just one request insofar that is concerned. Now, frankly, I have my instructions also that if an award now has to be passed, it will take time. If the lordships were to direct us to deposit this amount that as per the price fixation committee, will deposit it subject to whatever award.
Exceptions and my lords.
Yes,
That is what we said.
Yes.
So when will you do it and kill it though?
The lordships may direct us to do it with the time frame, because if we leave it to, if I ask my officer, well, the time frame that he suggests will be.
Iವ್ರದ್ದು
something
ಫಾಸ್ಟ್
that-
ಅಂದ್ರೆ ಇವ್ರದ್ದು ಮಾಡ್ಲಿಲ್ಲ ಇವರು. What is this, Mr.
My
Pandit?
hands are tied.
What?
Lords.
You are not in a hurry. We'll adjourn the matter by 3 months for them to do it.
Lords, the problem is we are in deep trouble because we have taken loans and project is on. In between, it's got stuck now, my lords, by
If you don't have 1 crore to pay, then no project is going on.
my lords, 1 crore iratte anta my lords, we can't dispute. But now that they have, my lords, about 9 crores has come to Dharwad.
ತಗೊಳ್ಳಿ ಚನ್ನಬಸವ. Acquisition as a preliminary notification as subsection 1 of section 28 having been issued on 9/11/2006, and the final notification under subsection 4 of section 28 having been issued on 7/5/2007. Sadly, no final award has been passed by the KDB, which reflects very poorly on the KDB and its officers. Though the submission of Shri Vikram Mohilgol and his senior counsel is that the acquisition was challenged and went up to the Honorable Apex Court. And the Honorable Apex Court disposed the matter on
11/10/2022.
11/10/2022. And as such, it cannot be contended that there is a delay from the year 2007. I am the considered opinion that post the judgment of the Honorable Apex Court on 11/10/2022, it was required of the KDB, SLAO of KDB, to pass an award and make payment of the due amounts to the petitioners. In that background, that the petitioners have been forced to knock the doors of this court, contending that the respond number 4 and 5 are now seeking to interfere with the possession of the petitioner and putting up construction thereon, having received the compensation amount. On inquiry as to whether any price has been fixed by the price fixation committee, Shri Vikram Mohilgol and senior counsel submit that the prices have indeed been fixed for different lands at different rates. If that be so, the least that the KIDB can do is to transfer the amounts as fixed by the price fixation committee to the petitioner at the account, to the petitioner at the bank accounts which details have already been furnished.
Petitioners, I think.
Petitioners.
Petitioners.
At the bank accounts, the details of which have already been furnished way back on
Monday, recent.
4/12/2024.
4/12/2024. Copy of the details thereof having been furnished once again today to the counsel for the KIDB. This, of course, will be without prejudice to the petitioners seeking for enhancement of compensation on an award being passed. Respondents 1 to the
3 minutes.
Three.
Number 3, I said.
are directed to transfer the amounts. You again, ನಿಮ್ಮ share ಏನು ಒಬ್ಬೊಬ್ಬರಿಗೆ ಎಷ್ಟೆಷ್ಟು ಅವ್ರವ್ರು ಸರಿಯಾಗಿದೆ ಮತ್ತೆ ಅದು ರೈಸ್ ಮಾಡ್ತಾರೆ.
ಇಲ್ಲ, ಬೇರೆ ಬೇರೆ ಇದೆ.
ಫಸ್ಟ್ ಪ್ಯಾರಲ್ಲಿ
First paragraph
ಎಕ್ಸ್ಟೆಂಟ್ಸ್ ಹೇಳಿದ್ದಾರೆ.
Extent of land.
Petition number 1, 4 acres. Petition number 2, I think 10 acres, 4 guntas.
Transfer the compensation amounts to the bank accounts of the respective petitioner in the manner of the entitlement as indicated in para 1 of the writ petition within 10 days from today. That is on or before 3rd February. Relist on 4th February. Interim order earlier granted is extended till next date of hearing. On that day, we'll fix the date for award. You find out when you'll pass the
That
award.
they have given and your lordships have directed them.
ನಂಬಕ್ಕಾಗಲ್ಲ ಅವ್ರನ್ನ.
But then we'll anyway come back to your lordships.
ವಿಕ್ರಮ್ ನಂಬೋದು ಅವ್ರ ಕ್ಲೈಂಟ್
Alala. But my only problem is, my lords, in between it is stuck, my lords, my project.
That's why we gave you an option, you transfer, you don't transfer. What to do?
The lordships are fixing it on 4th.
On 4th. ನೀವೇನ್ ಬರೋದ್ ಬೇಕಾಗಿ. VC is on.
Please.
List 2, ಇದು CPC. ಅದು ಯಾವಾಗ ರಿಪೀಟ್ ಮಾಡ್ತಾ ಇದೀನಿ? ಅದು ಸ್ಯಾಟರ್ಡೆ ರಿಪೀಟ್ ಆಗ್ತಾ ಇದೆ. ಇದು ಟ್ಯೂಸ್ಡೇ ರಿಪೀಟ್. The list 2 as regards CPC matters.
Two.
We'll repeat it on Tuesday, 28th.
Serial number 10, my lord.
Withdrawal.
Respondent number 5 has refused the
Withdrawal.
no, withdrawal. Respondent number 5 has refused the court notice, my lord.
Serial number 5.
10 only.
10. What about the other respondents?
The third respondents have already paid the PF, my lord. R1 I have to take because postal share has returned as
ಇದಕ್ಕೆಲ್ಲ Tuesday we'll hold it. We'll call out the matters again on Tuesday. ಏನೇನ್ ಮಾಡ್ಬೇಕಾಗಿದೆಯೋ ಎಲ್ಲ Tuesday ಒಳಗೆ ಮಾಡ್ಬಿಡಿ.
Please.
Process fee ಕೊಡಿ, copies ಕೊಡಿ, application ಹಾಕಿ,
compliance.
ಏನೇನ್ ಮಾಡ್ಬೇಕೋ ಮಾಡಿ.
Please.
ಅವತ್ತು we'll pass orders. Serial number 22. List 2, serial number 22. Petitioner is before this court seeking for the following reliefs. That counsel for the petitioner submit that the above petition does not survive for consideration. Accepting his submission, petition is dismissed as infructuous. ಏನು ಸೂಟ್ ಡಿಗ್ರಿ ಆಯ್ತಾ?
ಅವರು ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ದಾರೆ. ಕಾಂಪ್ರಮೈಸ್
ಆಗಿದೆ. It does not survive for consideration since the suit has been compromised. Accepting his submission, petition is dismissed as
My lordship, secondly, serial number 1, my lordship. He's paid the PF, my lordship. Respondent number 4, my lordship.
R5, you will have to file application.
Death.
R5 is dead.
Serial number 1, my lordship.
ಅದೇ serial number 1 ಹೇಳ್ತಾ ಇರೋದು. List 2, serial number 1. R5 is dead.
Yes, my lordship.
File application. Tuesday we'll repeat, file all of it.
Yes,
number 2, serial number 19.
For dismissal. For dismissal. Needful has been done.
Tuesday ಹೇಳ್ತೀವಿ. We are not dismissing anything today. ಆ dismissal ಹೇಳೋದು ನೀವು ಮಾಡ್ಲಿ ಅಂತ. ನೀವು ಅದಾದ್ಮೇಲೂ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ dismiss ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
Serial number 6, my lord.
We don't want to dismiss anything. On that ground, merits we'll consider.
Serial number 72, my lords, covered by your lordship's decision. That my
Now
lords,
list 2 72 illa.
Not serial number 6,
List
my
two.
lord. Serial number 6, my lords. I am filing the memo, my lords. Kindly permit. Serial number 6, my lords. Respondent number 4 has refused the court notice, my lord.
Respondent number 4
Four,
is?
please, my lord. Others have taken the steps, my lord. Serial number 6. Respondent number 4 has refused.
We'll consider everything on Tuesday.
Yes,
serial number 8, my lord.
Serial number 8, I am in full done.
Unless you want to withdraw, everything else will be considered on Tuesday.
Please.
ಏನೇನ್ ಮಾಡ್ಬೇಕು ಮಾಡಿದ್ರೆ we'll consider that on Tuesday. ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಮಾಡಿ we'll consider that on Tuesday.
17, notice may be issued on LR application.
17.
LRs of R8 application filed.
17, during the pendency of the above matter, respond number 8 has expired. In view thereof, IA 1 of 25 has been filed. Issue notice on IA 1 of 25, returnable by 18th March. Process fee and copies to be furnished by end of day 27th January.
Interim order.
Order earlier granted is extended till next day. Process fee and copies, if not furnished by 27th, the interim order will stand automatically vacated.
My lord, serial number 18, my lord, second list. Today I paid a PF, my lord. I am proxy counsel appearing for the.
ಮತ್ತೆ ಅದೇ repeat ಮಾಡಿ.
Serial number 20, serial number 20, my lord, B group matter. Interim order is still today.
B group ಇದೆಯಾ? B group ಎಲ್ಲ ರೆಡಿ ಆಗಿದೆಯಲ್ಲಪ್ಪ? 20 to 40 on 10 this B group matters, 10 of them will come on Monday, 10 of them will come on Tuesday in the first list.
Please.
So you can get ready and address that.
And list 2 interim orders may be extended wherever.
ಎಲ್ಲ interim order
Please.
Monday ವರೆಗೂ ಏನಾಗುತ್ತೆ?
Serial number 16, my lord. Serial number 16. R4, my lord, is not claimed ಅಂತ ಬಂದಿದೆ. If lordship holds.
Not claimed, ಇನ್ನ amendment ಆಗಿಲ್ಲ.
Yes, yes, I will take steps. Interim order may kindly be extended.
You take steps, we'll pass orders on Tuesday. ಒಂದ್ರಲ್ಲಿ ಮಾಡಿದೀರಾ ಒಂದ್ರಲ್ಲಿ ಇಲ್ಲ, ಎಲ್ಲ ಏನೇನ್ ಮಾಡ್ಬೇಕು ಟ್ಯೂಸ್ಡೇ ವರೆಗೂ ಮಾಡಬೇಡಿ.
Please, please. Interim order may kindly be extended, my lord.
We are not passing any order, it's just repeat.
Like serial number 110, orders matters. Serial number 110 in the first list. Therefore,
So list 2 ಆಯ್ತಲ್ಲ, 110 ಏನಪ್ಪ?
Lord, in that, Lord, status for order is passed. Lord, construction is. I appear for respondent.
Mr. Badoli, what was the submission?
Ballots, serial number 72. Ballots, a matter ballots against a city municipal council covered by your lordship's decision, where your lordships are pleased to hold that ballots suits itself against the municipal corporation. That was in context of BBMP is not maintainable. Similar suit is filed. TI is rejected, against which ballots the writ petition is.
As regards demolition.
As regards the demolition.
Not as regards any order passed on 321.
No.
We'll consider.
Please.
Interim order is still today.
My lord, list number 198, cover judgment 98 and 99.1. May proceed.
113. ಎಲ್ಲರಿಗೂ ಅರ್ಜೆಂಟ್ ಏನ್ ಮಾಡೋದು? It will repeat with some this one.
My lords, serial number 94, I am an employee who was appointed in Panchayat Kayaka Mitra.
It will repeat, it will come.
Yes, my lords.
Sir, ಎಲ್ಲ ರಿಪೀಟ್ ಇದು 104 ಎಂಟ್ರಿ ಮಾಡ್ತಾರೆ.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ. ಜಾಯಿನ್ ಡೇಟ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್
29
ಡೇಟ್ ಫೆಬ್ರವರಿ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡ್ತೀವಿ. ಸರಿನಾ? ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ ಸರ್. ಫೆಬ್ರವರಿ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡ್ತೀವಿ.
29 ಯಾವಾಗ ಬರ್ತೈತ್ರಿ?
ನಾನು ನೋಡಿ ಫೆಬ್ರವರಿ ಫಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಡೇಟ್ ಕೊಡ್ತೀವಿ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲಿದೆ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ.
710 ಒಂದು ಸ್ವಲ್ಪ ಅಟೆನ್ಸಿ ಐತ್ರಿ.
Serial number 29.
Birth.
31st ಕೊಡ್ತೀವಿ. 31st.
ಅದಕ್ಕೆ
Sir, 86.
ಎಲ್ಲ ಮತ್ತೆ ಇದೇ ಕಟ್ಟೆ ಆಗುತ್ತೆ.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಸ್ಟೇಟಸ್